हेल्प कर लेना जा. Hello, 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 hello. Good morning, everyone. We will be shortly starting our panel discussion and our conference shortly. Good morning. It's clear? Good morning, everyone. Hello. Hmm. Yes, yes, yes. Yes, yes. Oh, yes, yes. Done. Sir, sir, एक minute. Anjita Roy.
Good morning, everyone. Good morning, everyone. I request to all of you, please keep your phone on silent. Thank you. Pragya, let's start.
हेलो अरे हेलो हेलो एक मिनट मिनेश मेरे पति को फ़ोन करो यार मेरा चश्मा उसके पास में आ गया मेरे पति को फ़ोन करो चश्मा था मेरा मेरे पति को बुलाऊंगा तो अपना चश्मा धोने को बोलो ये हरीश टंडन सर का है हरीश टंडन सर तोमर जी हरीश टंडन सर बैठे उनको दे दो बैग हाँ संजय सर बोलिए हाँ क्या असिस्टेंट चाहिए हाँ हाँ मैं भेजूँ एक मिनट वन सेकेंड विक्रांत सर तोमर जी मुकेश आओ ये दीपांकर दत्ता सर को कोई असिस्टेंट चाहिए फोटो असिस्टेंट देखो क्या ये दीपांकर दत्ता सर के पीएस का फ़ोन आया है उनको कुछ वो चाहिए वोटर हेल्प कुछ चाहिए उनको कुछ हेल्प चाहिए हरीश टंडन सर का तोमर जी हरीश टंडन सर को बैग दो ना डेलीगेट चीफ जस्टिस उड़ीसा हाई कोर्ट नंबर 2 उनको नहीं चीफ जस्टिस उड़ीसा हाई कोर्ट we will be starting the session in 5 minutes just waiting for Justice Dipankar Datta he's on his way
Check. Hey. 1, 2. Testing. Check. Hey. All right. Check 1. Check 2. Check.
Good morning, everyone. I now request Mr. Vikas Singh, President SCBA, Mr. Rahul Kaushik, Vice President SCBA, to kindly escort Honorable Mr. Justice Vikram Nath, Judge Supreme Court of India, for the lighting of lamp, escort them to the dais. All the delegates, please come for lighting of the lamp.
ओंकारं बिन्दु संयुक्तं नित्यं ध्यायन्ति योगिनः कामदं मोक्षदं चैव ओंकाराय नमो नमः ओंकाराय नमो नमः ओंकाराय नमो नमः ओंकाराय नमो नमः नमो नमः नमो नमः नमो नमः नमो नमः
Sir, President SCBA, to escort Vikram Nath sir, Judge Supreme Court India, to the dais. Good morning, everyone. I welcome Honorable Mr. Justice Vikram Nath ji, Judge Supreme Court of India, Honorable Judges of the Supreme Court and High Court, distinguished speakers, respected seniors, and dear colleagues. On behalf of the Supreme Court Bar Association, it is my great privilege to welcome all of you to the first SCBA National Conference on the theme, Reimagining Judicial Governments, Strengthening Institutions for Democratic Justice. Usually, when lawyers gather in such large numbers, it is for an important case or an urgent mention before the court. But today, we have gathered for something equally important, to pause, to reflect, and to discuss how we can strengthen the institution that delivers justice. Over the next few days in Nandi Hills, Bengaluru, we will deliberate on important themes such as mediation, justice delivery reforms, inclusion in the legal profession, the journey of first-generation lawyers, and growing role of technology and artificial intelligence and judicial government's role of Viksit Bharat. This conference is particularly special because this is the first time that Supreme Court Bar Association is organizing a national conference of this kind. So I welcome all the participants again. So I hope that along with meaningful discussion, we will also create memories together of ideas shared, conversation continued, and friendships strengthened within the legal fraternity. We are deeply honored by the presence of Honorable Mr. Justice Vikram Nath, sir, whose guidance and encouragement to the bar make this gathering even more meaningful. Before we begin the proceeding, let me leave you with one thought. Justice is delivered in courtroom, but it is strengthened when the legal community pauses to reflect together. With these words, may I request the dignitaries on the With these words, I request Mr. Rahul Kaushik, Vice President SCBA, to kindly give the welcome address.
Honorable Mr. Justice Vikramnath, Judge Supreme Court, Honorable Judges of the Supreme Court, Honorable Mr. Justice B.R. Gavai, former Chief Justice of India, Chief Justices of different High Courts, Judges from different High Courts, Mr. Mukul Rohatgi, former Attorney General of India. On behalf of Supreme Court Bar Association, I extend my sincere gratitude to all the honorable judges, distinguished speakers, respected members of the bar, and all the participants for coming together for SCBA First National Conference on Reimagining Judicial Governance, Strengthening Institutions for Democratic Justice, which will be today and tomorrow. This conference is of great significance, not only because of the importance of the themes being discussed, but also because it brings together the bench, the bar, and the wider legal community for a meaningful exchange of issues that go into the heart of our judicial system. We are extremely thankful to all the members of the SCBA for the huge response, as around 400 members have registered for this conference. We are thankful to all the senior advocates, panelists, members of the bar, whose presence reflects a shared commitment to strengthening judicial institutions and improving justice delivery in India. I would also like to sincerely acknowledge the efforts of every person in the executive committee associated with the planning, coordination, and smooth conduct of this conference. Organizing a national conference of this scale requires immense effort, careful coordination, and constant dedication. And for that, I convey my heartfelt appreciation to everyone working behind the scenes, especially my EC members. We are extremely grateful to all the honorable judges for taking out their valuable time from their extremely demanding judicial responsibilities to grace this conference with their presence. Their willingness to join this national conference to share their thoughts and to guide the discussions on issues of such institutional importance is deeply humbling for all of us. Their presence not only adds great dignity and depth to this conference, but also serves as a source of encouragement and inspiration to every member of the bar and every participant present here. I hope that the deliberations in this conference will not only be intellectually enriching, but also contribute meaningfully to the larger conversation on democratic justice, institutional reform, and the future of justice delivery in India. With utmost respect and gratitude, I thank all the honorable judges, respected members, and participants for their presence, and I welcome them all, and I look forward to this national conference being a truly meaningful and memorable success. I also acknowledge the presence of Attorney General for India, Mr. Venkatramani. I missed it in the beginning. Thank you.
Thank you. Now I request our President, Vikas Singh sir, to come and give the presidential address.
Honorable Justice Suryakant in abstention because he's going to join us in the afternoon. And why it is important to take his name, because this whole idea of having this conference started when he gave us this date in Bengaluru, and he said he's there only for half a day for some function and he'll be with us for this national conference. Justice Vikramnath, who has been very gracious to fill in for the period when Justice Suryakant is not to be with us. He was supposed to be with us for the Commonwealth Lawyers Association session where we are signing a memorandum of understanding with the CLA, and also filling in the inaugural and the valedictory, and also in the mediation sessions. Honorable judges of this court, Mr. Sriram Panchu, Stephen Thiru, Mr. Mukul Rohatgi, Mr. Rajiv Gauba, Mr. Attorney General Sanjeev Sanyal, Ashutosh, Chief Justice of the Guwahati High Court, Justice Tandon, Shibu Shankar, my friend, and all the other friends who traveled all over the country to be here today. It's actually a very emotional moment for me because this is my last term as the President of the Supreme Court Bar. And this is something which was on my agenda from my very first term. Unfortunately, we could not generate consensus because I always believe in consensus in my first term and we couldn't do it. The second and third term went in the pandemic, so unfortunately nothing like this could have been organized. So I said I must do something which will create a legacy for all times to come, where the Supreme Court Bar Association should do something which is very much in the charter of the Supreme Court Bar Association. Our charter says that it's one of our duties in the memorandum which says that it is one of our duties to engage on meaningful discussions to improve the functioning of the judiciary and to have dialogues so that whatever improvements can be done in the system can be done by virtue of this meaningful exchange. And I have tried to get in a very diverse speakers on various subjects. Some of them are critical of the judiciary also, but there is no harm in having their views and trying to tell them what is our problem, and if there is something which is a positive suggestion from them to try and improve our system as well. So this whole conference is meant to be basically a exchange of ideas and also to see that what better we can do in the functioning of the judiciary. And some of the issues that we have taken are very live issues: pendency in courts, mediation. I've always said mediation is justice for all, because even if you decide all the cases today, you don't get justice for all, because half the people will go feeling that they didn't get justice. But if you mediate a settlement, you get justice for all. Both sides go happy. So the issue with regard to first generation lawyers, today we see large number of young boys and girls joining the law colleges who are first generation. They are a little rudderless. They need to be handheld. Women in the judiciary is a very sore point, because we see the higher judiciary, the percentage of women is very, very small. So that is one subject which we'll be doing in the afternoon, which is the subject with the Chief Justice of India will be with us in the afternoon. So all these are very, very important subjects. The CLA session also, where we are signing the memorandum of understanding, and we are also talking of the AI in judiciary. So I'm extremely grateful to all of you for coming all this far and to attend this conference, and I hope it will be a huge success. Thank you.
I welcome Honorable Justice Prashant Mishra sir, Justice Varale sir, and Justice Koteshwar sir. This is to inform you that Attorney General for India has specially penned down a special poem for this session. So in his session, we are looking forward to a special poem, sir. So I welcome you especially, sir. With this, I request Justice Vikram Nath sir to give the welcome address.
A very warm good morning to everyone present in this auditorium. My esteemed colleagues, Honorable Chief Justices coming from different high courts, Honorable Judges coming from different high courts, my elder brother and guide and mentor, Justice Gawai, former Chief Justice of India, Learned Attorney General, Mr. Vikas Singh, President, Supreme Court Bar Association, members of the Executive Committee of the SCBA, Mr. Sri Ram Panchu, learned senior advocates, learned mediators who have come all over from the country. Indeed, this is a very commendable step from the SCBA to have organized this conference, especially here in Bengaluru, giving us opportunity to travel and spend a couple of days out of the hectic life in Delhi that we lead, which probably a lot of people don't understand outside the system. But this break is actually welcome. My memory for mediation goes back to 2006. I was just talking to Mr. Panchu yesterday evening over dinner. I was made a member of the committee of the Allahabad High Court Mediation Committee. Justice Ambani was chairing that committee and I was one of the members. And the first session we called for training of mediators, Mr. Sri Ram Panchu had come for that. After that, I never had an occasion to meet him. I met him only yesterday. Probably he is the father of mediation in India and the most sought after trainer. He travels world over. So mediation over a period of years has come a very long way. And today we find so much activity around mediation and in order to promote mediation, because it is one of the best way to solve a dispute. Today, one dispute has arisen with the President of the Supreme Court Bar Association, because I wanted to say something, he has stopped me from saying that. So now we'll need a mediator to sort it out. And I would request Justice Gawai to accept this request and resolve that issue. The terms of the mediator will be settled by the parties mutually, but that needs to be resolved. Anyway, without taking much time, and as it is, we are running a little late, and there are judges who have come from Delhi who have to catch their afternoon flights, so if we delay the session further, their session gets delayed. So I will not say much, and once again, I thank SCBA, and I welcome all of you here. The first session is about to start, and I will be there in that session. So thank you very much.
Thank you, sir. Now I request Mr. Sushil Tomar, Joint Treasurer, SCBA, to come forward and present a bouquet of flowers to Honorable Mr. Justice Vikram Nath. Thank you, sir. Now I'll call the panelists for the first session now. Wow. Chairs and the first panelist. I will introduce the panelists of the first session. We have Honorable Justice, Mr. Justice Vikram Nath. Justice Vikram Nath is the Judge Supreme Court of India, appointed on 31st August 2021. Previously, he served as a Chief Justice of the Gujarat High Court and a Judge of the Allahabad High Court. The second panelist is Honorable Mr. Justice Sandeep Mehta. Honorable Mr. Justice Sandeep Mehta is a Judge of the Supreme Court of India, appointed on 9th November 2023. A specialist in criminal and constitutional law, he previously served as the Chief Justice of the Guwahati High Court and has held various leadership roles in the Bar Council of Rajasthan. The third panelist, we have Mr. Mukul Rohatgi, Senior Advocate. Mukul Rohatgi, sir, is a very popular senior advocate, former Attorney General for India and the Additional Solicitor General of India. The fourth panelist is Mr. Shriram Panchu. Mr. Shriram Panchu is a senior advocate of 46 years of standing at the bar. He is the forefront of the mediation movement in India and an internationally recognized Indian mediator. I request all the panelists to come on the dais.
Hello.
This session, we start the first conference of the SCBA and our session on the transformative role of mediation. ADR and mediation is a relatively new concept in judicial system, but has received phenomenal response. On an average, according to the report of NALSA, nearly 1 lakh cases get settled every year through mediation. However, there are challenges. Many lawyers are skeptical about mediation. People perusing large commercial dispute do not prefer to get their cases referred to mediation. Many litigants do not have the confidence that the mediators are in a position to understand the nature of the disputes. We will discuss this and many other issues in this first session. The session is being moderated by Rahul Kaushik, Vice President SCBA. I request Mr. Rahul Kaushik to start the session.
So we can start.
There's a lot of echo. Please, can you just help? Technical team, please help. Our fourth panelist, Mr. Panchu, will be joining us shortly in 2 minutes. In the meantime, we can start the panel discussion.
So I'll request Mr. Mukul Rohatgi, former Attorney General of India. He needs no introduction. He appears in every high-profile matter. So we'll just like to hear from Mukul, sir, about mediation.
Good morning, everybody. Justice Vikram Nath, Justice Mehta on the dais, judges of the Supreme Court, retired judges, retired Chief Justice of India, Justice Gawai. It's a great honor to be here and to look at all our friends from the Supreme Court in a very different environment. This is actually an environment which should be akin to mediation, not an environment of a war or fighting in court with lawyers on both sides without giving an inch. That's what our system, our society, and I'm sorry to say, our legal system and the lawyers have become. What have we grown up with? Lawyers doing litigation, taking it like a war, not an inch to be given, not an inch of suggestions, no attempt to try and settle. This is what we have become. And I must say, the lawyer's body must take a fair share of this blame. If you look at the lives of Mahatma Gandhi, or for that matter, Abraham Lincoln, they spent most of their practice in trying to see that matters are settled rather than fought out. We today have a system where the litigant and the lawyer don't trust anybody. So first court, appellate court, high court, Supreme Court, review, curative, all this will go on and the war is endless. At the end of the day, if you had to get 1 rupee or 8 annas in a settlement and you get 1 rupee after 15 years, the actual value of that 1 rupee is nothing. But that's how the system has become. So if you go back to the times which were described by Premchand, Panchas, I am reminded of a case, and maybe a time has come to modulate mediation and arbitration into something like a hybrid. A case comes to my mind. So there was a dispute between the Modis. Matter was referred to Chairman IFCI. He had to decide. He decided. Question arose before the High Court and the Supreme Court. Is it an arbitration? And if it is not an arbitration, his decision, what is it? It was argued by one side, it's an arbitration award. The other side said, no, it's not an arbitration award. It is just a decision of an expert, and it is final. The Supreme Court ruled in that case it was not an arbitration. It was a decision of an expert to whom you have faith in, and the decision is final, and the decision is that of an expert. Now, if we have something like that, because what happens today is the court sends it to mediation. The mediator tries it, but the positions are so hardened. You say, we'll see in mediation what happens. Doesn't happen, come back to court, the same battle continues. So it's like a ceasefire. The ceasefire helps in 1 out of 100 cases. If you have something like this and we drive parties to an expert who is trusted by the court, trusted by the lawyers, and his decision is therefore final. So it doesn't give rise to mediation in court or an arbitration, 34, 37, etc. Maybe we could look at something like that, have a hybrid kind of a situation. Maybe it can, if we resolve our outlooks and come back to the old ways of Panchas, maybe this could be an innovation. These were my opening thoughts. Thank you.
Thank you, sir. sir with his experience shared, this litigation is endless. The moment it starts from the lower courts, the moment till the time it reaches the Supreme Court, the litigation is endless. So mediation is the way forward. So now I would request, we will have all the panelists are going to speak for some time. In the end, we are going to ask some questions, and if we have time permits, we'll request the audience also to put some questions to the panelists. May I now request Mr. Sriram Panchu. He needs no introduction. He is one of the most renowned mediators in India with an experience of more than 46 years. He would have been a mediator in all the high-profile disputes. May I now request Mr. Sriram Panchu to share his experience with all of us. Thank you.
Good morning. Esteemed panelists, distinguished judges, my fellow members of the bar, other participants, ladies and gentlemen. In the 1990s, when I first started speaking about mediation, I did so with an evangelical flavor, trying to convince those who came to scoff to remain to pray. But now I don't do that. I just say it as it is. I say, you lose if you don't try it. Why? Because mediation ticks off all the boxes for good resolution of conflict. These boxes are time, cost, not just the cost of litigation, but the cost of overrun projects, as Vikas was talking about yesterday, relationships, restoring or salvaging relationships, a completely risk-free process, because there is no risk in mediation, the centrality of parties in the process, they are the ones who matter, a practical solution which all accept, and that sends justice for all, and enforceability. I was telling Vikas yesterday, I've mediated now for 35 years. I have never had a single case where a party went to court after the mediation to question the mediation agreement. Not one case. And I think this is the best way to deal with dispute. The best way to deal with dispute is to end dispute. So it is therapeutic. It's good for body, it's good for mind, it's good for soul, and it's good for the purse. We all want mediation to play its role for better and wholesome resolution of dispute. In the appropriate case, not all cases, but in the appropriate case. And to rid us of this perennial backlog. We all want it. But ladies and gentlemen, that requires strategic thought, focused planning, and concerted action. And I'm going to focus on that. I'm going to borrow from photography. And I'm going to use the concept first of a standard lens. The standard lens is where we are now, court-annexed mediation. That's where it started. It will always be an important stage. But to achieve its potential, we need to do 3 or 4 things pointedly. Number 1, pay mediators better. This honorarium or just above will not sustain interest in mediation as a career. Number 2, government should realize that the cost of resolving a dispute in mediation is a fraction of the cost of litigating it. So it makes economically good sense to fund mediation, and I'm glad Mr. Sanyal is here. But in the courts, we can do a bit. In cases where the stakes are large and the mediation is successful, all that the judge has to do is to ask the parties to make a donation or payment to the mediation center. Some of these cases run into hundreds of crores. A party will be more than willing to pay. And Rahul, if you ask me during the questions, I will give you a wonderful example. Send mediators good cases, not just routine transfer and matrimonial cases. Send them cases that matter, civil, commercial, property, personal, cases with complexity, cases with challenge. Send our mediators those cases. Increase the flow of cases. Apply the mediation filter at each stage, pre-litigation, just after interim orders, at the appellate stage, whenever it seems that they are fatigued, and that includes arbitration as well. And never mind if it's been tried before. Quite often, cases will settle in mediation at the 2nd or 3rd attempt. Each case has its own karma. The time for resolution has to come. We only have to keep trying. For the judge, the backlog is a burden. For the mediator, it is a treasure trove, like nowhere else in the world. All we have to do is to evolve a mechanism to dip into this trove, select the cases appropriate for mediation, get them referred, and save the parties years of waiting time. It's quite simple, actually. And some ideas that work are actually quite simple ideas. Can I have that water, please, to come to my... It's on my table. It's on that flask. Yeah, thank you. I'm fortifying myself before I come to the most important point. The most important point is that fundamentally we must realize one thing. Court-annexed mediation is not the mainstay. It is a fantastic learning experience, it is a great feeder, and it is a great backup. But if we want mediation to achieve its full potential, we must focus on professional, career-oriented mediation. Professional, career-oriented mediation. That is what we need to encourage and build. That is the only way it will be sustainable and successful and achieve the dreams for it that we are investing in. How do we do this? Bring it into law schools and add on practical observation and role plays. Encourage mentoring of the young. Open the court annex system to fresh entrants to the bar. They can be observers, they can be co-mediators, they can mediate small claims and grow. They will grow to embrace it. These are our future. But we need to permit entry early. If you tell them to wait for 10 years to join the mediation system, they will go elsewhere. Idealism cannot be refrigerated. They have their idealism at 21. We have to get them at that stage. Creating rewarding work is the fulcrum, the real key. How do we do this? At the time of referral, generally I would say, give the parties the choice and option of selecting their mediator. This respects party autonomy. They will choose a person they trust, and that is halfway to success if both of them choose their mediator. And it creates a field for professional mediation. When the court is appointing a mediator, it should also consider appointing experienced mediators who have served the court system for long. Consider, please, another idea. Consider pairing a retired judge with a senior mediator. A retired judge brings the air of benign authority and the capacity for resolution. A mediator brings the art of opening up communication and problem-solving skills. I had a very interesting experience of mediating an international mediation with Chief Justice T.S. Thakur. Both he and I thought this was a good combination. The parties thought so too. They settled a major dispute in 1.5 days. So I hope you will give this thought, sir. In the appropriate case, I think it will help. And perhaps in this dispute which was mentioned just this morning, I could team up with Justice Gawai and we could co-mediate this dispute. Abroad, the medium of costs is a great propeller to get parties to mediate. Costs are awarded for refusal to mediate, for not participating in good faith in the mediation, and even for turning down an offer in mediation which is reasonable. Now, this has been justified as being in the interests of administration of justice because it works to getting an amicable resolution, and cases which eat up much of the court's time over years get resolved in a few sittings. So it lessens the burden on judges. When I think of Indian judges, I always think of that Greek figure, Sisyphus. He was consigned to always pushing that rock up the hill only to have it roll back again. Your backlog is not just as daunting as his, but I think far, far more. So I think these measures, apart from bringing good resolution, will go a great deal to cut that backlog down. Now let me switch to the wide-angle lens. One impediment, we don't talk about it, is the deterrent financial aspect that lawyers and law firms face. If a major stakes matter, big stakes matter, gets taken to mediation and gets resolved there, there is loss of anticipated income from a long-lasting dispute with multiple petitions and appeals. We need to address this. The problem is because lawyers and law firms build on a per-appearance basis. One way out of this is to permit and encourage the concept of a mediation settlement fee, a consolidated fee, if the matter gets settled. We have frowned upon conditional fees because we thought it akin to champerty. But champerty is frowned upon because it aids litigation. This is mediation which ends litigation. So we should encourage a mediation settlement fee when it comes to mediation. If we can financially incentivize lawyers and law firms, we would have overcome a major hurdle. And Rahul, I have an example on this. If you have time, you can ask me. Now, this is not to deny that lawyers genuinely want to help their clients to settle. Indeed, I think mediation opens up the tap of humanism in my comrades at the bar, and I have seen it very often. A big challenge is in getting government to mediate, 48% of cases. It's not that they can't be mediated. Government officers and PSU's officers told me, sir, we can mediate more than 50% of these cases. But the big stumbling block is the fear of facing investigation and prosecution when they negotiate a settlement. All settlements involve giving up something. You're giving up something small to get something big. But if the giving up of that something small becomes the basis of a prosecution later, then you will not do it. So government doesn't settle. What's the way out? There is one way out. Appoint a high-level committee or committees. Have it headed by a Supreme Court judge, a retired Supreme Court judge, a former CAG, a former CVC, whoever you like. Let negotiations be, disputes be negotiated. Let the draft settlement terms be taken to this committee. They will either say yes or no, or say go back and renegotiate this point. But once the committee has given its approval, there should be official and legal immunity for the negotiating officer. If you do this, you will cross the midway point in settling government disputes. Sanyal Saab, please, this is very, very important. Then we talk of panchayats when we talk of mediation. That's our route. But we don't have a mediation service at panchayats. It is not difficult to administer training to panchayat members. It is not difficult to associate a trained mediator with panchayats. Let us reharness this pervasive, grassroots, indigenous, and culturally rooted methodology of resolving disputes that we have in a way that benefits disputants and the community. Water. Yeah. Thanks. We have the Indian Administrative Service, the Police Service, other services. We have the Judicial Service. Perhaps it's time we thought of the Indian Mediation Service. It could be a permanent cadre or short service tenure. Mediators on its roles could provide service at courts, panchayats, police stations, government offices, public sector bodies, and other places. Their services could be loaned to institutions and agencies on request. They would become the first fence against dispute resolution. And I think on this, the Mahatma would definitely smile if he started this. Let's not leave our business and industry from the lens of reform. We need to send out a message, rather strong and repeated messages, that going to court is not business as usual any longer. While the courts are there for urgent matters and as the place of last resort, commercial litigants must give mediation a good try. Industry associations, CII, FICCI, etc., can set up mediation facilities for their members. One other reform. The Companies Act has provision for statutory appointments. Company secretary, cost accountant, chartered accountant, labor officer, and so on. My suggestion is, companies above a certain size should be required to have an in-house mediator. Below that size, maybe they can draw from a pool. The mediator is available to sort out disputes within the company and also help in resolving disputes a company has with suppliers, customers, etc. And I ask you a question. Surely, isn't dispute resolution as important as the keeping of accounts? So let's think of this also. Because what it will do, it is not just establish a mediation culture in the commercial world, but it will open up vast opportunities for mediators and young mediators. The landscape will change. So I've done the standard lens, I've done the wide angle one. Let me close with the telescopic, which is the looking glass into the future. Ladies and gentlemen, if we adopt the right strategies, in 25 years, with the will that carves the way, half of India's civil, commercial, and property litigation should shift from court dockets to mediation tables. There are legacies to be made here. To my friends who say this is excessive enthusiasm, I have two answers. The first is Victor Hugo. He said, "Nothing is as powerful as an idea whose time has come." And the second, my personal favorite, is Robert Browning. He said, "A man's reach should exceed his grasp, else what's the heaven for?" Thank you very much for listening.
Thank you, sir. It was so good to hear from Mr. Panchu, from his 35 years experience as a mediator. He shared his experience. And what all I could just hear, at least 4 or 5 very good points he made. It's high time we need to have full professional career-oriented mediators. We need to bring it in law schools, encourage early mentorship so that people actually can take up as a career as a mediator. Secondly, emphasize that parties be given option of mediators. Most importantly, what people are not realizing, actually a huge backlog which we have. You know, with the huge pendency we have with this mediation, we can actually cut down a lot of pendency. And most importantly, government is the biggest litigant. So if 48%, in fact, what he emphasized, if government can actually seriously think about mediation in their matters, lot of litigation is going to come down. And we see a lot of corporate litigation also, in fact, not, I would say corporate litigation, but litigation in the company itself. So what he emphasized with, in fact, all the companies can actually have mediators to settle the disputes inside itself. So thank you, sir. It was a very meaningful lecture by you. We're going to ask questions to sir in the end. Now may I request Justice Sandeep Mehta to share his views on mediation with us.
Good morning. And first of all, thank you SCBA for giving me this opportunity to be in the alma mater, amongst the alma mater, the bar. My esteemed elder brother, Justice Vikramnath, thank you, sir, for sharing the bench today also. My brothers, Justice Mishra, Justice Varale, Justice Koteshwar Singh, Justice Augustine Masi. My mentor on the bench of Supreme Court, Honorable Justice B.R. Gawai. Thank you, sir, for giving me all that opportunity when you really guided me for almost 6 months when I was sharing the bench with you. The opportunities which you gave me, I'll carry them in my heart. Esteemed dais, this topic which we are discussing today on mediation, I'm given a very difficult period of speaking after Mr. Sriram Panchu has spoken. As everyone knows, he is an authority on the subject, and he has indeed given very valuable insights on how mediation should be looked at in the future. Speaking for myself, I must confess that I never had the opportunity of having a mediation training. But there are 2 incidents in my career as a High Court judge which I distinctly remember and like to share, which changed my perspective on how everyone should look at mediation. The first incident related to a matrimonial dispute in a Rajput family. It was a case from the city of Bikaner. The matter came up before me in relation to an interim order passed in domestic violence proceedings. As is usual, every one of us, whenever a matrimonial issue comes up, tries to see if there has been an effort of mediation. So obviously, I also asked the same question to the lawyers. And they told me, sir, we have already had 3 or 4 rounds of mediation which have all failed. As I could see from the records, the parties were embroiled in no less than 11 different kind of litigations. The wife had been given a residence order in the DV Act proceedings of right to reside in the shared household, and resultantly there had been physical fights. Now, a few observations, and Aishwarya ji will associate with that. They really bothered me. The wife and the family members from the matrimonial side, they included, of course, the husband, the mother-in-law, and the husband's aunts. They were all in the court. They were all wearing dark, grayish kind of clothes that depicted the kind of disputes which were going on. So I told the lawyers, let me make another effort of mediation. Of course, they were skeptical, said we already have tried many times, it doesn't succeed. I told them, just bear with me for a while. So now, 2 things which Mr. Rodgi said and Mr. Panchu said, both are there in that experience. So I first asked the lady as to what she wanted. They were embroiled in disputes for last 9-10 years, so there was hardly any possibility of resolution, in the sense there was no possibility of them uniting. Fortunately, there were no children from the marriage. So the lady, she said, a very gracious woman, as women usually are. So she said, I don't want anything. I am from a Rajput family. There is no possibility of me remarrying. So what I want is, I should be given a small house where I can live and a lump sum amount so that I can do my, use it for my expenses, day-to-day expenses. So I asked her what was her expectation. She told me that the joint or the shared household wherein I am presently residing, where all these disputes have been taking place, that is worth almost 1.5 crores. We are talking of 2015-16, and a city like Bikaner. That was really valuable. She also said that the husband has got a small apartment 10 kilometers away, which is hardly worth, say, 15-20 lakhs. And if I am given that and some amount, I'll be happy. The husband was resisting all along. No, that's too much. I can't afford that, this, that, all. So then I showed him the mirror. That's what is really important. I asked him to come back after a few days with a calculation on how much he had spent on lawyers' fees during the extended litigation for almost 9 years. I also told him that you think of it, I am assuring you that this litigation, if it doesn't end now with the effort of mediation, it will continue for another 20 years. You will not be able to remarry, and your fate is almost accomplished. So I told him to come back with that calculation. Next date, the parties again came. I asked the husband, have you calculated how much you have spent? And tell me just fairly whether what you have spent is not more than the value of the small apartment the lady is asking for. He confessed, sir, it is true, I have spent much more. Then I told him, prepare to spend many times more in the next 10 years. I also asked the lady as to what amount she was expecting. She gave a figure, say around 25 lakhs. I told her, be a little reasonable, because if he's giving you the house, he has already spent a lot in litigation. You also are qualified, you can work, earn for yourself. So she scaled down that demand somewhat. The husband agreed. I fixed the matter 7 days later. And on the next date, when the ladies appeared, they were all wearing bright clothes. The matter was resolved. All 9 litigations between the parties were closed by a single order. So the most important takeaway from that experience was that you have to show the mirror to the parties. You have to make them understand that what they are losing, not only in terms of money, time, effort, most important is the future opportunities. If you are able to convince them, I'm sure the efforts of mediation will never fail. The second incident was even more interesting. The matter came up before me in an anticipatory bail application, which was pending in the High Court for almost 8 months. I could see from the proceeding sheets that at one point of time, they both were young people, tech experts working in Pune. At one point of time, the girl had demanded 80 lakh rupees for settlement. So again, when the matter came up before me, I asked them whether there has been any effort of mediation. Same reply, number of efforts, all failed. I asked the husband, what is the problem? He said, sir, there is nothing, only temperamental differences, and I am ready to take her back. I was ready to take her back, but the problem is that though I am before you seeking anticipatory bail, but my parents had to go behind bars. They were arrested. So I gave the parties a picture of what the future of their litigation would be. I told them that I had had a good significant experience of trial courts. The case, the single 498A case which was pending at that stage, I told the girl it will take at least 10 years to conclude. The husband would get, even if I reject the bail application today, the magistrate would release him on bail. The very next day he is arrested. Thereafter, the bad blood would start even increasing more. The possibilities of resolution would completely evaporate. And while the husband would get away with an exemption from personal experience, the girl would have to, on every date, think why my case is not proceeding. She would then become the tormented rather than the prosecutor. I gave them just time of about 2 hours. I told them, you go to this particular mediator, keep these things in mind, and come back at 2 o'clock. And please see the result. At 2 o'clock, the girl came and said, I don't want anything, not a single penny. My original documents are lying with the boy, the husband. Please get those documents for me. And I want a divorce order within 7 days, divorce decree in 7 days. 80 lakh rupees to zero in one session of mediation after I had shown them the true picture of their litigation. Ultimately, the order was passed. They got a decree of divorce by mutual consent in 7 days, and everything was resolved. So what Mr. Rodgi observed, that if this positive, this true picture is provided to the litigants by the lawyers at the first stage, probably the chances of mediation succeeding would increase manifold. The second observation, of course, Mr. Panchu has drawn a wide canvas. These are two matrimonial matters which were resolved. Sitting with Justice Vikramnath, we have had the opportunities of getting many more other kinds of litigations resolved through mediation. But the most stumbling roadblock, as Rahul Kaushik pointed out, is the government. The experience in the National Lok Adalats, where we hold pre-litigation mediation sessions, is sad to say the least. There is hardly a single department of this government which comes forward with a positive response. The officers, they shirk, or they are rather afraid to give any kind of commitment lest they face the flack for compromising at a later stage. If this mindset were to change, I am sure that a large number of cases of involving petty disputes, say pension matters, medical reimbursement, if a more pragmatic approach was to be taken by the government, large number of cases would be resolved by mediation. So once again, thank you SCBA for giving me this opportunity. These are small experiences which I had I could share with you. Thank you. Jai Hind.
Thank you, sir. When we appear before Justice Mehta, he is more prepared than all of us are. And here also, he was so focused in what he spoke. So what he shared from his experience, 2-3 things. In fact, this is for all of us lawyers to ponder actually, that whether we all give a real picture to the clients. He spoke from his experience. As a judge, he actually told the clients, if the litigation might go on for 10 years, if you keep on fighting, you'll keep on going to the trial court. So this is actually a point for all the lawyers. Even at the lower level, are we giving the real picture to the client? The matter actually can get settled. There's so many litigation can actually be settled. And again, our second speaker also actually spoke about regarding the government. Whether actually government is actually coming forward when the matters can be mediated. The officers are actually shirking away from that. So this is actually for all of us to ponder about. With this, may I now request Justice Vikramnath, our next speaker. There's never a dull moment in his court. In fact, if you want an adjournment around 1 o'clock, he says, whosoever wants a dismissal, he can come. So this is how he is in his court. There's never a dull. May I request Justice Vikramnath to speak?
So once again, I'm here, but this is going to be a very dull address. Court proceedings are different, but addressing such a distinguished gathering is something very different, and I have to be very careful and cautious of what I say. In court, I can say many things which I cannot say here. So let me begin by saying that mediation is one of the most spoken about subjects in the legal discourse today. There are conferences organized, papers are being written, panels like this one are constituted, and yet, for all its familiarity, it is one of the most misunderstood areas. The most common misconception is this, that mediation is the art of splitting the difference. That at its core, it is a process of compromise. Each side giving up a little, meeting somewhere in the middle, going home mildly dissatisfied but resigned. If that were true, mediation would be a lesser form of justice, somewhat diluted. But that is not mediation in its true sense. What it does is something far more ambitious and far more human. It seeks equilibrium. And equilibrium is not compromise. Compromise means both sides lose something. Equilibrium means both sides find something, a restored balance and a rebuilt relationship. In a court of law, the question that everybody is concerned with is who is right. Mediation asks something far harder. How do we live together after this? History tells us that mediation has always been the first preference for resolving disputes. Long before there were courts, every civilization developed its own version of sitting people down and making them have a dialogue. Our panchayat system did this for centuries. The Confucian philosophy in ancient China went on to the extent to say that a magistrate who sent a dispute to court had already failed. In Arab cultures, the Sulha tradition brought feuding families to the table not to determine guilt but to restore coexistence. These were not merely curiosities, they are evidence that mediation as a system has always been instinctively preferred by societies to resolve disputes. This discussion becomes all the more important because we stand today at a moment of profound stress for the justice system. The challenges are different from any previous era, and they demand that we think differently. Our courts are overwhelmed. The pendency of cases keeps on growing. In this context, mediation performs a function that is both pragmatic and principled. It offers a pathway for resolving a significant category of disputes, particularly those involving continuing relationships, in a manner that is faster and less adversarial. When deployed thoughtfully, mediation does not compete with adjudication. It complements it, enabling the justice system to allocate its resources more rationally and to deliver outcomes that are both timely and effective. At the same time, the justice system stands on the threshold of another transformation, with artificial intelligence beginning to influence research, drafting, and even elements of decision making. While these developments hold considerable promise in terms of efficiency, they also raise an important question about what must remain distinctly human within the administration of justice. Mediation answers that question with clarity. It is a process grounded in listening, perception, and the understanding of human behavior. As certain aspects of adjudication become increasingly technology-driven, mediation assumes a renewed significance as the space within the system where emotion and human experience are not peripheral but central to resolution. In that sense, mediation does not merely coexist with technological advancement, it serves as a necessary counterbalance, ensuring that in our pursuit of efficiency, we do not lose sight of the human dimension that gives justice its legitimacy. With all great promises that it comes with, mediation has its own problems. Parties sometimes adopt dilatory tactics. They try to delay the process, exert pressure on the other party. These are real limitations, and they demand real responses. Better training for mediators, more rigorous case screening, and the institutional support that the courts and statutory rules provide. For the first time, we now have a dedicated statute for mediation, the Mediation Act 23, which holds considerable promise. It lays down a comprehensive framework, provides for pre-litigation mediation, online mediation, and community mediation. With this in place, there is also a need for developing a cadre of trained and specialized mediators. Mediation cannot be treated as an intuitive skill that any legal professional can step into without preparation. It requires discipline, combining legal understanding with psychological insight, communication skills, and ethical sensitivity. There is also a practice at some places that even mediators have undergone training and certification. Their recognition remains confined to the particular center or court-annexed program that impaneled them. This creates fragmentation and discourages professionalism. I would like to use this platform to urge the institutions that once mediators have been recognized by a certain institution, they ought to be recognized across all jurisdictions and forums so that mediation can develop as a credible and cohesive discipline. If mediation is to be integrated into the justice system in a meaningful way, its practitioners must be accorded a degree of professional legitimacy and mobility that reflects the seriousness of the role they perform. Courts should promote plain language, explanatory material, short pre-meditation orientations for parties, and short statements in the record by mediators describing the scope of the settlement and any safeguards used to protect vulnerable parties. Clarity about enforceability is another important aspect. Settlements must be recorded in a form that preserves voluntary choice, yet gives the parties confidence that their agreement is durable. With that being said, I would like to briefly highlight certain recent developments in the field of mediation. The Mediation and Conciliation Project Committee, which I presently have the privilege of heading, has been consistently working towards strengthening mediation infrastructure. MCPC is continuously working towards increasing the number of trained mediators and trainers. Under the Mediation for Nation 1.0, launched in 2025, about 540,000 cases were referred for mediation, out of which more than 110,000 cases were settled. Several connected cases were also disposed of on the basis of these settlements. Under the Mediation for the Nation 2.0 program, more than 6 lakhs cases have already been referred for mediation. The number of mediators have increased significantly from 7 to 8,000 to nearly 20,000 within a year. The Train the Trainer TOT program is being implemented across states to develop local capacity so that all states have their own mediators. For instance, from the state of Gujarat, MCPC has empaneled 11 trainers and 12 potential trainers. Law colleges have also been integrated into the training ecosystem. Faculty members from institutions such as NLU Patiala, NLU Ranchi, and the Faculty of Law, University of Delhi, have completed mediation training with others like Nalsar University of Law and NLU Visakhapatnam expected to follow. As per the data received by the High Courts, more than 2 crore 33 lakh cases which are currently pending in the Indian courts are considered suitable for mediation. Community mediation initiatives such as the recent program in Bagpat, Uttar Pradesh have been introduced to strengthen grassroots dispute resolution and reduce avoidable litigation at the village level. These developments mark important progress in the evolution of mediation in our country. At the same time, they invite us to look beyond the institutional framework and consider what mediation means in lived human terms. Coming to a close, and I say this with experience, some long-stretched disputes have very little to do with the reliefs actually claimed. This is particularly true of matrimonial cases. People who have been litigating for years are more often than not at their court, not fighting about property or maintenance figures. Of course, it forms a part of the collateral, but they are fighting because no one has yet acknowledged what they went through, and that acknowledgement can never happen in a courtroom. It's only in mediation that they can openly talk about it. What a party sometimes needs is not a favorable order. It is for the person sitting across the table to say that they understand, that they recognize the cost and sacrifices. People carry conflicts for so long and so heavily, but not always because they want to win, but because they are waiting for that acknowledgement. This is something that restorative justice in criminology has long argued, that harm is not only material but relational, and that accountability and not punishment is what genuinely heals a wound. These two concepts cannot be conflated, but they definitely share the same conviction. Dialogue between people actually affected by a conflict can achieve what no external authority can impose. Both of them place acknowledgement at the center of resolution. Might I add, this is not a soft idea. It is among the most honest things either discipline has to say about human beings actually heal. Courts will always be necessary. The rule of law demands them, and nothing I have said today should be read as diminishing what adjudication does and must do. There are disputes that belong in courtrooms and where the law needs enforcement. That role is an indispensable one. But the rule of law also demands that justice actually reach people, that it heal and not merely decide, and that it restore and not merely punish. Across civilizations, across centuries, across conflicts that seemed impossibly intractable, human beings have returned again and again to the table, to dialogue, to mediate, to the hard work of finding their way back to each other. Mediation is not an alternative to justice. It may be justice in its most complete, its most honest, and its most enduring form. Thank you very much. I'd be happy to have any questions from Rahul and carry on the discussion with the other panelists. Thank you very much.
Thank you, sir. Sir actually spoke about regarding the delay tactics by both the parties in the mediation, to what can be done to improve it. what all is being done to strengthen mediation, and most importantly, with dialogue, you can actually end all disputes. Now with this, we come down to the most interesting part. Now we are going to start the question answer session. And I'm going to start with Mukul sir since he was the first speaker. And my first question to Mukul sir is, now with regard to other speakers, they were all actually for mediation. This is the way forward, but his view was a little contrary to the sense. He's not exactly opposed to mediation, but he was actually not very in for the mediation. So what makes him think that way? That's for Mukul sir.
Thank you. Let me make it clear. I am not opposed to mediation. But I am saying the present setup and the legal system as it is framed is completely topsy-turvy. What does practical experience show? You have Section 12A in the Commercial Courts Act. It is supposed to be a pre-suit mediation as compulsory. There is an exemption. Exemption is if you seek interim relief or urgent relief. I have not seen a suit, by and large, in which interim relief is not claimed. Invariably, exemption is claimed under Section 12A. Invariably, exemption is granted. So there is no pre-suit mediation and parties go to court. When you go to court, in the first round, second round, third round, by that time the positions harden so much that people look at it as an attempt to compromise, as Justice Vikramnath rightly said. All right, ek attempt kar lete hain. After 10 years or 15 years, you just go through the motions and come back. If it happens, good enough, but if it doesn't happen, the object of pre-suit mediation, when I said Premchand and that Panch Parmeshwar, the idea was you sit across, decide it. Justice Mehta said, see the mirror on the wall, what you will get after 10 years, what you will get now. That system is lost in this current setup. So either we should foster a system which is a pre-suit mediation which should happen. Otherwise, the only way out to end this litigation or disputes is to ultimately have a mediator on whom there is trust. People must start trusting people and systems. You trust somebody, tell the mediator to give a decision which will be final and not open to challenge. There will be some right, there will be some wrong, but it will not be endless. This is what I meant by saying we can't just go down one path.
Yes.
Look at this situation.
Absolutely. So,
Yeah, please.
As we all know that Mukul sir is most highest paid senior in the Supreme Court. So I want to know from you, sir, how significant are advocates' fee? Do they influence the process or the party's willingness to settle the mediation?
Look, one should always try, but as I said, it would probably work best in matrimonial or domestic disputes. When it comes to banks, let's look at it practically. 50% is litigation with a PSU or a bank or state government or corporation. There's no question of mediation. They're not willing to give up a penny. So you can't have that. Ultimately, it resolves in what? In these kind of matrimonial issues. It will work best there. Lawyers should do that. And that's why I started by saying we lawyers and our system is to blame. We treat it as a commercial venture. You have a good client, you file litigation, do this, do that. If we have to look within also and try and see if something can be done. So a holistic movement is required between judges, between lawyers, between our system, between our society to see if something can happen. That is a utopian concept. I hope it can happen. If not in our generation, maybe the next generation.
Thank you, sir. Thank you, sir.
so my next question to Mr. Mukul sir is, sir, you have spent decades in high-stakes litigation and served as Attorney General for India also. What can be done to change the mindset of litigation first, even when a settlement would serve the client better?
See, as I said, the government's mindset has not changed over the last 50 years. Mr. Gaba is sitting here. He was cabinet secretary for a large number of years.
Yes, sir.
You can ask him. And also, I must say, I tried as Attorney General in disputes between two PSUs, government, central bodies.
Yes, sir.
There was orders of the Supreme Court, sir, that you will have that committee.
Yes.
Justice Gaba is aware. Mr. Gaba is aware. I sent 1 or 2 matters when he was cabinet secretary or earlier secretaries. Not one case
Yes, sir.
was settled between the ministries.
Yes, sir.
I spoke to I called 2 secretaries to my office, sit across, like Oil India and say Indian Oil.
Yes.
No question. Not settled. I even referred it to the Prime Minister. And I must confess, the Prime Minister, I will not name which one, the Prime Minister then spoke to me quietly. It was a more sensitive issue, not this, more sensitive in terms of water disputes and all that. The Prime Minister then spoke to me and said, "Arey Baba, court mein settle kar do, yahan nahi hota." Now, sir, this is how it is going on. So 50-60% goes this way.
Yes, sir.
Then commercial high-stake disputes between 2 big conglomerates, they have batteries of lawyers. They are not willing to give an inch. मूछ का सवाल है, न्यूज़पेपर का सवाल है, मीडिया का सवाल है, तो वो भी निकल गया. तो बचा कितना सर? उतना जो जस्टिस मेहता बोल रहे हैं. कोई एक हस्बैंड आया, एक वाइफ आई, ये हुआ वो.
So.
वो भी बहुत जरूरी है सर. I say lawyers are to be blamed
Yes.
also. We
Yes.
must look within.
Yes.
That's right. You're right, sir.
So.
Let's hope that happens.
So what I get from Mr. Mukul sir is actually at times it's the professional interest of the lawyers is also coming in the way of effective mediation.
Rahul, we have request, all the contributors are AG also. AG
Just
also.
finish this question as yes. And the government is actually not coming forward for mediation in most of the matters. Now my next question is. So I'll come to Mr. Shriram Panchu. So sir, you actually with your 35-year experience actually talked about we need to change the mindset. We need to start with the law schools early mentorship. The mindset needs to change actually to have the most effective mediation. What makes you say this with your experience after 35 years, sir? Sir.
I don't think we need to change the mindset of the law school. We need to change our mindset. We need to change the mindset, the way we think about mediation, the way the courts think about mediation, the way the lawyers think about mediation, and the way the litigants think about mediation. I'd earlier, when I spoke about government, I was focused on Mr. Sanyal because we were talking yesterday. But I must say, with an apology to Mr. Gauba, that, sir, the same points I would like to make regarding government to you as well. And I think really, you know, we can talk piecemeal, complaint-wise. We can say, oh, this is not right, that is not right, it's not this, etc. That's why I started my presentation by saying we must look broad and we must look for structural reform and we must look for concerted action. It's only when we apply that kind of thinking that we start getting somewhere. The map then unfolds. And then these things that we are talking about just become mere obstacles in the path.
Thank you, sir. So my next question is for Justice Sandeep Mehta. Sir, in your experience, do you feel the lower judiciary is still hesitant to refer the matter to mediation, and the mindset also needs to be changed, as by the time the matter is referred to mediation by the Supreme Court, the litigant has already spent around 10-15 years in court?
So first of all, I'll correct you. Now it's no longer to be called lower judiciary. It is the district judiciary. That is the first change in mindset which is required. Secondly, so far as you are saying lack of reference, you may be mistaken, because now it is a mandate that the magistrates and the judicial magistrates and the municipal magistrates, they are under a mandate to refer the maximum number of matters for mediation. Issue is why it doesn't succeed. Those issues I have already touched in my experience sharing session. So probably we need to start there. The mindset of lawyers has to change. The training has to take a new kind of initiative as to now why we are stuck at that particular point of time or position that the mediation is only working, and that too partially at the district court lawyer in matrimonial disputes. Its success rate is much more, say, in Delhi High Court or even in Supreme Court. So we need to explore and introspect why the same result is not being achieved when the case is at the trial stage. It will be much more fruitful if you can get a resolution at the initial stage, because the parties would be younger, the resolution would not have cost them much. So probably with that mindset, if it can be changed, the success rates of mediations in the trial courts may improve. Thank you.
Thank you, sir. So may I have the next question from Justice Vikram Nath? I am not going to get this opportunity again. It is who is going to ask me all the questions in court. So first, sir, you recently launched a pilot project called Community Mediation towards a litigation-free rural India in Baghpat. And do you feel it's the way forward for strengthening grassroots dispute resolution through dialogue-based mechanisms?
Yes, definitely. Everything starts with initiative, small, drop by drop, you create an ocean. So that way we started litigation-free villages.
Yes,
And
sir.
Baghpat, we identified 6 villages, and we trained the people from the village only, the community people, as it's called, community mediators, so that they understand the logistics, the dynamics, the politics of the village, and they can easily resort to. So those 6 villages have been declared litigation-free. We are in the second phase of identifying 12 more villages in Baghpat.
Yes, sir.
And gradually we intend to spread it all across the country, so that if the villages are litigation-free, then a lot of litigation coming in courts will definitely reduce substantially. I think it's a good this thing.
Thank
It
you,
will
sir.
give good results also. Yes.
Thank you, sir. Now this for Mr. Shriram Panchu. Sir, as per your vast experience, what all should be done by all the stakeholders? Since you are the most important person, you have been doing it for 35 years. So what all should be done by all the stakeholders, that is the government, judiciary, bar, so that India could become a global hub like a Singapore for mediation in next 10 years?
You know, let's not compare India with Singapore. Singapore is a small city-state which is focused on being a commercial hub in the region. We are a far, far bigger nation. Our problems are far more diverse. And we have to look at mediation in multiple ways. We need to look at commercial conflict and see, you know, what do we devise for that. We need to look at the way law firms operate and to see, you know, how do you financially incentivize lawyers to settle in big cases. You need to see how to free up government from the constraints they have of officers who negotiate settlements. They're scared of punitive action, and therefore how to give them immunity. We need to see how to make the court system, court annex mediation system, how to improve it in terms of paying more and sending better cases. But most of all, we need to encourage private, professional mediation across the board. That is really the answer.
Thank you, sir. Though we had a lot of questions, but we are slightly running behind the schedule. I may now request Mr. R. Venkatamani, London Attorney General for India. He also likes to share his views on the subject. Sir.
It's good we began the conference with the subject of mediation. Any other subject to qualify as important for a discussion would have probably receded into insignificance. I congratulate Vikas Singh and the SCBA for starting with this wonderful idea. If you're talking of Viksit Bharat, I should probably talk about mediation Bharat. So how do you go about it? And I don't propose to talk at great length, but the transformative potential of first conferences like this, and secondly, the idea of a mediation like this, I think we need to unleash the transformative potential in as many ways as possible. And that can happen only if you have structural changes. Panchu, with all his experience, has emphasized repeatedly about structural changes. A couple of personal experiences. So I share my views with Mukul to a large extent. But then in the last couple of years, when I took over, and looking at what my predecessors have done, the handling government litigation, we thought we should have a national litigation management policy. It took almost about a year and a half or two before it could come to some shape. It has now come to some shape. And I'm sure once the litigation policy is put into practice, we'll find that it begins to put the adversarial dimensions of our court systems to recede to the background. How do we therefore accomplish the adversarial dimensions of our justice system receding to the background? That can happen only if we're able to focus on what I call the transformative potential of mediation. Now, a couple of things I did after the litigation management policy was conceived. Then we went into ministry after ministry, department after department, as to how to use a mediation as an idea which every head of a department can probably internalize. Now, within private parties, managing the loss or gain, financial otherwise, is where they are accountable to themselves. But in a different context, government, it's an entirely different game. The process of institutions themselves. I think sooner or later, we'll be able to achieve that task too. But in order to do that, the mediation council is yet to be fully, put into position. But I thought in order to get it done, where will the persuasions come from? It must come from we the people of India. And the bar, the Supreme Court bar must play a big role. Therefore, we conceived the first national conference on mediation, and that is a huge success. The next idea was, if the bar can come together as a national mediation association. We have worked on that. Sooner or probably in another weeks or time, we'll have a trust which will register the National Mediation Association, and this association will act as a fillip for the Mediation Council of India to start working. I've already set in motion few internal dialogues inside. I'm sure probably not beyond the December of this year, the National Mediation Council will start its work. And once it starts its work, we'll see how National Mediation Association at the private level and National Council of Mediation at the institution level will merge and accomplish all the tasks we are talking about. Therefore, I think finally I just want to share, when you say people are very reluctant, the government to settle mediation, as far as pensions are concerned, the defense ministry is the most litigated area. And I found when I took over, not less than 7,000 to 10,000 pension cases were coming almost on a yearly basis. Thanks to the credit of the armed forces and the defense ministry, we did not go for litigation in about 3,000 to 5,000 cases, pensions which were settled, which were simply settled because they came to an understanding. And therefore, there is a possibility, the possibility that you can settle happens only when inside the ability to manage the accountability principle can be comfortably handled. So why can't we move towards all that? But finally, I want to say that SCBA is not only a Supreme Court Bar Association, it's a Supreme National Bar Association. So let us work towards what I call that transformative potential of law in as many fields as possible. And mediation is going to be one of the wonderful things to happen in our country. And thanks once again for calling me to share my views. Thank you.
Thank you, sir. Thank you, sir, for giving your valuable insights. You talked actually about the mediation association to make the mediation more meaningful, and how actually the government in the defense ministry did not go for litigation with regard to pensioners. So we actually got to know the view of the government also regarding this. With this, may I now request Pragya to carry on with the proceedings.
Thank you, sir. Thank you, all the panelists. Now I request Mr. Mukesh Singh, Member Executive SCBA, to come forward and felicitate Honorable Mr. Justice Vikram Nath, Judge Supreme Court of India. Justice Sandeep Mehta, sir, Judge Supreme Court of India. Now I request Mr. Gaurav Kumar to felicitate Mr. Mukul Rohatgi, sir, Senior Advocate, Supreme Court of India. Now I request Mr. Rohit Bus to come and felicitate Mr. Shriram Bhatt, sir, Senior Advocate. Thank you all the panelists on the dais. We request everyone to join for tea. There will be a short tea break. We request everyone to join for tea.
So our first session is over. We are extremely thankful to all the panelists. We just have a group photograph. Yes, yes. For a very insightful first session. Thank you, sir. Yes, sir.
क्या आपको पता है आपका और हमारा बहुत ही लंबा और करीबी रिश्ता है। उस चट्टान में जो आप
assemble as quickly as possible.
आपका और हमारा बहुत ही लंबा और करीबी रिश्ता है। हम उस चटकारे में जो आप अपने दोस्तों के साथ लेते हैं, उस दराज में जिसमें छिपा है माँ के राजमा चावल का राज, उन सांसों में जो आपके पलों को महकाते हैं।
Requesting everyone to kindly come back to the hall in next 10 minutes as we have got very distinguished speakers in the next session.
ठंडी हवाओं से राहत बनकर, कभी मुंह में पिघलती चाहत बनकर आपका दिल चीखते रहे। तो अगली बार आपको कोई चीज पसंद आ जाए तो उसे पलट के देखिएगा, जरूर हमारा नाम दिख जाएगा। क्या आपको पता है आपका और हमारा बहुत ही लंबा और करीबी रिश्ता है। हम उस चटकारे में हैं जो आप अपने दोस्तों के साथ लेते हैं, उस दराज में जिसमें छिपा है माँ के राजमा चावल का राज, उन सांसों में है जो आपके पलों को महकाते हैं। कभी आपके साथ एक अच्छी आदत बनकर, कभी ठंडी हवाओं से राहत बनकर, कभी मुंह में पिघलती चाहत बनकर, आपका दिल जीतते रहे। तो अगली बार आपको कोई चीज पसंद आ जाए तो उसे पलट के देखिएगा, जरूर हमारा नाम दिख जाएगा। क्या आपको पता है, आपका और हमारा बहुत ही लंबा और करीबी रिश्ता है। हम उस चटकारे में हैं जो आप अपने दोस्तों के साथ लेते हैं, उस दराज में है जिसमें छिपा है माँ के राजमा चावल का राज, उन सांसों में है जो आपके पलों को महकाते हैं। कभी आपके साथ, कभी ठंडी हवाओं से राहत बनकर, कभी मुंह में पिघलती चाहत बनकर आपका दिल जीतते रहे। तो अगली बार आपको कोई चीज पसंद आ जाए तो उसे पलट के देखिएगा, जरूर हमारा नाम दिख जाएगा। क्या आपको पता है, आपका और हमारा बहुत ही लंबा और करीबी रिश्ता है। हम उस चटकारे में हैं जो आप अपने दोस्तों के साथ लेते हैं, उस दराज में है जिसमें छिपा है माँ के राजमा चावल का राज, उन सांसों में है जो आपके पलों को महकाते हैं।
Check, test. Check, hey, check 1 2, testing, check.
जो आप अपने दोस्तों के साथ लेते हैं,
Hello, check 1.
उस दराज में है जिसमें छिपा
Check, test, check.
चावल का राज, उन सांसों में है जो आपके पलों को महकाते हैं।
Check. 1 2 3, 1 2 3, check.
कभी आपके साथ
Arun, on mic.
कभी ठंडी हवाओं से राहत बनकर,
Check. Hey, check, check, check.
कभी मुंह में पिघलती चाहत बनकर आपका दिल चीखते रहे। तो अगली बार आपको कोई चीज पसंद आ जाए तो उसे पलट के देखिएगा, जरूर हमारा नाम दिख जाएगा।
Check.
क्या आपको पता है आपका और हमारा बहुत ही लंबा और करीबी रिश्ता है। हम उस चटकारे में हैं जो आप अपने दोस्तों के साथ लेते हैं, उस दराज में है जिसमें छिपा है माँ के राजमा चावल का राज, उन सांसों में है जो आपके पलों को महकाते हैं। कभी आपके साथ एक अच्छी आदत बनकर, कभी ठंडी हवाओं से
Check, check.
राहत
Dust. Check. 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 On the mic. Check, check, check.
चाहत बनकर आपका दिल चीखते रहे। तो अगली बार आपको कोई चीज पसंद आ जाए तो उसे पलट के देखिएगा, जरूर हमारा
Check.
नाम दिख
On to
जाएगा।
check.
क्या आपको पता है आपका और हमारा बहुत ही लंबा और करीबी रिश्ता है। हम उस चटकारे में हैं जो आप अपने दोस्तों के साथ लेते हैं, उस दराज में है जिसमें छिपा है माँ के राजमा चावल का राज, उन सांसों में है जो आपके पलों को महकाते हैं।
Check, check, check. Test on the mic. Check, check.
कभी आपके साथ एक अच्छी आदत बनकर, कभी ठंडी हवाओं से राहत बनकर, कभी मुंह में पिघलती चाहत बनकर आपका दिल चीखते रहे। तो अगली बार आपको कोई चीज पसंद आ जाए तो उसे पलट के देखिएगा, जरूर हमारा नाम दिख जाएगा। क्या आपको पता है आपका और हमारा बहुत ही लंबा और करीबी रिश्ता है। हम उस चटकारे में हैं जो आप अपने दोस्तों के साथ लेते हैं, उस दराज में है जिसमें छिपा है माँ के राजमा चावल का राज, उन सांसों में है जो आपके पलों को महकाते हैं। कभी आपके साथ एक अच्छी आदत बनकर, कभी ठंडी हवाओं से राहत बनकर, कभी मुंह में पिघलती चाहत बनकर आपका दिल चीखते रहे। तो अगली बार आपको कोई चीज पसंद आ जाए तो उसे पलट के देखिएगा, जरूर हमारा नाम दिख जाएगा।
Check, 1, 2. Hello. Hello. Hey, check, check, check. Check. Testing 1. Check 2. Hello, hello. Check, check, check 1, 2. Hello, hello, hello. Hello, hello. Check, check, check. Check, check. Hello, hello. check. Hello, hello, hello. Check, check, check. Hello, test. Check, check. Hey, hey, check. Hello, hello, hello. Check, check, check. 1, 2. Hey, hello, hello. Check, check. Hello. Check, check, check. Check. Check, check, check. 1, 2. Hello. 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 Check, check. Check, testing, testing. 1, 2, 2. Check, check. Hello. Check. Hey, 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 hey. Check, check, check. Hey, check, check.
Good morning to all of you. Kindly be seated, please. We are starting next session. Good morning to all of you. Welcome to the second session, From Pendency to Prompt Justice, Rethinking Justice Delivery in Indian Courts. There is a constant criticism in the judiciary relating to pendency of cases. Recently, there has been a strong criticism from the executive regarding the same. An important point to note is there is a significant low judge count in India. In addition to that, any given point in time, there is a large number of unfilled vacancies. All the judges in India work extremely hard. They sit in the court for 5-6 hours, spend over 7-8 hours reading the files, and over 3-4 hours writing judgments. Catching up on developments in the law, perform their administrative functions. On the other hand, courts have vacations. This is criticized by everyone. To address this continuous issue, it is my privilege to invite to the dais very legislative dignitaries who have done extensive work on the subject. May I now invite Honorable Mrs. Justice B.B. Nagaratna, Judge Supreme Court of India, Honorable Mr. Justice M.M. Sundaresh, Judge Supreme Court of India, Honorable Mr. Justice Deepankar Datta, Judge Supreme Court of India, Honorable Mr. Justice N. Koteshwar Singh, Judge Supreme Court of India, Honorable Mr. Justice Manmohan, Judge Supreme Court of India, and Mr. Sanjeev Sanyal. Kindly be seated, Miller. We start this session with opening remarks by Mr. Sanjeev Sanyal. Mr. Sanyal is an Indian economist and a member of the Economic Advisory Council to the Prime Minister of India. He has helped prepare 6 editions of the Economic Survey of India and has represented India at G7 and OECD meetings. Mr. Sanyal, kindly.
Honorable Justice Nagaratna, Honorable Justice Sundaresh, Honorable Justice Datta, Honorable Justice Singh, Honorable Justice Manmohan, ladies and gentlemen, let me begin by thanking the Supreme Court Bar Council for giving me this opportunity to come and speak to you today on a very important topic. And what I'm going to do is that I'm going to elicit your support for 3 things that I hope you will agree need to be done. The first thing that I am going to argue is that we need to have a serious discussion about massive investment into our legal infrastructure. This is a point I've been making, by the way, for the last 20-odd years. Now, I'm going to shift here and say that, look, instead of thinking about the legal system as a profession, for a moment think about it as critical infrastructure, like the electricity grid. If you want to expand the system, you have to invest into it. So, the question then arises is how much do we need to invest in? So go work it backwards. Now, I have actually written about this for 20-odd years. My very first book, Indian Renaissance, published in 2007, I had half a chapter on this issue, and where I made the case that the single biggest infrastructure that we need to invest in, where the highest rates of return would be actually to expand the legal system and to invest into it. And at that time, I had done an estimate with a very well-known economist, Vijay Kelkar, some of you may have heard his name. At that time, that a one-time investment of about 0.2% of GDP to expand the hard infrastructure of the legal system, and then 0.05% every year in recurring cost, would take our legal system into a completely different modernized orbit. Now, I don't have good estimates of how much it would cost today. So I need your help, both of those on the stage and off it, to create what would be a good estimate of how much infrastructure investment, and here I'm talking about the soft infrastructure as well. How much do we actually need to invest into it? My guess is that it would not be off the charts. After all, we invest 50, 60,000 crores kind of money into, say, a single airport. Upgrading the entire legal system of the country, how much would we need? Do we need 10,000 crores? 20,000 crores? I don't know. Okay. I mean, I don't know how much that is. Even if it is, let's say, 5 billion, it's not off the charts amount of money for a country that has $4.2 trillion economy. So let's have that debate. It is not to have a maximalist view on the matter, but to something that is a reasonable estimate. But once we have that, we can work backwards to how much time it can be. Because if you have a hard number, it is radically easier for the government to begin to work out how to spend it, what are the things, and why we are spending it. Also to explain it to Parliament, which has to pass these budgets. As an aside, not related to this issue, I do hope that some of that money will be used to build some iconic buildings. We have now been free for 80 odd years, and frankly, whatever criticism we may have of the British, they did build some amazing courts around the country. I think modern India needs to build some iconic buildings, and some of this money should be used to do that. I think that has value in its own right, but that's a different debate. So this is one. I need your help to come up with a good estimate. The second thing I need your help with is to think about process reforms in the legal system. So what is process reform? You see, typically in government, and this is something we have done a lot in government, we have done a lot of process reform. Now, usually when you think of reforms in government, you think of large structural reforms, which is GST introduction, insolvency and bankruptcy, inflation targeting, big structural changes. But in fact, most of the reform the government actually has done in the last decade are small process reforms. They're not the cool reforms that are on the front page. They're mostly boring things like rule number 43B, subsection D, 3 words have to be changed. But let me tell you, as somebody who's been part of that process, and I have been personally involved in dozens of these reforms, the amount of bang for the buck you get for these, and typically they are not partisan issues, political issues, they are pure efficiency issues. We can make that system move significantly faster. So let me give you some examples of such reforms that I have done, and Mr. Gauba is here, who has been my friend, mentor, and guide in doing some of them. Some of you may remember that back in 2020, you needed actually 77 approvals to fly a drone in this country. Effectively, India's regulatory mechanism treated a drone as an aircraft. So if it basically needed almost the same number of OKs as would needed to fly a Boeing. Over several weeks, I and a young officer called Manhar, we actually simplified this using just common sense. And we reduced that number down to 4. With several iterations, it's now, I think, drifted back to 7, but still, 77 to 7. Now, what has happened as a result of this is that for the first time, we began to have our indigenous drone ecosystem and manufacturing sector. If we had continued with that 77 rule system, we would still have drones in this country, except there would be Chinese drones that would be being flown essentially illegally by the Shadiwala photography guys. But our own indigenous drone system would never have arisen. But now we have the third largest drone building ecosystem in the country because we reduced these number of rules. Now, has anything terrible happened as a result of this reduction from 77 to 4 or 7? No. Can there be misuse of this simplification? Yes. But I have so far held off many attempts to add back these rules by making a very simple common sense point. no matter what damage a single drone or how bad a single drone may be, for a 21st century country, the bigger national security issue is not to have a drone industry at all. And that I hope you can see from the war that is happening in Ukraine and now in the Persian Gulf. The greater danger was that we didn't have a drone industry. So we made that trade-off, and I think that is an example of where we had something that would 100% not have allowed that sector to evolve to something where we have dramatically created another one. Let me give you another example. Voluntary closure of companies, something that many of you actually deal with. Now, in any country, there is ease of entry, of course, but we also need ease of exit. Now, usually debates go on about insolvency and bankruptcy, but in fact, 90% of companies shut down in any country are actually shut down entirely voluntarily. Because somebody has grown old, his kids don't want to do the business, or there's a special purpose vehicle, whatever the reason, voluntarily companies are shut down. There are two ways of doing this. One is through IBC, which is the rarer route. Most of it is done under company law. Till about 3 years ago, a company where nobody is disputing the fact that it's not like it has some encumbrance of some sort. Everybody agrees this should be shut down. The process used to take an average 500 days to do this, shut down a company. Some of them would take 7-8 years to shut down. And remember, keeping a company going means you have to do all the paperwork for it. Huge burden of ease of doing business. So about 3-4 years ago, in fact, in the last days of when I was still in Prime Minister, in the Finance Ministry, I looked into the process of doing how to shut down a company. And I then found that 80% of the problem was in 20% of the process. And I proposed some changes to that. I made a presentation of how the process can be changed to the Honorable Prime Minister firstly, and then to the Honorable Finance Minister. They said, okay, give it a shot. So I went to the Ministry of Corporate Affairs and made a presentation to the bureaucracy there. Everybody was angry with me after that. But I thankfully managed to persuade enough of them to make the change, and I had, let me say, the support of Mr. Gauba, who was then the Cabinet Secretary, and we made the change. Net result is we created a website called CPACE. What happens is, if you want to shut down a company, you put in your application into it. The system itself goes to the nodal officers to ask for NOCs. If NOCs are not given within no objection is there, the system itself generates an NOC and then sends a list to the register of companies for putting up the advertisement in the newspaper. All of this is automated. Now look at what has happened in the last 2 years as a result of this change. What used to take 500 days on a routine matter now takes just 60 days. It's an 88% reduction in the time taken for a voluntary closure of companies. Many of you may have benefited from this already. Another example I'm going to give before I stop on this and move on to the next subject is something I'm working on right now. I don't know how many of you have heard of a body called the Investor Education and Protection Fund, IEPFA. Several of you have. And as many of you will be aware, its record on educating and protecting investors is somewhat checkered. So for those who don't know what it is where unclaimed shares go to die. So if you happen to have an aunt who has left you 50 crores worth of some shares and you're celebrating because you've just inherited it, please don't, because the shares are going to be sent to IEPFA, and the high likelihood is that you will join your aunt in the afterlife before those shares are given to you. So I took up this matter. I wrote actually a newspaper article about it. And of course, many people again got very angry with me for doing that. But then, in the last 1 year, I sat down and actually went through the process. Here is what I found of this process. So hear me out, because you will see the parallels with here what we are discussing. I found that in order to get your unclaimed shares out of the IEPFA, there were 25 separate steps. And if you made a mistake or something happened on the 24th step, you had to go back to step 1. It was even worse than that. These 25 steps were spread over 3 separate websites. There was one website for getting approvals, for getting your shares back. Another separate website for getting your dividends back. And after you had got your approvals, you had to go to a third website in order to apply to get the actual transfer. None of these 3 spoke to each other. Now, at every step there were errors. Any error means you go back to step 1. So the net result is that IEPFA on a good day would manage to do, in a good month, would manage to do between 400 to 2,000 cases a year. And do remember that new cases are always appearing. So by March of last year, 2025, this fund had accumulated 1 lakh crores worth of unclaimed shares, plus 8,000 crores of unclaimed dividends. And the rate at which it was giving them back was no more than 2,000 to 3,000 crores a year, so it was actually growing in size. So I sat down, went through this whole thing step by step, where the blockages were and so on. Very excruciating thing. But I then managed to do two or three things. First of all, by September last year, I unified all the 3 websites. So they talk to each other, you only have to make sure. So there is no chance of a manual error shifting back and forth. And that process went from 25 to 15 steps. I'm now in the process of reducing it below 10. Look at what has happened as a result of this. This data, by the way, I'm making it public for the first time. What used to, the IEPFA used to process between 400 and 2,000 cases every year. In December last year, it processed 11,000 cases. Same group of people, same laws, same claims, more than 10 times increase in processing capability. So why I'm making this thing, and this is why I need your help. If it is possible to create a small task force and perhaps in an experimental basis, take up certain processes of the judicial system and try and map it step by step. This is very crucial. And try and begin fixing it. Not every change will work in the first iteration. Sometimes there'll be unintended consequences. But after a few iterations, let me tell you, the system will work. And now that I have done over 100 of such changes, let me tell you that their 80-20 rule applies. You will only need to clearly change 20% of the process. You will get 80% of the improvement. It is not impossible to do. Prepare for dramatic improvements in efficiency. So, if you're willing, sir and madam, if you give me an opportunity to do that, give me a small team, let me do this. And experiment it in one place where you don't think anything bad will happen. And let me demonstrate to you how much more efficient you get if you apply industrial process management on judicial processes. We have done that, as I said, in the government with very good results. As I told you, very often, the bureaucracy initially when I began doing this got quite annoyed with me. Thankfully, thanks to people like Mr. Gauba, I managed to do it. But today, they are my allies. I routinely have departments, joint secretaries, secretaries to Government of India coming to me with a problem, and I attempt to solve them. And I'm telling you, this has radical benefits. Now, the third one is another madcap idea of mine, but I think it has some legs. So please help me see if it can be done, which is to try and create a 21st century single source of truth for what our laws, rules, and regulations are. We have made some sort of an attempt at this, And I know Justice Manmohan has pushed for this as well, the India Code effort. Now, my idea is to take it one step forward. So what is the idea? The idea is basically a very simple one. You tell the citizen that the ignorance of the law is not any kind of defense. Fair enough. That is the basis of our judicial legal system. But does the citizen have a fair chance of finding out what the law is? What happens today is that the regulations, rules, etc. are there in all manner of circulars, laws, etc. And actually, I have no fair chance of finding out what it is I'm supposed to be doing. In fact, when I began writing about this, I actually used the example of the fact that the Delhi police had not even put up its traffic rules and traffic fines on its website. So I used that as an example last year when I wrote about it. Thankfully, they have put it up as a result of that article. But I can tell you, Bengaluru, for example, I don't think has its traffic rules on its website. So what is it that I'm supposed to be doing? So my argument here is, and I want this thing to have legislative backing, because unless the new India Code has some sort of a law backing it, there will be no form of enforceability. What is the idea? The first idea is that whatever the rule, regulation, law is that is on that website, that single source of truth, is the law of the land until it is changed. So some form of enforceability. If, for example, it says that I should do Bharatnatyam in order to get a driver's license, then till you have changed that law, I did Bharatnatyam, you have to give me my driver's license. 2, it should be time-stamped. This is critical because then I can create a history. So that website will be like a Wikipedia. You can go to its history. I should be able to say that at 9 o'clock on 29th of December 2024, what were the rules, regulations, and laws that applied to me? You may have changed that law at 9:30, but at 9 o'clock, what was the rule that applied to me? And the third important thing, before I stop, is that the law should be presented as a whole as it exists today, not as a series of circulars. And we have actually done a very good experiment on this in the Reserve Bank of India, which has been a super success. So the Reserve Bank, like any other government institutions, had a large number of circulars, something like 9,400 circulars, rules, regulations, etc. In November last year, it reduced that by removing almost 60% of them. The remaining 3,800 of them were subsumed into 240 master circulars, which are done by subject. It removed all internal contradictions. Everybody knows what the rules are. And the experiment has dramatically lowered the amount of disputes, confusion, harassment, any other thing that used to happen. So essentially, this kind of thing really works. But again, I have written, by the way, a draft kind of law. I'm not a great lawyer, so I have done it with a lawyer friend of mine, but who knows whether what I've written is sensible or not. I've given several of you copies. I can share some more with you. But basically, the idea is that such a law, if it's put in place, then allows a single source of truth for all rules, regulations, and laws. I would argue this is a very cheap thing to do. It's very doable. And the benefits to the society, benefits to the legal system, but also even benefits to the bureaucracy of knowing what the rules it is as a society to change. Remember here, I'm not changing the rules, the essence of the rules. I'm merely saying, tell me what the rules are. Thank you very much, ladies and gentlemen.
Thank you, Mr. Sanyal, for sharing your ideas. Now our next speaker, Honorable Mrs. Justice B.V. Nagratna. Justice Nagratna is a judge of Supreme Court of India, elevated on August 31st, 2021, and is in line to become India's first woman Chief Justice in 2027. Known for her expertise in constitutional and commercial law, She previously served at the Karnataka High Court and is recognized for her firm stance on judicial independence. May I request, ma'am, to share your thought?
Namaskar and a very good afternoon to everybody. My esteemed colleagues of the Supreme Court on the dais and off the dais, Honorable Chief Justices and judges from various high courts, learned panelists, Mr. Sanyal, Mr. Vikas Singh, President of SCBA, and his office bearers, former Chief Justice of India, Sri Gawai, learned senior advocates and members of the bar, members of the media, ladies and gentlemen. I'm happy that this conference is happening in my hometown, Bangalore or Bengaluru. Just as we had Bengaluru principles with regard to the conduct of judges, I'm sure that there would be some reforms which would come out of this first conference in Bengaluru. Therefore, my first submission in response to what Mr. Sanyal has said is, I would say from my conclusion, right at the first, that is, let this conference give the proposal or an idea of having a Judicial Reforms Commission to reduce pendency. And this Reforms Commission must have membership not only from the judiciary of the Supreme Court, the High Court, as well as the district judiciary, but also have members from the bar, learned Attorney General, learned Solicitor General, and also from the certain members representing the bar from the institutional level, like such as the bar president and from the government side. This is my first idea. Why do I say this? The reason is, I will start from what I have said in my conclusion, and that is symptomatic of what is happening in our system. That is, from the point of view of various stakeholders. A litigant gains from status quo to prolong proceedings. And a lawyer or an advocate loves adjournments and postponement because he benefits from per appearance and extended timelines. A government department reduces bureaucratic risk by appealing rather than accepting defeat. A judge, and particularly a trial judge, is always acting with caution because he is confronted with appellate reversal, and therefore he prefers procedural caution rather than having an aggressive docket control. Each of these decisions is individually rational, but how does it help the system? It is only leading to systemic delay. In order to break this equilibrium, what we require is institutional interventions, and that is what I said by this Judicial Commission to reduce pendency, rather than merely exhorting better conduct from judges, procedural timelines to be adhered to, exhorting advocates not to take adjournments, asking the government to reduce litigation, and generally having the courts to function on all days 24/7 and asking the judges not to take leave. That is not the answer to the real problem in our system. Therefore, while I congratulate Mr. Vikas Singh and the office bearers for having this topic from pendency to prompt justice, rethinking justice delivery in Indian courts, I must at the outset say that how important the judiciary is in this country. It is not merely another branch of the state, but it is an organ which guarantees that rule of law prevails over rule of force. But the ability of the courts to perform is not only the de jure authority of the judges and the courts, but in fact, the de facto capacity. When I come to de facto capacity, I would say the inflow of cases is so great compared to the outflow of cases, that is the disposal, that we are facing a massive backlog in the Indian courts system today. I need not go into the statistics at the district court level, the High Court level and the Supreme Court level, for you all know about it. But my approach is as to what is really necessary for the stakeholders to do. Secondly, I would like to concentrate on the expression pendency. What is pendency? What are the flaws in the system? And how does pendency happen? For instance, a case filed today is pending tomorrow. A case filed today adds to the statistics. But what is the form of that case filed today? Many a times the cases are filed with defects. For years, for weeks, for months, the case does not come onto the dais of the judge, and they are taken note of for the purpose of statistics. Why should a defective case be given a number at all? Why should it be taken into statistics? Therefore, my submission is that cases which are defective should not be added to the statistics of pendency at all. Secondly, what adds to this pendency is the next stage after the matter reaches the court, when a notice is issued or it is dismissed or adjourned. It is at that stage that case must be added to the pendency or to the docket statistics. The another reason for delay in the system is when notices are issued by the court, how the litigants, respondent seek every trick in the game to evade notice, and how many years are spent in service of notice. Therefore, we need reforms as to how notices must be served, not just through the usual RPAD system, we say the postal system, but or at the end we say Order 5, Rule 20, paper publication. It should be by other ways such as WhatsApp methods or through the electronic methods, which should be introduced and applied in the courts. Then the next point of delay is at the time of filing responses. We have Order 8, Rule 1. The trial court is very strict and he will say no written statement filed. But what does the High Court say when it comes in revision? There is failure of natural justice, and on imposition of cost, written statement is allowed to be filed. How many advocates file counter affidavits and statement of objections on time, even though the writ proceeding rule says it should be done within a period of time, and the Supreme Court's rules also say that. These are all, again, additions to the delay. Every attempt is made by the defendants to prolong, to avoid any adverse order. The tactics are in the trial court, frequent adjournments on one ground or the other. For example, a simple eviction suit. What does the defendant tell the advocate? Sir or madam, please ensure that the litigation is prolonged, and I want to stay by paying 500 rupees to in this house as long as possible. As a result, frequent adjournments on one ground or the other, witnesses not being called for deposition, documents not being produced on time, and for other reasons. If the trial court is very strict on this and says adhere to procedure, then what does the High Court say? There is violation of the principles of natural justice, there is no opportunity, there is stay of the proceedings. These are the systemic delays in the system as such. Of course, I must also say, judges take long time to write orders, to dispose of cases while writing judgments, but there is a dual role of the judges there. Morning till evening, they are sitting in the court, adjudicating, conducting trial, hearing cases. But it is only after court hours, if the judgments are not dictated in open court, that they have time to dictate the judgments in the evening hours, late into the night, weekends, summer vacation, Dasara vacation, Holy vacation, Christmas vacation are all used by judges to write judgments and not to take only LTCs and go here and there. So therefore, this is the dual role of judges, both inside the court, and it is an open court, mind you, and after court hours. After the trial court judge passes an order, within 15 days, as the CPC says, what happens? Matter goes in revision, matter goes in appeal, and there another saga of delay starts. The High Court or the Revisional Court will say, yes, stay, despite Order 41, Rule 5, conditional order being made, blanket stay. Then vacation of stay. Then instead of vacating stay, why we'll hear the main matter, the court will say, and it goes on and on. These are some of the, aspects of delay which I am highlighting, because all of us are stakeholders and we are interested in reducing pendency. So therefore, I have certain suggestions to make, but before that, I want to give one more perspective from the government perspective. Now, the government occupies a dual role. As Mr. Sanyal said, they are responsible for providing infrastructure, for providing reforms, etc. But the government is also the biggest litigator, whether it is at the central level or at the state level. The state is expected actually to litigate with restraint and be a model litigator, but that does not happen. It goes on litigating until the end. The government is not only a mere participant in litigation, it is also the largest single generator of litigation. If there is proper training of officers on the administrative side to hear both sides, to write a proper order, follow the principles of administrative law, why will there be erroneous orders? Many a time it is only on these basis that we have 64 lakh cases pending in the High Court, and how many of those arise in writ petitions and writ appeals from administrative action. The problem is not merely in the number of disputes that originate in the government decision making, but the behavior of the government after those disputes begin. A government officer who settles a dispute will face audit objections, vigilance bodies will go after him, or his political superiors will question him. Any compromise will be interpreted as an admission of administrative failure. By contrast, an officer who files an appeal or a revision rarely faces this criticism. So what does he do? He will go by caution. An appeal signals diligence, whereas a decision not to file an appeal will invite vigilance inquiries. It demonstrates that every available legal remedy must be pursued. The result is predictable. Appeals become routine rather than rare. Cases that should end in lower courts continue through successive layers up to Supreme Court. The behavior transfers the cost of bureaucratic caution into the judicial system. See, we are carrying, in fact, the burden of all this, evasiveness of the government into the judicial system. This is particularly seen in service litigation and taxation litigation. The pattern produces a paradox. The government publicly expresses concern about judicial backlog while simultaneously feeding that backlog through relentless litigation. The state becomes both the complainant and the cause. And mind you, the state's responsibility does not end there. The capacity of court itself depends on public investment. Judges must be appointed on time. Courtrooms must be built. Staff must be recruited. Technology must be deployed to manage filings and records. And these decisions lie squarely within the domain of governmental policy. Therefore, I suggested that let there be an inter-institutional dialogue by having a judicial reforms commission for lowering the pendency in court. Yet, judicial infrastructure rarely receives sustained political attention. Expanding courts does not generate the same immediate visibility as constructing highways or launching welfare programs. The political incentives is weak when it comes to judicial infrastructure investment. Therefore, the percentage allotted is also very less. The consequence is stagnation. The volume of dispute grows with population, economic activity, and regulatory expansion, but the institutional capacity of courts grows slowly. Therefore, judicial pendency cannot be understood solely as a problem internal to courts. It is also the product of governmental choices. The government therefore stands not only as a litigant within the system, but as the principal architect of systems congestion. Therefore, if I may take a few more minutes with the permission of my learned brothers, I have certain solutions. I don't like to only highlight problems. I would like to give certain solutions. From the perspective of the judges, 1, judicial case management. 2, limiting unnecessary adjournments, even if the judge is to be unpopular. 3, efficient use of court time. 4, writing clear and concise judgments. 5, adoption of technology. 6, prioritization of cases. 7, encouraging ADR. 8, judicial accountability. 9, specialized benches. 10, institutional leadership. From the perspective of the advocates, there must be discharge of professional responsibility. 2, ethical litigation practices. 3, efficient case preparation. 4, avoiding excessive procedural objections. 5, cooperation with case scheduling. 6, encouraging settlement. 7, responsible use of appeals. 8, adapting to technology. 9, continuous legal education. 10, role as officers of the court. From the perspective of the litigant, understanding the legal process with the help of the counsel, avoiding frivolous litigation in the form of revisions and appeals, cooperation with the legal counsel, openness to ADR, respect for court procedures, realistic expectations, use of online platforms, responsible use of appeals, public awareness and demand for reform, and access to legal aid. From the perspective of government, to formulate a practical and efficient litigation policy, filing of appeals and revision in appropriate cases within the period of limitation that is stipulated. Non-filing of appeals and revision should not result in audit objections, vigilance inquiries, or objections from political superiors. Training of officers who are in the regulatory bodies and in administration so that the disputes do not get generated. Take adequate and timely steps for providing funds for our infrastructure of courts, for deployment of technology, and generally for providing adequate facilities and amenities for all the stakeholders in the judicial system. Recommendations for appointment of judges should be acted upon on a timely basis, depending on the vacancy situation, and instead of the government acting selectively and after a long delay and much prodding. Therefore, my appeal to all the distinguished delegates here is that if you want something to come out of this Bangalore conference, please give positive suggestions to Mr. Vikas Singh so that he will be able to have a dialogue with Honorable the Chief Justice of India and possibly the senior judges of the Supreme Court and learned Attorney General also, so that there is something which comes out of this conference and not just for enjoying the ambience of this hotel and the city of Bengaluru. Thank you for your patience. Namaskar.
Thank you, ma'am, for sharing innovative thoughts. Now, I'll skip the introductions and request to Honorable Justice Sundaresh to share his thoughts.
Dignitaries on the dais, off the dais, including the former Chief Justice of India, Justice Gawai, my colleagues, senior advocate, and other lawyers. A good afternoon to everybody. My thanks to the President, Vice President, and his team for inviting me to address this August gathering. To talk about this topic would take at least a day. There are multiple issues involved. I would confine myself to the disposal of the criminal cases. Again, to talk about this, I need a couple of hours. Therefore, I'll just give a bird's eye view of the problem we are facing and where does it lie. A flourishing democracy requires a steady, continuous flow of civil cases, which shows the confidence in the system. On the contrary, the criminal cases are expected to reduce over the years. Civility and criminality are part of every human being, including us. What matters is the degree. There are two factors which are required for this: knowledge and character. Knowledge is something we acquire, character is something which is formed. Both are interlinked. What is the duty of a king has been explained thousands of years ago in Tirukkural. The saint says that the primary duty of a king is to create and sustain an orderly society. And how will he do? To take action against an individual who commits an offense. And what do we mean by an offense? What do we mean by a crime? It is nothing but a deviant behavior on the societal norms. You take action because it is against the norms of the society. While doing so, you make sure that that person is reformed, meaning thereby he comes back. So retribution and reformation are part of the system, which unfortunately we get given it a go by. We live on the colonial pangs. We have never done any research as to why a crime happens. Who does a crime? Does it have anything to do with a community, a caste, a religion, culture, belief, custom, tradition? No. Let me tell you, crimes happen for a reason. You would find particular type of crimes keep happening in the slums. You will find particular types of crime happen in the villages. What do we do? Nothing. You apply the same rule. Now, what is in store before us now? I will give the statistics. I do not wish to go in depth. Though we are actually in the process of finding out a solution, for which I should take the former Chief Justice of India who has come here. He is the one who constituted a committee going to this, and which is continued with much more focus by the present Chief Justice of India, Honorable Justice Suryakant. We have about 4 crore and 81 lakhs cases pending, roughly in all the courts. Of these 4 crore cases alone are pending in the trial court. So now I'm telling you this so that you will understand where does the problem lie. It's a trial court which creates a problem. We need to strengthen the basis. Maybe we have to cut down the tiers of scrutiny. We have to enhance the quality, increase the strength. That's a different issue. Of these 4 crore cases, about 3.50 cases are criminal cases. 3.50. Now, 3.25 cases are again pending at the trial stage. Now, which means only about 25 lakhs cases are at the appeal stage, revisional stage, High Court, Supreme Court. Of these cases, 2.5 crore cases, I'm saying crore, I'm in the terms of crores, 2.5 crore cases of 3.5 crore cases are the offenses punishable up to 7 years. Now, if you look at if you go through the statistics, these are all done by illiterate, poor persons coming from the bottom of the society. As I said, if on a honest introspection, if you and I are born in that place, we would be termed as a criminal. As a consequence, what happens is we create inheritance of crime. Grandfather does his, father does it, son does it. What will we do? If you are to address this, I believe we need to have a very radical approach. That approach is to give a chance to all the accused persons, give a chance to the victim to have a better participation, as we have now under the BNSS Section 360, which facilitates the participation. And for this, all the stakeholders will have to come around. I will only tell you, how does it help? We have plea bargaining, we have other enactments, Probation of Offenders Act, termination of proceeding, initiation of 528, which is 482 of the Code of Criminal Procedure, compounding. What we have done to deal with the problem is that initially we did a pilot project in one of the High Court. We requested the Chief Justice to have a couple of dedicated benches. Then we had an interaction with the judges who were entering the benches. We told them to have an interaction with the trial court judges. Ask them to give due intimation to the public prosecutors, the counsel for appearing for the accused person vis-a-vis the victims. You won't believe it, within 40 working days, they were able to clear 25,000 trial cases with the approval of the victims. These are all petty offenses. Then we have decided to take it to the trial courts so that they themselves can deal with it. We had an extensive discussion with the Honorable Chief Justice of India, who said it will be more ideal if you involve the trial courts, which appears to be the correct approach. Now we are in the process of interacting with them more and more, and we also touch base the other stakeholders, state government, to come up with a particular government order, facilitating a participation of the victim, accused persons, having a cutoff with respect to pendency, let's say 3 years and above, so that the scores of these cases can be cleared. Now, why should we? Now, we adopt this practice because it actually helps everybody. It helps a victim. In many cases, those cases which were disposed by the dedicated benches, all the victims came and said, "We don't want to pursue because you kept us away by forcing on us to stand away behind, not allowing us to have participation in the criminal case because you think it's an offense against the society. We don't want to precipitate things. We want to move on. So from the victim points of view, victim will have clarity. It will clear unnecessary backlog, facilitate the victim have a participation, and it's a win-win situation. From the point of view of the accused, he will have a renewed life. Some of you who had practiced in the trial court will know. Filing of an FIR is a very serious matter. Not only the person, his family, and the persons who are very close to them. Everybody will be affected. Our experience shows children would stop from going to school. The person would lose his employment. Social stigma. As a developing nation like ours, we need to give an opportunity to them to come back. Particularly when we are dealing with these petty offences. We are creating a situation wherein we have 75% of under trials occupying all the prisons. In some of the state prisons, we have 200% occupancy. In some of the cases, at the maximum, we have 400 to 500% of occupancy. Prisons are overflowing. Now, what does it do with the courts? The trial courts, namely the municipal courts, civil junior division, senior division, district courts, would be in a better position to deal with substantive suits. We have to encourage suits being filed. Please appreciate the fact that today we have ever-increasing pendency as filing has increased, as my sister has pointed out. Every year, 2.8% of enhanced filing we are facing. How are we going to deal with this pendency? It does help the government. There is no need to spend money. There is no need for a police who can deal with something else. There is no need for concentration on these matters. You are facilitating a citizen to start his life afresh. So looking from every other perspective, we need to have a different thinking for which a larger discussion is required. I'm only trying to tell my views on these aspects. Ultimately, we have to lay out a roadmap to deal with this huge pendency, which are completely clogging the system. Take for example now, Sandeep Sanyal was speaking about the reform that is being done. Whenever a legislature is introduced, I think a little bit more scrutiny is required by thinking more deeply into the impact of the legislation on the courts. Take for example, Negotiable Instrument Act. It was Negotiable Instrument Act. Today we have roughly about 60 lakhs cases. Of these 60 lakhs cases, 80 to 85% of the cases are pending with the trial courts. You will be surprised. More than 33 lakhs cases are pending at the notice stage. Now, police is not interested. One day, the respondent will not come. Then how do we serve notice? You can invoke Section 82. But it's practically impossible to get that person back. He was again referring to GST. GST again something which is waiting to implode. I was told even as of now you have at least 10-15 lakhs of cases pending. I was part of the selection process. It is done. Then now the tribunals are functioning. But how do we deal with this? We need to think deep. Thank you very much for giving this opportunity to express my views. Thank you very much.
Thank you very much, sir, for sharing practical solution. Now, I would like to request Honorable Mr. Justice Deepankar Datta to share his thoughts. Sir, your PPT is ready to share.
Good afternoon, one and all. Right from the first day I was appointed as a judge, I was told by my elders that you should speak through your judgments. But times have changed. Thanks to Mr. Vikas Singh and team, that we are given the opportunity to express our thoughts. And I do hope that what I present before you today reaches the powers who matter. Mr. Sanyal said this is an important topic. I say it's a burning topic. Pendency to prompt justice, rethinking justice delivery in Indian courts. Do we live in a perfect society? The answer is no. Had society been perfect, we would not have a proliferation of litigation, courts being flooded with disputes and differences between parties. In present times, the four sins, hingsha, violence, lobh, greed, kama, lust, and krodh, wrath or rage, have so overpowered and overwhelmed people that they have lost sight of what is truly important, that is the preambular promise of fraternity. You know, these four things, hingsa, lobh, kama, and krodh, you'll find it in every people nowadays. Are we responsible for delayed justice? We are singled out. The judiciary is the soft target. People will commit crimes. Could be. Some of them have been falsely implicated. But when it comes to court, you will have to understand under what circumstances judges and judicial officers work. And this would be my endeavor to show to you. You know, the Supreme Court has no spokesperson. We can't go to the public and tell them what are our difficulties and predicaments. Now, I will try to show to you, as a spokesperson of the Supreme Court, what the reasons are for pendency. I start with Leo Tolstoy's moral question, what then must we do? Confronts us today as we examine delayed judicial decisions and pendency of cases in courts, while at the same time seeking to secure people's right to access to justice. The crisis is not merely one of numbers, but of design, discipline, and shared responsibility. What must all of us do within the system we collectively sustain? This is a broad overview of the topics I intended to touch, but because of time constraints, I will not be touching number 3, which has been dealt with by Justice Nagaratna. Justice Nagaratna has also dealt with extensively the path forward. Several suggestions have been given. I will also exclude that. Okay. I'll try to confine myself to 1, 2, 5. 1, 2, and 5. Now let us see what is the crisis. Numbers reveal the depth. Judicial vacancies as of August 2025 against 112 to sanction High Court judgeships, only 788 judges are working, leaving 334 posts vacant. This was said by the Minister of State. Now, so far as budgetary neglect, state governments are supposed to contribute the lion's share to judiciary budgets, yet, except for a very few, no state spends more than 1% of its budget on the judiciary. This is from the Indian Justice Report. There's a quotation at the end, but I believe you may not be able to see it. I read it out. When a judge has 300 to 500 cases, he feels, let me deal with each case and do justice. But if a judge has 2,000 cases, it becomes oppressive and the judge starts thinking of disposing of cases rather than doing justice. This is Justice Ravindran speaking. Now, Mr. Sanyal said about investments. Let us see what investment the states do so far as the district judiciary is concerned in each state. Mind you, under the concurrent list, entry 11A, it's the state's power also. Look at this chart. You find horizontal yellow lines, and at the beginning you find a red dot. What are these red dots? Top to bottom red dots. You will not be able to see at the bottom what is the legend. The red dot is the amount allocated to the judiciary by the states, and the yellow is the total budget. And let me tell you, apart from two states here, one is Meghalaya and the other is Uttar Pradesh, the budgetary allocation for the judiciary in all the other states is less than ₹1. If the budget is ₹100, for the judiciary it is less than ₹1. And we talk of investment in the judiciary. I'll go to the next slide. Judicial capacity, a far-off desideratum. On the left-hand side, under serial number 1, you have the recommendation of the Parliamentary Standing Committee led by Mr. Pranab Mukherjee. In its 85th report, it was the recommendation of increasing judge strength to 50 judges per 10 lakh, up from a mere 10.5. This was followed by the Supreme Court's mandate in the All India Judges case, where it said in March 2002 that in 5 years' time, we must reach the figure of 50 judges per 10 lakh people. This particular directive was aimed to serve the judge population, severe the judge population imbalance and ensure prompt justice. Now what do we find? This is the statement in 2024 February by the Minister of State. Not to speak of 50 judges within 5 years, that is 2007. In 2024, the figure is 21, and presently it has gone up to 23. Why? I will also tell you that. With 21 judges per million population, with a population of 140 crores, ever-increasing litigation, the people of the nation expect that the judges who are there are solely responsible for the delay. Nothing can be more unfortunate than this. Now I will show you 3 slides about the district courts as on 31st December 2024. Please concentrate on the 4th and the 5th column, the vacancies and the percentage of vacancies. On the right-hand side, extreme right-hand side, you will find, according to the sanction strength, what would be the judge-case ratio and what is in fact the judge-case ratio based on the working strength. I will not delve deep into this first and the second one. This is the second one, but Now come to the third one. Juxtapose Maharashtra with the others. Now there is a history behind this, why Maharashtra has now 56% vacancies. There is a committee in the Supreme Court, National Court Management System Committee. I had the occasion to be a member and thereafter a chairman of the committee. We devised a formula as to how we can reduce pendencies. And the formula was forwarded to all the high courts to find out what is the number of judges that are required. So far as Maharashtra is concerned, Justice Abhay Oak was the chairman of the committee. According to him, 13,000 judges' posts were required to bring down the vacancies. But his lordship felt that 13,000 is absolutely absurd. So he kept it at a conservative 8,000. When I became the Chief Justice of the Bombay High Court, I impressed upon the executive about increasing the number of judicial posts. It was 3,000. Fortunately, this is only one state which has accepted the Chief Justice's suggestion and has increased the number of posts. My suggestion was increase it in phases, but they increased it by more than 2,500 at one go. And see the result. It was 3,000 earlier, it has become 5,469. What is the working strength? The working strength is the same. Vacancies have increased, percentage increase is 56%. Now, why is it that this extra additional posts cannot be filled up? First, there is no infrastructure, no court, no support staff. Secondly, where is the pool of law graduates from whom we will be filling up these posts? As it is, when it is 3,000, there is a vacancy of 5 to 10%. At one go, we have increased the posts, but without any infrastructure and without a pool of law graduates who can fill up these posts. Let's come to the high courts. This is 31st December 2024. The red pillar is the vacancy. Red pillar is the vacancy. Now a question arises, why are posts not filled up? Now, most of the time the blame is placed on the High Court Collegium and the Chief Justice. Chief Justice, you know when your judges are retiring, why don't you send names? Well, if names are sent, the names are kept pending at the governmental level at least for 5 to 6 months. Thereafter, the files move. Leave aside blaming the executive with regard to delayed movement of the file. I'll share with you 4 small incidents from my own experience. The first one, an advocate was recommended when he was below 45. By the time the recommendation reached the Supreme Court, he was plus 45. Central government returned the recommendation of the Supreme Court on the ground that he was below 45. Next time, when his case came up for reconsideration before the High Court Collegium, he appeared with folded hands and said, "Sir, 2 years is a big enough time. I have lost sufficiently well in practice. Please don't embarrass me." He goes out. Second incident, most of the High Court judges of a particular High Court feel that one particular advocate is suitable for being recommended as a judge. He comes up and seeks my advice. Please tell me, sir, I'll take it that the High Court Collegium will clear my name. The Supreme Court Collegium will clear my name. Can you guarantee that the government will clear my name? I said no. Then he said, I don't want to put my head under the guillotine. I went to Bombay. I found 3-4 very promising, very talented lawyers between the age group of 44 to 47. I asked them, are you interested? They were solid performance in the Bombay High Court. They said, sir, nowadays times have changed. Our children go to abroad for educational purposes. With rupees 2.25 plus allowances, it will not be possible for me to make both ends meet. So good lawyers refuse judgeship because what we pay is not sufficient for their needs. And the last one is the icing on the cake. This I heard from my predecessor, Chief Justice. He invited a senior advocate. He came. Yes, sir, what do you want? I want to offer you judgeship. Very well. So what is the salary? Rupees 2.5, 2.25 plus allowances. What was his answer? Sir, I have 4 pets at home and I spend rupees 4 lakhs for my 4 pets. If I have to become a judge, I have to steal. So let the government think of it. You don't have the core meritorious persons coming over to the judiciary. You need to incentivize them so that they come over. Not everyone is a hermit. Not everyone is a hermit. That they would be not thinking about their lives and taking judgeship. Unless you have meritorious people on the bench, don't think of expeditious disposal of cases. Now let me come to the Supreme Court. This is what Justice Sanjeev Khanna said in his foreword to the 2025 report. Docket explosion. You have it on the screen. Can I have a glass of water, please? Now see, this is the strength of judges in the Supreme Court. Right from 1950 onwards, I have taken up to 2018. Now see the yellow portion. 1st of December 2019. In 2018, there was a burst of cases and Supreme Court had 40,000 filings. And then the strength was 31. The judges felt that there should be an increase. And in 2019, 31 was increased to 34. From 2019 till 2026, today, we have the same number of judges. Now let's go to the next slide. 2018, 40,000 cases I just now told you. Disposal was 37, pendency was 57. There was a slight increase in 2019. Leave aside 2020, 21 and 22. These are the COVID years. Now come to 2023. The filing becomes 53,000. The pendency goes up to 80,000. 24, filing goes up to 60,000. Pendency goes up to 82,000. 2025, last year, it's in excess of 75, and the pendency has gone up in excess of 90. Now let us see what has happened during the 2.5 months in 2026 in the Supreme Court. This is the entire figure. You will get it in the annual report. I'm not pointing out this one. This is 15th of March 2026 figure. Total filing is 15,985. That is almost touching 16. Total listing is 81. Total disposal is 14, nearing 15. And what is the case clearance ratio? Case clearance is 93%. If 100 cases have been filed, we have been successful in disposing of 93.61. It is on the deficient side. But what happens to the whole lot of arrears? What happens to the whole lot of arrears? Why doesn't the executive consider increasing the strength of Supreme Court judges from 34 to 40 at least? It was 34 when the pendency was 40. Now it's gone up to near about 80,000 and we have the same number of judges. At least 6 judges would mean we have 3 more division benches of 2. And going by this calculation of what is the filing on 15th of March, we would be touching 77,000 this year with the same number of judges. Now, who is to answer? Are the judges responsible for this? Here, Mr. Vikas Singh, being the president of the Supreme Court Bar Association, let me tell you very frankly, maybe it's a question of survival of advocates, but you too also need to conduct awareness programs to tell your members that please, don't come up against adjournment orders. We also know what is the purpose of filing an SLP. You know what the fate is. But ultimately, you would be getting an order from the Supreme Court, expedite the hearing. And that is what your client needs. But think of those people who are coming from far-off places, South India, Northeastern India, who do not have the resources to come to the Supreme Court to get this small order. So therefore, the responsibility of the members of the bar, I would appeal to you that you should conduct awareness programs to ensure that this explosion does not take out the pendency of the Supreme Court beyond 1 lakh, which is very near. Now, in the last slide, you would find, in the last slide, you would find that 92,000 is the pendency. Of that, 10% are the defective matters, which Madam Nagaratna spoke of. I am also one with her that the defective matters should not be shown as pending because, for the simple reason, unless the defects are cured, the matters do not reach the judges. Why should we be held responsible for these matters which have been kept pending only for the purpose of going back to the High Court and saying, my matter is pending before the Supreme Court? Right? They take advantage of it. Now, this is a famous quote of Dr. B.R. Ambedkar. Every one of you have read about it. Now, there is a lot of criticism about the functioning of the collegium. People say collegium has failed. Now, I was wondering if the collegium system had been there in the original constitution from the very beginning, what would have been Dr. Ambedkar's answer? And I think this would have been Dr. Ambedkar's answer. So it all depends on us who form the collegium, that we pick the best. Now, how to pick the best is the real big question. What should weigh with the collegium? Now, everyone says merit, merit, merit. I also repeat merit, merit, merit. There's no lady on the bench. Should have been there. Should have been there. No, I believe, merit should be a combination of these 4 components. Vertically, competence, integrity. Horizontally, we find temperament and industry. I'm perhaps delaying the proceedings, but this is what is my suggestion. Let the record tilt the scales. The deciding factor should be a fair and objective consideration based strictly on the materials on record. Decisions should be grounded in judgments delivered, reported cases, professional evaluations, written work, and documented conduct. And last thing, the second bullet point is also very important. Personal affiliations, social proximity, lobbying, informal recommendations, or perceived closeness to those in power, judicial, political, or otherwise, must be excluded. Madam, you are not there on the diagram, but you are here now. The next slide. Yes, I've quoted you. I've quoted you. Now, this is what I say. I'm in complete agreement with the statement. Many judges have had the mental courage and conviction to take the hit for the greater good. However, how many judges in present times would prioritize ethics over career growth? Do you expect them to have the rectitude to practice what is preached? It's a bitter pill to swallow. There have been instances in the past where those who followed this statement were not protected by the collegium by ensuring that they are not victimized for their righteousness. My appeal to you as a member of the collegium is to rise to the occasion, to stand by and protect these judges who act as you have stated in that particular lecture. Now, this is more or less the life of a Supreme Court judge. You know, people ask me, this is particularly me because I'm a night owl, so therefore I rise a little late. And you will find most of the time goes for court work. And this is the daily routine for how many days the Supreme Court is open. One must in this connection also read what Justice Hima Kohli said in London. I quote, "The courtroom is merely the visible tip of the iceberg. The most substantial and intellectually demanding work of a Supreme Court judge happens silently in chambers far from public view. While observers witness only the 10:30 a.m. to 4 p.m. courtroom proceedings, the true measure of a judge's dedication lies in the early mornings, late nights, and countless hours spent in thoughtful deliberation over complex legal questions." Now, I was told by my wife, she saw a video yesterday. Justice Vikram Nath was presiding over the bench. At 4 o'clock, Justice Vikram Nath said, "We are adjourning it for another day." The advocate stood up and said, "Why don't you continue today?" Now, as if, you know, when judges are there on the bench, once they have taken up a matter, they must take it to its logical conclusion, irrespective of what the time is to be taken. You know, these are people who don't have experience about judging. You know, when a judge judges from 10:30 to 4, he has to keep his focus on the matter during the entire time. And the brain requires some rest. Otherwise, what happens is this. People take judging as a divine function. It is God who decides between two of the rival parties who is right and who is wrong. And in place of God, you have placed the judges. Now, don't you think that you are taking a risk by urging a judge to sit beyond court hours? Is it not fair, unfair on the part of the litigants or the advocates to try to insist upon the judges to complete the matter the same day it has been taken up? Please have some mercy for the judges. This is what I say. We are there to serve the nation. But that does not mean that you stretch the judges to such an extent that there remains a risk of an indiscretion which will result in injustice. I'll finish here. I think within this 10-minute period, it's very difficult, as Justice Sundesh said. It would take an entire day. The other parts, you know, Madam has covered, Justice Sundesh has covered, and I believe Justice Singh and Justice Manmohan will do the rest. Thank you very much for giving me this opportunity.
Thank you very much, sir. Sir, you spoke very well and gave excellent view on the subject, and your insights are going to be very helpful for all the stakeholders. I'll request Ms. Samta to felicitate Honorable Mr. Justice M.M. Sundaresh. Sir has flight, so he go early. Sorry for inconvenience. Session will be continued. Sir has flight at 3 p.m. So he has to go early. Now, Lordship, may now may I request Honorable Mr. Justice N. Koteshwar Singh to share his view.
A very good afternoon to everybody present here. Time is short, running short, so I'll skip the formalities and my esteemed colleagues on the dais, the resource persons, and off the dais, Honorable Chief Justices, Honorable Justice Gawaiji, CGIX of India, the President of the Bar, Vikasji, senior members of the Bar, and all others, counsel, advocates present here today. Much of what I wanted to speak today has been already spoken, but still, I would like to emphasize on certain issues, which is pendency in this country. As all of you have a mobile phone with you, I request you to just type the NJDG. What does it indicate? As I stand today in front of you, the number of cases is reflected, pending. Just a second. If you see that NJD, it reflects civil cases 1,11,08,021. Criminal cases 3,76,21,335. Total 4,87,29,365. And pre-litigation 12,81,952. As I said, you have seen it, the pendency is mostly in respect to the criminal cases. Of course, today's function being organized by the SCBA, I'm very grateful to the SCBA for giving me this opportunity to share my thought. But as mentioned by earlier speakers, we have a pyramidal structure. The pendency is at the highest, at the lowest rank of the judiciary. In fact, the same page would indicate there are 82%, out of the cases which are pending more than 10 years, 82% are in the criminal cases. So and so forth. If you just see it gives a glimpse of the condition of the criminal justice system in India. Now, all of us know, those who have practiced in the lower courts as well as in the high court, the criminal justice system gets activated when FIR is filed. The moment an FIR is filed, not only the filing of the FIR, but also it adds to the pendency of the case. One may say, how? Because the moment a FIR is filed, the person accused goes for an anticipated bail, or if he's arrested, he goes for a bail. Then the clock starts ticking. Unfortunately, what is happening today is that though the cases are supposed to be concluded at the earliest, as CRPC mentioned, the timeline, how many FIRs are concluded, investigation is concluded. It goes on for years sometimes, unfortunately. Even if it is concluded, do the prosecution file the cases, the charge sheet in time before the court? Again, the same story. Innumerable cases coming up, even to the stage of Supreme Court. Let us forget the high courts. How many cases keep coming before the Supreme Court for a direction that the charge sheet should be filed? And if the charge sheet has been filed, trial has started? No, perhaps not in many cases. Even if they have started, it is not progressing again. It goes on for years and years. Now, if we understand this, what is the role of the judiciary? Except that we are custodian of these case records. Till the stage of trial, the judiciary has nothing to do with it. It is the state, it is the police which has to investigate. It is the prosecution which has to frame the charge sheet. And it is the state which has to procure the witnesses. When I was the acting chief in Guwahati High Court, we are stuck with these figures. I said, why the police is not completing the investigation? Why they are not filing these charges? Why they are not producing the witnesses? We had a meeting with a DG. I said, this is what you are doing. And blame comes to us. जोली LLB में क्या दिखाते हैं हमारी हालत? Blame comes to us. You are responsible for this delay, but we are to take the blame. Is it fair? He assured us, sir, we'll do all the needful. We'll make sure that the investigation is completed at the earliest. We'll make sure that the charge sheet is filed at the earliest. We'll make sure that the witnesses are produced. Because in criminal cases, it's not a duty of the complainant, not the court, to see that the witnesses are produced in time. It is the prosecution. Therefore, much of the blame is put on the system, the judiciary, for many of these delays. Because why I pointed out this figure, because the figure shows that the criminal justice system is really under strain. And who is responsible for that? We also are responsible to the extent have been mentioned also. We'll come to that. But what I try to submit before this August gathering is that these are areas where the judges have no role to play, have no control at all. Therefore, why put the blame on the judiciary? Well, when we see the budget, I don't have the exact figure. Pardon me if I am mistaken, but I just Googled out from, Google Baba is a great help in time of crisis. So I just Googled out what is the total figure, budgetary provision of the government of India. 54 lakhs 47,315 crores. That's the annual budget of this country. It may vary from source to source. I don't have the authentic figure. And what is the budgetary provision for the judiciary? 4,509 crores. Less than 1%. With less than 1% of the budgetary provision, we are expected to work like PC Sarkar, magician. Is it fair? When I was acting Chief Justice in Guwahati High Court and also the Chief Justice in J&K, I used to take interest. I mean, as a Chief Justice, I used to always be in the meeting of this infrastructure committee. Let us find out how many buildings are completed within time. We found the figures. Some are yet to start. Some have 20%. Some have 30%. Some have 50%. Some have 70%. Well, I can understand which is yet to start. There is no point banging our head. 10%, 20%. Let us see what is the reason. Various reasons. Again, I don't want to spend time here trying to find it. Because again, what I want to say is that judges have no role to play because construction of buildings is in the hand of the government. We are just supervisory. That's all, nothing else. Not even directly supervising. That's the engineers. I told these officers, you have completed 70% of the buildings. That means you have substantially invested the money. Because of 30% you are not completing. Isn't it a waste of this money? Precious fund which is made available, that to less than 1%. Is it fair? Sir, we'll do it. Sir, we'll do it. What I'm trying to say is that the condition of the infrastructure. I have come from a very small state. I have seen the infrastructure in that state. I have gone in Assam, various districts of Assam. I had a meeting with the judges. There was one lady who just entered the system. Sir, can I say something? I said, yes, please tell me. Sir, I'm staying in a rented house. The landlord says I have to come back before 7 o'clock. And there is no running water in that. So I have to collect water standing along with other tenants, buckets of water. I said, this is shocking. Fortunately, I had a meeting with the Dean and Chief Minister. I said, what is this happening? You expect a judicial officer to function efficiently when the landlord dictates the time that you have to return before 7 o'clock and you have to collect the water, bucket water. Do you expect this judge to perform so efficiently? There are small instances, much have been highlighted by Brother Dipankar also, for the facts, figures which have been pointed out. These are areas, how we work, under what kind of condition we work. Very few people understand this. The judges, the lawyers, as mentioned by Hima Kohli also, just what is seen is as a tip of the iceberg. We only see the Supreme Court judges in YouTube, everything is, but how many people see how the judges in the district judiciary are functioning under pathetic conditions? And they are the ones who are holding the majority of the burden. This is something which has to be looked into. Well, I don't want to go into facts and figures of the inadequacy in the number of judges in India. I mentioned earlier also, we are out of a total sanction strength of 1,114. We have only 770 High Court judges. There is a shortage of 70%. The reasons have been explained very lucidly by Brother Dipankar. Now, we have also heard the overworked judiciary, the nature of work done by us. I don't want to again go into that. Yes, there's some areas where we have to do some introspection, judges. That is the case management, case scheduling. This is in our hand, for which we cannot blame others. We all know in the civil matters, issues are decided after examining the pleadings, plaint and the written statement and other pleadings. Then we frame the issues. We know what are the issues to be decided. And the parties have already given the list of witnesses. Then why can't we make a schedule also? Say that, yes, you have so many witnesses. You take this much time. If you fail to do so, this cost must be imposed in advance. Settle them with that cost in advance. Failure to stick to your own time limit. Case management is something which we have to develop. Unfortunately, though these rules are in place since 2000, it is hardly adhered to in any of these district judiciary. This is a grave issue, challenge before the district judiciary. We must formulate. It also appealed to the Learned Council also. Learned Council, unfortunately, are also responsible for many of these delays because of this Tariq pe Tariq, Tariq pe Tariq. This must be avoided. There are very few jurisdictions in the world which are so liberal in granting adjournments. Very, very few. If they grant it at a heavy cost, I have not seen, abhi tak wahi cost hai, 50 rupiya, 100 rupiya. Lower court में जाइए 50 रुपया 100 रुपया से ज़्यादा नहीं लगाते हैं, डरते हैं वकील से. Judges also are scared because they don't want to be unpopular judges. These are systemic issues. This we must sit inside without outsiders, of course, mostly. inside our, closed rooms, and we must, think over. These are matters of introspection. We must think it over. How do we deal with these issues? Because non-adherence to timeline is one of the greatest cause for pendency in our judiciary. Yes, much has been spoken. I don't wish to time. My time was only for 10 minutes. I am almost reaching that penultimate part of my speech. I just want to end this. When I was a lawyer, I was very fit. I didn't have this protruding stomach. Then when I joined, it started growing. Prosperity in the middle. Not in my bank account, in the middle portion. Then suddenly I had one day I was feeling very tired. So I called the doctor. He came and said, "Sir, let me check your BP." He checked. It was so high. But I said, I never had BP in my life. I'm very fit. I play a lot of games. I'm fine. No, sir, you have BP. You have to take this medicine. Because he said, why it happens? That this is a disease peculiar to judges, which has been confirmed by the doctor in Supreme Court. I know all the honorable judges, they will not disclose their state of health because it's a top secret, confidential. I know that the doctor goes to every judge to measure their BP. And the doctor was telling me also, "Sir, this is a peculiar of judges. You are not the only one. All these have." So now from where this BP has come? Nobody would like to have this BP. It's just a sheer work pressure. I don't want to again go into, Justice Dipankar has elaborately discussed the reason why go on, not depression, but depressed by the blood pressure. This is something, of course, there are many ways, solutions have been also suggested. Well, thank you for giving me this opportunity to share a few thoughts. As mentioned by Justice Sundaresh, this is something which can go on. And this is something which we are worried about, certainly, because we don't want to have many of these Jolly LLB serials coming up. Because otherwise, unless we mend ourselves, we make drastic improvement in but of course, for which the government has to do a lot of role to play. For improving the condition of the judiciary, they have to spend much more in the judiciary. They have to invest much more in infrastructure, in training, in various others. And of course, I'm today in the first session, of course, was dealing with mediation. This is something which also will, to a great extent, reduce the pendency, because as we are all used to this adversarial system, we are not able to shift to this gear of mediation, which is of a totally different nature. The lawyers have to be trained, they have to be educated about this system, which will, to a great extent, reduce the system pendency, because the mediation, not only the Act of 2023, which has been, but this whole mediation, the scope of mediation is already there in various statutes. We all see from one of these, first was in the family courts at a time, but I don't know how effective it is in the district courts, because all the family courts are functioning, but I understand it is improving, but this is one area. And of course, as coming to mediation, the nature of scope, the nature of mediation is different in different contexts. If it is a commercial mediation, obviously, it cannot be the mediator who is specializing in family dispute mediation, because the psychology is different, the requirement is different, the skill is different. These are huge challenges, but I feel that mediation is another area which, if fully harnessed, the potential fully harnessed, can do a lot, can be a magic wand to reduce the pendency in our system. Thank you very much.
Thank you very much, sir. Now I request Honorable Mr. Justice Manmohan, Judge Supreme Court of India, to share his view.
A very good afternoon to everyone. First of all, I must congratulate the Supreme Court Bar Association for having a discussion on this issue. Because I was asked about pendency and how we intended to reform the system only when I visited universities abroad or spoke at the think tanks abroad. This for the first time, I think we are having a dialogue in this country about this problem. So congratulations to the Supreme Court Bar Association. The advantage of speaking last is that everyone has spoken on the issue and nothing remains to be said. But I will just try to illustrate the points that have been mentioned by giving a few anecdotal references. According to me, the problem of pendency is not just about numbers. It is far deeper. It is about insufficient resources. It is about structural insufficiencies. It's also about archaic laws. It's also about how, on the administrative side, we tend to handle issues. Let me first talk about infrastructure deficiencies and how they impact at the ground level on a daily basis. Not many people understand this. I was Chief Justice of Delhi High Court, and I realized very soon that there was a huge gap between the working strength and the sanction strength of my district judiciary. So I decided to ramp up the recruitment. Within about 6 months' time, we were able to bring our actual strength at par with the sanction strength. Because in Delhi, there is no dearth of talent. You hold one exam and you get a good talent. We were assured all throughout by the state government that as soon as the recruitment takes place, infrastructure like a building would be provided. We did the recruitment and we could not find a building that suited us. I did not know where to seat the people whom I had recruited. Can you imagine there is no place for them to sit? And I have recruited them, they have undergone training. So I start with the digital courts and make them sit in one room on rotational basis. This is how it impacts at the ground level. I was told in one court in Rohini, a family court judge was handling 3,700 matters instead of the average of about 1,200 or 1,300. So I decided to visit the court complex myself to find one small room where I could, make one judge sit. I went to one courtroom. I was told that by the judge there that a bomb blast had taken place over there about 1.5 years ago. Went to the other courtroom. They told me about 2.5 years ago there had been a shootout in the court. There is no space. And I have to make that judge sit in that district. I can't make him sit anywhere else. So there is no space. I have the judge with me. I have a trained person, but I cannot make him sit. This is the physical infrastructure. Now see the resource gap that is there. One day I went on a round. I used to take round of my district courts on a Saturday. I went there in the morning at about 11 o'clock. And I find that there is a huge crowd outside one courtroom and the judge is not sitting there. So I went inside, found out what's happened, why is the judge not sitting, why is he late. I was told that he was sitting in his chamber. So I went, I met him, I told him there is a huge crowd outside the courtroom, why are you sitting in your chamber? He said, Chief, there is one PP which 2 courtrooms share. So till the public prosecutor has finished his cases in the other matter, in the other courtroom, he will not be available in my court. So how do I handle the bail cases without the PP being present? This is how it impacts at the ground level on a daily basis. And people say that we are asking for too much. We need the resources. They are required at the ground level if you want the issue of pendency to be addressed. And then, on top of it, we have a large number of archaic laws which are not in tune with the times. How do we handle complex issues? Issues that are arising because the economy is shifting, say, from the physical world to the digital world. Every day, a judge has to innovate. And with what resources? Today, unfortunately, take the panel lawyers who are appointed on the panel of public sector or of the state or of the government. Are they recruiting on actual merit? Take any state government. Let's take the case of Delhi. Whether it is A party, B party, or C party. In fact, there are only A, B, C parties in Delhi. And the panel lawyers are virtually recruited on party lines, unfortunately. So does a judge get proper assistance to decide a complex issue? And yet, because his name is attached to that judgment, he will try to do his best. He'll have to do work on his own. He'll have to do research on his own. Is the system being fair to the judge? I think we have to all analyze that. And we have to ponder over it. The government is also the biggest litigant. But yet we find that it is not being very responsible in this role. A large number of frivolous appeals are being filed on a daily basis. Why? Because there is mistrust in the system. As was pointed out, if an officer genuinely writes on the file that no appeal needs to be filed, he could be haunted by the police, by the CVC, or by any other investigative agency. So he says, why should I take the burden on myself? It's better to file an appeal and get it dismissed. As a result, the courts are getting clogged. The government also is bringing about legislations which it is not implementing. Government is propagating alternative dispute resolution mechanisms like mediation and arbitration. But is it following them? Is it adopting them? Recently they have said that they will not go for arbitration in big matters. I understand they have certain concerns with the way the arbitration system is operating. But they are in charge of the situation. If it requires legislative amendment, they must do it. But it does not mean that they'll give up on arbitration, which is a very important way of resolving complex disputes. Why can't they resort to mediation in contentious commercial matters where, say, it's a highway construction and everyone knows that if the matter goes to court and the project gets stuck, there'll be huge cost overruns. But no one will follow the practical way. Everyone says the burden should not fall on me. I should not get prosecuted. This mistrust in the system has to change. Without this peculiar problem being dealt with, I don't think we are going forward. And this mistrust, I am sorry to say, is also there on the administrative side in the courts. I have always wondered if the Chief Justice of a state has recommended one person as a judge, why should there be any debate about that name? The Chief Justice of a court is not to be trusted? How do you get talent? You have to trust the man at the spot. The Chief Justice of a state is not an an ordinary officer. He's a constitutional functionary. And we don't trust him. The Supreme Court Collegium will sit on it, then the government will give its advice, the IB will give its advice. This mistrust in the system is costing us dearly. I think we need to debate the collegium system threadbare. I am finding a lot of challenges within the system, to put it mildly and honestly. It really needs to be examined. A High Court judge can only function when he has full power and full authority. He cannot be scared of a transfer. You have to empower him. You cannot emasculate a High Court judge by putting the fear of transfer in him. I think this is a very serious issue which needs to be debated. I have seen it in some courts, and I really am quite disturbed about it, and I think a real good debate needs to happen on this. Also, I would think that the laws that are now being brought in are being brought in without deep study, without deep examination. Brother Sundaresh mentioned about the Negotiable Instruments Act. It was brought about in 1989. Look at the litigation that has cropped up because of one single amendment in the Negotiable Instruments Act. In Delhi, in the trial courts, it's about 45%. Imagine 45% of the trial court litigation is under the Negotiable Instruments Act. And there was no impact assessment of the statute that was done before introducing that amendment. There is no ramp up of the infrastructure in Delhi when this amendment was brought about. So with the same infrastructure, we are dealing with 45% more cases. That's a real issue which needs to be highlighted and needs to be addressed by the executive. Take the case of IBC. Today, I think 7,000 cases are pending before the NCLT. It's a new body that has been created, but I think the calculation was not done of what would be the extent of cases that would be filed under that act. There are a large number of statutory amendments which have been done which say that a judge would hear this matter on a day-to-day basis. Let's take the case of sexual offenses. But if a judge has on his board 1,200 cases, how do you expect him to do that matter on a day-to-day basis? You're setting timelines which are bound to be breached from day one. Why have these laws when they are going to be not observed? I think the matter needs to be examined at all levels. And really, what we require is not just a mere transformation. We require to reimagine the entire system. We require to reimagine our laws. We require to reimagine how we work administratively. Why should the Municipal Corporation of Delhi have about 10,000 cases? It is not at war with its citizens. It should have a procedure whereby the citizen can go speak to the municipal council officers and resolve their disputes. They must tell them what is the correct way forward and follow this path and get the approvals. We have a large number of issues on the administrative side also. They need to be resolved. But one thing is there. By calling one institution as obstructionist, we are not going to move forward. We can only move forward if we all join hands. That's the legislature, the executive, the judiciary. There needs to be communication. There needs to be a dialogue. Without that, we will never become a powerful nation, a nation which can deal with new challenges like environmental challenges. Imagine today, certain things which we used to take as granted are now being agitated in courts on a daily basis. That is fresh air, which was taken for granted when I was young, or clean water. This was also taken for granted when I was going to school. But today, we have courts which have to grapple with this issue. Why should courts be grappling with all these issues? This is to be done on the administrative side by the government, by the executive. And look at the proportion or the magnitude of the problem. The courts have to step in because people have no other alternative and no other forum to appeal to. So in conclusion, I would like to say that all of us must work together. We have to reform the system. It needs to be reimagined at all levels. And then only we can become a Viksit Bharat. Thank you.
Thank you very much to all the speakers. Now I'll request Ms. Asna Gandhi to felicitate Honorable Mrs. Justice B.V. Naratna, Judge Supreme Court of India. May I request Mr. Upendra Mishra to felicitate Honorable Mr. Justice Deepankar Datta. May I request Mrs. Ashish Sinha to felicitate Honorable Mr. Justice N. Koteshwar Singh, Judge Supreme Court of India. I request Mr. Manish Mohan to felicitate Honorable Mr. Justice Manmohan, Judge Supreme Court of India. Dear member, this is to inform you that our... May I request Mr. Rohit Bas to felicitate Mr. Sanjeev Sanyal. Dear members, this is to inform you that our senior advocate and SCBA member, Mr. Srivatsava Raghavendra, senior advocate, who is from Karnataka, has thoughtfully arranged personalized pens with each participant's name, along with keychain. Participants are requested to kindly collect the same from the counter placed outside the hall. The items will be available during the lunch hours. You are requested to please check your name and collect your personalized set from the counter. Thank you. Request for good photograph. Ma'am, one photo.
please join us for lunch. And the participant, please, the lunch is organized by Greater Bengaluru Authority. We will assemble here at 3 p.m. Chief Justice of India Supreme Court, Justice Suryakant, has already reached the venue. He will be shortly joining us at 3 p.m. Please note, thereafter we will have a group photograph of with all the participants and judges. We have made a special podium for a group photograph with all the distinguished speakers, judges and the participants. So please assemble by 3 p.m. or try as earliest as you can. I'm sorry we are behind the schedule. We are making unreasonable requests from the participants. Please be cooperative in this effect. Dear participant, one of our member has lost the gold bracelet in the hall today. If anybody finds it, please deposit to any of the EC members. I will write the message in the group, and I've already informed the authorities also. Thank you.
क्या आपको पता है आपका और हमारा बहुत ही लंबा और करीबी रिश्ता है। हम उस चटकारे में हैं जो आप अपने दोस्तों के साथ लेते हैं, उस दराज में है जिसमें छिपा है माँ के राजमा चावल का राज, उन सांसों में है जो आपके पलों को महकाते हैं, कभी आपके साथ एक अच्छी आदत बनकर, कभी ठंडी हवाओं से राहत बनकर, कभी मुंह में पिघलती चाहत बनकर आपका दिल जीतते रहे। तो अगली बार आपको कोई चीज पसंद आ जाए तो उसे पलट के देखिएगा, जरूर हमारा नाम दिख जाएगा।
Check. Mic test on. Check, check, check.
I request everyone to be seated for next session. Mr. Ashok Panigrai. Honorable Chief Justice of India has already arrived. I request everyone to be seated for next session. I request everyone, please come for the next session. I request everyone to welcome Honorable Chief Justice of India. He has arrived. Everyone is requested to come for next session. Monica ma'am and Ashok Panigrai ji, come on dais and start the session. Thank you.
ये चल Namaskara, Namma Bengaluru. Justice Ruth Bader Ginsburg of Supreme Court of United States said, "Women belong in all places where decisions are being made. It should not be that women are the exception." This evocation of the exclusive places leads to critical exploration of socio-legal discourses from the perspective of gender. Today, the theme of third session of Inclusive Institutions for Democratic Justice, the Women in Legal Profession, addresses not only the contemporary lacuna in gender discourse, but also paves the way for future discourses. On behalf of Supreme Court Bar Association, it is my great honor and privilege to welcome our distinguished dignitaries, Honorable Justice Suryakant, Honorable Chief Justice of India, Honorable Justice Suryakant, Honorable Chief Justice of India, a first-generation lawyer, is recognized for holding the office of Advocate General Haryana as the youngest in age in history of Haryana, and is also the first from state of Haryana to reach the esteemed office of Chief Justice of India. His Lordship launched our First Lady Lawyers Survey on 3rd December 2025 at Supreme Court Auditorium and proved once again that he is a champion of gender equality by directing 1/3 reservation of seats for women lawyers in all bar associations, including the Supreme Court Bar Association. Your Lordship, your presence here today, despite your busy schedule, is an inspiration, and we are, as always, eager to hear you and be guided by your wisdom. On behalf of Executive Committee, Supreme Court Bar Association, I now warmly welcome Honorable Mr. Justice Vibhu Bakru, Chief Justice of Karnataka High Court. The illustrious journey from the bar to bench of my lord reflects exceptional legal acumen, scholarship, and an unwavering commitment to the administration of justice. My lord, an alumni of Campus Law Center, Delhi University, also is fully qualified chartered accountant and is known for his expertise in commercial law. We are deeply honored by my lord's gracious presence today. Honorable Mrs. Justice Anu Sivaraman, it is a matter of great honor and privilege to welcome Honorable Mrs. Justice Anu Sivaraman, Judge, Karnataka High Court. Her ladyship's career reflects not only deep legal scholarship and judicial excellence, but also a remarkable understanding of the evolving realities of the legal profession. We extend a very warm welcome to her ladyship and are deeply grateful for her gracious presence with us today. It is my proud privilege to warmly welcome Shri R. Venkatramani, Learned Attorney General for India, to this esteemed gathering. Shri Venkatramani's contributions are marked by legal excellence, constitutional wisdom. He has also been involved in the work done by Constitution Review Commission and has been a member of Law Commission of India. His presence at this discussion greatly enriches the occasion, and we are deeply grateful for his gracious presence. It is also my privilege to warmly welcome Mrs. Aishwarya Bhati, Learned Additional Solicitor General of India. Mrs. Bhati, one of the youngest women lawyer to be conferred the designation of a senior advocate by Supreme Court of India, has also been Secretary of the Supreme Court Bar Association. We are certain that her insights and experience will greatly enrich today's conversation on the gender justice. Welcome, ma'am. Shri Vikas Singh, the President of Supreme Court Bar Association, is, through his 4th term as President of Supreme Court Bar, his remarkable journey in the legal profession is an inspiration not only to the first generation lawyers, but also to entire Supreme Court Bar Association, including his EC team. He has been a committed supporter of female education and women's rights, reflecting his enduring commitment to justice, equality, and social empowerment. On behalf of all present here, I extend a heartfelt welcome to our esteemed dignitaries and thank them for joining us for this significant discussion to share, reflect, and inspire. A whole generation worked to empower women, but forgot to teach men how to live with empowered women. I request Tech Team to start the presentation showcasing the efforts undertaken by Team SCBA to widely publicize the first of its kind national survey on welfare of lady advocates. Inspired by Indra Nui, CEO Pepsi's remark to leave the crown in the garage, as part of Team SCBA, we started contemplating the unprecedented when in July 2025, discussed the issue of welfare of lady advocates with my Lord Justice Suryakant, now the Chief Justice of India. That discussion developed with the help of EC, took the form of pilot project survey containing 19 questions on the problems faced by lady advocates of Delhi NCR. It culminated in the panel discussion at Supreme Court Auditorium on 3rd December 2025. The exercise highlighted the seriousness and scale of the issue, though the issues were being observed anecdotally but were not systematically recorded. There was strong need to gather ground realities through a study with the purpose and to convert marginalized participation to full participation. It being first of its kind, trial and error method was adopted to improve accessibility of maximum number of lady advocates. It is a process when no direct solution is known. Learner tries one approach. If it fails, then try another until a successful outcome is achieved. We did face considerable number of problems, the very first being length of survey. While the pilot project for Delhi NCR had 19 questions, for the national survey, we ended up having 75 questions, which were reduced to 53 questions, and the 54th being suggestions invited up to the word limit of 300 words. Second barrier was language barrier. While in pilot project, it was English, as concentration was on Delhi NCR. For national survey, we kept receiving requests from various corners of the country to get it translated into regional languages, but because of time constraint of a month or so, that could not be done, and we were left helpless as far as this issue is concerned. Area covered, like pilot project, we started with initially with Delhi NCR, and the difficulties being faced were practical difficulties, like we had responses, the lady advocate has already filled the form while she was getting confused with the earlier pilot project survey. Further, they kept deferring because of time constraint and the survey questionnaire being too lengthy. The few chose to not respond to any query. The advocate on record and non-advocate record who could shift for a while to their respective home states were sent away to Tamil Nadu, Andhra Pradesh, Kerala, Jammu. The Standing Council of various states practicing in Supreme Court were requested to request the advocates known to them in their respective home states so that they can be reached out and we can have more and more responses. Further, we adopted high-tech mode. We created QR code, Google link. Interns, juniors started visiting 10 out of 13 bar associations of Delhi in a clockwise manner. They'll start from Saket, Dwaraka, Rohini, or anti-clockwise manner from Kadkaduma to Tis Hazari to Rohini, with the aim of reaching out to more and more lady advocates gathered on the occasion of some cultural function or seminars, as we also try to ensure that the SCBA circular being circulated has been placed on prominent places in respective courts. The problem was at times technical glitch, QR code not working, Google link not opening. Then we started with emails and WhatsApp. The team SCBA sent more than 11,000 emails to respective individual lady advocates throughout the country, more than 7,000 WhatsApps, but every day they will get blocked after a number of WhatsApp and emails are sent. The SCBA office repeatedly sent emails to lady advocates, members of SCBA, 797 district judges in India, bar councils, bar associations, office bearers, as well as Registrar General of various high courts. If it was not enough, we approached YouTube influencer and started with extensive study. Response of it being, it's a scam, or there was also a threat from an advocate in Jhajjar. He said he'll lodge a FIR because all this is fabricated. So we decided to visit various districts in Haryana, Uttar Pradesh, and we did manage to visit as many as 25 districts because of the time constraint. The procedure framed was find out a source within the Supreme Court or at the respective district court, then create a nodal officer who will fix a working day when we can physically visit and explain the survey to the lady advocates there. The problems we faced, no response from source or the nodal officer, or the date finalized was having strike in the district court, or on account of some death, the lady advocates were not available. The best response we got was from Panipat district in Haryana, where the gathering of the lady advocates asked us that please let us first fill the response to the survey Later on, you can speak and tell us what is the purpose of this survey. They were so excited. In Mathura district, also in Uttar Pradesh, the lady advocates did not hesitate to learn how to operate QR code or Google link and how to fill in the form. The SCBA team did travel overnight also, and in early hours in extreme adverse weather conditions. We also had NTTV coverage by Ashish Bhargava, journalist, wherein we came to know that Bhuj district in Gujarat, it has no separate washrooms for lady advocates, and many lady advocates sent response to that NTTV coverage, highlighting that they are ailing with hygiene issues, including UTIs. We also had virtual meets with various universities like Jamia, Hamdard, Jindal, and many others to reach out to lady advocates who were, though enrolled, were not in active practice because of their higher studies. I'll be failing my duty if I do not express gratitude to Akhil Bharatiya Adhivakta Parishad, Women Unit, Meera Tai, Vice President, Anjali Helkar, National Secretary. They motivated the members of the Parishad to fill the national survey form. Interestingly, strangers to survey who had no direct interest also were eager and contributed to the filling of the national survey form. Male colleagues, both advocates on record and non-advocate on record in Supreme Court, volunteered to get the response added to in numbers. There was a gentleman director, Muzaffarpur Law College, Bihar. He went to various district courts to circulate the form and ensure that more and more lady advocates fill the form. One of erstwhile client 2 decades ago in Ahmedabad, Gujarat, visited High Court, District Court, Ahmedabad thrice on herself explaining the data to the lady advocates there. The indirect benefit of the survey was in the form of an intern in my office, Ujjaini, who was introvert, and I never heard her saying anything throughout her internship period. But on the last day, she showed me a video that she had been on the dais at Gadwal Lady Advocates gathering in Connaught Place, Delhi, and she explained the survey form with its benefits to the lady advocates in the gathering. In this drive, in view of responses received, it is suggested that such exercise of national survey are held periodically by the Supreme Court Bar Association, maybe after every 5 years. We are certain responses might change. May I now request for the release of the National Survey Report by the Honorable Chief Justice of India. I will now request Madam Anindita Pujari, Senior Advocate and Senior Executive Member, SCBA, to explain the National Survey Report.
Namaskar everyone. Since the background for why and what we did during the process of survey has already been explained by my colleague, I'm not going to get into that. I will be speaking mostly of the statistic, the findings that has emerged, and I'll try to make it as brief as possible. Technical team, we can start with slideshow. So slide 1, it talks about, I begin with a thought that is inspired by Michelle Obama, though it is adopted for today. The future of our legal world is only as bright as the future of our women legal professionals. What follows is not a mere presentation of statistics, it reflects the distilled weight of 2,604 voices drawn from across 23 state bar councils spanning district courts in the Northeast, High Court corridors in the South, and the Supreme Court of India. To the best of our knowledge, this constitutes the most expansive national empirical exercise ever undertaken so far as women legal professionals are concerned. The next slide, we begin with why this survey was needed at all. For over a century, the lived experience of women at law have been treated as a personal anecdote rather than structural deficit. We needed baseline evidence. Hence, this survey asked 54 analytical questions spanning every stage of a women practitioner's life cycle. It drew 2,604 responses with grassroots participation at its core. 52.9% of the respondents practice in district courts, 28.2% in High Court, and 23 state bar councils represented. Slide 3, the demographic profile that you can find out. Question number 1, 2, 3 dealt with that. It shows 37.4% in 0 to 5 years of practice. So they are very early on in their practice. 30.7% with over 15 years of practice. Question 4 shows 45% relocated for some reason or the other, primarily because of the family reasons. Either the husband is working there or they had to relocate because of family obligations. Question 5 shows 58.2% independent and 2.8% in larger firms, those who participated in this survey. Question 6, in fact, shows that 87.6 advocates and only 0.4 senior advocates were part of this survey. Question 7, in fact, shows that 53.9% say designation is easier for men. While we were doing this survey, the 54 questions not only captured the fact or the raw data, it also did try to capture the mindset, the nuances and the biases that exist, and the preconceived notions or the belief system that existed. So this is a reflection of that. Question 8 and 9 shows 64.5% never held any government role. This includes the government panel advocates or anything of that sort. Question 10 and 11 show 59.4% show panel reservation. In fact, women have consistently, even in during our pilot study and now, have insisted that there has to be some amount of reservation for panel allocations, and 67.28%, which is pretty high, support policy for women law officers. Question 12 shows that 55.5% say panel appointments are easier for men. Question 13 shows participation across civil is those who are practicing civil law is about 71.3%, family law is about 65.4%, and interestingly enough, the criminal law practice domain showed 64.5% women being there. And this is actually to deflect from the stereotypes that exist. Question 4 shows 56.9 face limits due to gendered expectations, and 15 shows 83.1 are first generation lawyers. In fact, this data of 83.1% being first generation lawyer is one of the most important things that happened to this survey, because it shows the aspiration of the first generational lawyers and the struggles and tribulations that they have to face. And another interesting finding that came across, irrespective of whether a woman is in the range of 0 to 5 years or she has already invested 15 years of her career, the struggles and the challenges remain same, and the profession remained similarly harder irrespective of the age group or the number of years that you have invested in this profession. Next, we come to some infrastructural challenges and the biases that raise, and those were from question 16 to 28. 16 and 17, in fact, show only 19% have offices near the court, and 12% have none at all. Question 18 shows barriers of rent and other financial limits, that takes it to 37.5%. Altogether, it takes us to, in fact, about 80% women having financial difficulties in owning or having an office proximate to the court. And 77% lack staff, 56 lack stable digital access, because a clear digital divide also did arise during this survey, and it shows that 60% report gender bias in their professional career. Question 21 shows bias in fees that a women could command and they received, and work-life expectations bring them to 39.5%. And briefing, the number of time a woman gets briefed is at 32.8%, and insofar as appointments are concerned, that's at a low, which is at 29.1%. Question 22 shows 65.3 report positive impact of technology so far as women lawyers are concerned. Question 23 shows 63.7 find the profession discouraging at some point of their professional career, and 24 shows 81.3 say their journey is harder than men. Question 25 shows 16.1 report harassment at some point in their professional career, and up to 28.8 may have experienced it, but they do not wish to say. That takes the figure even higher. And many, in fact, have indicated that because who is there in the committee to redress these subjective factors, tell them whether they should report it or not, which is also a matter of concern. Because irrespective of these subjective criteria, the system should be robust enough to redress issues. Question 26 shows 57% of those reporting faced backlash. This is a huge number, and question 27 shows 45% report horizontal hostility. This is in fact a new finding that we found, that there is a clear lack of collegiality and sisterhood so far as women lawyers are concerned for each other, and that takes us to 45%. Question 28 shows 72.3 say gender limits networking, and that is a difficult challenge for them to navigate. Slide 5, we can go to that. Then the challenges and personal impact questions range from question 29 to 45. 29 shows challenges of limited work, which is a 60%. Networking that women are not able to do, which is 42.8%. And pay inequality takes us to 40.2%. The work-life balance challenge is 37.5. And question 30 shows 37.7 are in the, there is a huge demand for mentorship, however, they just do not have access to it. 31 shows 25.6 are confident in grievance redressal system, however, 32 shows burnout. This is again an extremely important matter of concern, because we are, in our data, we found 83% were young lawyers, and out of which about 84% are saying they are burned out in this profession in the early 0 to 5 years. And 94.4% among the early career lawyers that they are facing burnout. 33 and 34 questions showed us that 59.7 support uniform judicial syllabus, because we also had questions on, in judicial services examination, what are the kind of reform that you want, or what are the challenges that you face. And in fact, about as huge as 80.5%, they support reservation in high-end judiciary. The percentage, some have indicated, some have not, but they do mention that. Question 35 shows 44.1 are married with children. We were also trying to have a demographic analysis of that. And 36.4 are single. 36 shows that 71.5 report that there is an impact of marriage on their career progression. And 37 shows work-life and financial strain that follows thereafter. 38 and 39 questions shows 42.7 denied child care accommodation when they are discharging their duty as a professional lawyer. So there is a clear need for having more accommodation policies so far as women lawyers are concerned, including the use of technology to that effect. 55.2% face difficulty in case deferrals if they needed it for caregiving roles to be accommodated. Question 40 shows 30.3% say familiar limits opportunities. 43 shows 47.5 would recommend judiciary as a career option. This also was the finding during our pilot survey, that a lot of respondents and their families would believe that if they join the judiciary, there would be a sense of stability that would be there. And 44 shows 89.8% support returnship program. This was a novel idea. We thought, why not put it to the respondents? Would they require or would they demand for any returnship program? Because after the maternity gap, when they join the profession, they do not have the same number of opportunities, and they must have lost clients in between. So, and 89.8% said they want returnship programs. Question 45 shows 1 in 10 are unable to enforce their own rights. Coming to slide 6, which is very interesting on leadership and aspiration questions, 46 to 54. On the last occasion also in December, we had noticed that with the intervention of the Honorable Supreme Court, Honorable the Chief Justice, in providing for 30% representation of women in bar leadership position, it had a clear impact. So question 46 shows 25.7 say equal leadership opportunity are required, while 64.7 they do not find it existing at all. 47 shows that barriers of network is a major reason why women are not in the leadership positions in the bar associations and bar council. Financial and time limit follow that. And next comes the family expectation, and the last being the hostile election procedures and practices. Question 48 shows 76.4% are considering judiciary as their career option, and 37% aspire to law officer roles, and 34.5% to prefer bar leadership. And question 51 takes us that 77.3% support term limits in any elected positions, because that seems to be a real challenge. They are not able to navigate unless there are term limits in the bar leadership positions. 52 shows us that about 77.5% of women legal professionals are exploring leadership positions in bar associations and bar councils. And about 50.9% are satisfied with having this role, and about 35% are still neutral, and few others are still exploring. And so far as question number 54 is concerned, they reflect, because it was an open-ended question and 300 words they had to write. We tried to cluster them into different groups. They reflect a strong demand for structural reforms. Coming to slide number 7. Now, what do we get out of this statistics? It actually sounds like a mere number, but what is the impact of it? So we did try to do a cross-section analysis of the data and find out some of the interesting findings that are emerging, because then only we can lead forward for some reforms in the system if need be. So number 1, multi-dimensional reality. While before we come and go anywhere, it is imperative that we pause and actually conceptualize what runs through these data points. The legal ecosystem expects an extremely singular, linear form of endurance that's required in the profession. That is not so far as women are concerned. Next, there is a brief-based focus that probably everybody expects them to have. That may not be possible. Number 3, there could be an assumption that there is domestic support that may or may not be there. Have that along with the caregiving roles that the women have to play. The female practitioners bring a multidimensional reality to that same space in comparison to their other counterparts in the legal profession. She manages the unsaid biases, she carries the domestic anchors that society assumes she can shoulder alone because it is linear. She deploys emotional intelligence to navigate a professional space that routinely mistakes grace for weakness, as she treats financial independence as central to her dignity, even when the profession rarely acknowledges it. The number 2 key finding that we have here is entering without a safety net. And this is a very important finding. 3 numbers define the challenge at the entry itself. As I mentioned earlier, about 83% of our respondents were first-generation lawyers, meaning no inherited networks, no informal mentors, no institutional memory, so to say, that can be passed down at home. When asked whether the respondent's immediate family member had any space in the legal sphere or not, 83% of the same no. 58.2 are sole practitioners without any support, operating without any structural support of a firm or a chamber. When asked about the practice structure and setup, 37.4% in their first 0 to 5 years of practice, a massive influx of the young, talented women entering a profession unprepared to receive any mentorship, lacking in legacy or any support, structural support in their families. The next takeaway, what do we find? Slide number 9. It takes us to the mentorship deficit, as I already mentioned. When we are talking about 83.1% entering as first-generation lawyers, we find that only 31.5% have any formal system of mentorship existing for them, and are satisfied with the guidance they receive, but there is a huge aspirational category that exists. 37.7% report an active but unmet need for mentorship. I think this is where the bar associations and the bar councils have to chip in to provide mentorship programs for the young budding lawyers, those who are in need of mentorship. When in the absence of inherited professional networks, this becomes a very important factor. The next takeaway is the proximity penalty. As we discussed when we were looking at the statistics, we did see that the financial and other reasons are the primary reasons why women lack having any physical infrastructural support closer to the court. So that is what we are calling the proximity penalty. Only 19% of the respondents have a walkable office near the court. When asked about office, in fact, there are different rings. If you look at the ring, you will find that this is not a preference issue. It's not that by choice they do not want to have an office closer to the court. They just cannot have it yet. It is an access issue. And therefore, this needs to be again addressed by the bar associations and the bar council so far as the access issue is concerned. 83.8% say proximity to court helps practice significantly, however they lack it. Why are women excluded from proximity? The reason that they cite is 45.4% cite high rent, 37.5% say it is not financially viable yet because they're all young lawyers. 20.3% are pushed outward by the family responsibilities and therefore they do not choose to have their own physical infrastructural office spaces. And 8.2% cite commute safety being a concern for not having it near the court, as they will have to put in a lot of hard work even after the court hours. Therefore, they do not choose to have it near the court. Proximity, therefore, dictates access to brief, to network, to visibility. Its absence shadows women from formal ecosystem. The next takeaway from this entire survey is the anatomy of everyday bias that lingers on, and that sets the undertone for the women professionals. And here, out of the 81.3, women say the professional journey is harder than male counterparts when they were asked about, do you believe in that? Because as I said, besides trying to capture the fact, it was also the idea to capture some of the notions that exist and how do they feel. Now, 6 in 10 women have personally experienced or witnessed institutional gender biases. When they were asked about, have you ever experienced gender bias in your workspace? Where does the bias manifest really? The fee negotiations, as we just mentioned, the work-life expectations imposed by gender, client trust, and the briefing decision, and panel appointments, and the judicial appointments. This is not interpersonal conflict. It is a structural texture that exists, and we found in the report. The next takeaway, what emerges from the survey? Seniority versus perceived difficulty. One of the most important findings of the survey is that perceived difficulty, is the profession harder for you? That question was in fact shocking, the revelation that we got. The perceived difficulty does not diminish with seniority. Irrespective of the years of practice that you have put in, the proportion of reporting that the journey is harder than male peers remain consistent across age group. This means the barriers are not merely entry level. This is systemic. They are embedded throughout the profession, and that is something of matter of concern for all of us. The next takeaway for us is the attrition cycle. A lot of women lawyers are joining the profession, but where do they really get the attrition happens for them in the profession? About 84% experienced work-related stress or burnout in the past 12 months. Among those in their first 0 to 5 years of practice, this rises to 94.4, a near total early career crisis, so to say, signaling impeding attrition. Now, compounding this is a horizontal hostility that I've just mentioned, which is about 45% of women have reported that there is gatekeepers, women acting as gatekeepers against women. The next takeaway is the work-life balance wall, which is 52.2% face difficulty getting matters, differ on childbirth issues, and therefore the work-life balance remains a consistent issue. 42.7% said they were denied support when they sought accommodation during the caregiving years. In fact, shockingly enough, many of them did say that the digital divide is so high that they are forced to go to court and they're not able to manage all their work on an online mode. The next takeaway, I'll try to quickly wrap up and not read all the findings. In fact, the report will be uploaded today itself on the Supreme Court website, and it will be also broadcasted in the WhatsApp group for all of you, those who are participating, so that we have access and we can save the environment as well. Coming to the technology and e-court, as already mentioned, technology has emerged as an equalizer. 65.3% report a positive overall impact from the e-court initiative. But the gap in digital access is real. 56% still lack stable internet and devices. So therefore, it is difficult for them to navigate the digital device. The next takeaway is the backlash algorithm. As I just mentioned, if you report, you are in problem. If you do not report, you are not happy in the profession, there is burnout, and then there is an attrition. So up to 28.8% respondent indicate experience of sexual harassment in courts. 38.6 choose silence over reporting. Of those who reported, just 16.1, which is a very small number, 57% of them said that they face backlash. And what are the kind of backlash that happens? 13.5 clearly stated they faced work exclusion. When asked about the confident grievance redressal system, they asked for more. The next slide, slide number 17, the underrepresentation of women at the top is not a pipeline problem, but it exists as a series of compounding subtractions. Now I'm almost at the end of the presentation, and I will just read out the subtractions, how gradually the attrition happens. Here, what exists is a series of subtractions, and here it is. It starts with 100% ambition at the beginning, minus 83.1% who enter without an inherited family network, which is question number 15, minus 45.5%, 4% pushed to the margins of visibility because they cannot afford office or other infrastructural issues that they have to have. Again, subtract 42.7% denied caregiving accommodation when they, whereas they expect maternity benefits and deferral accommodations. 55.2% could not get a matter deferred due to child when they were in maternity leave. Again, deduct 57% who faced backlash. What remains? What remains is a very small number. And that takes us to only 0.4% of the respondents who were women senior designated counsels. So therefore, the attrition, if you look throughout the process, it's systemic. So it's not a pipeline issue merely. The last leadership paradox I've already read, for which we are eternally grateful to the Honorable the Chief Justice of India. There is a huge aspiration of 77.5% to actively explore the possibility of being a bar leader. So I think that is soon going to be realized as soon as the order is implemented. And the exclusion loop. 72 slide number 19, it says 72.3 says gender limit access to professional networking. And when we asked, do you want to do legal aid matters? Because if you do not get briefs and the clients actually discriminate or they do not choose you or prefer you for whatever reason, do you want that? About 59.4% favor mandatory minimum representation in NALSA, SALSA and DALSA panels, with only 12.3% expressing to some other view. The judiciary still remains an aspirational scenario for women lawyers. About 76.4 are planning or considering a transition to the bench. When we asked, do you want to recommend somebody, a daughter in your family, to follow this path of legal profession? Mostly said yes. But when you ask them, do you want them to do practice law, join the law firm, or join the judiciary? Most of them preferred join the judiciary. 80.5 support reservation for women in High Court and Supreme Court, and they want transparency in the selection processes. And now, we began by saying this survey is a documentation, slide number 23, I'm skipping some of them, of hard work, of difficulty, yet above all, a quiet resilience, and the enduring will to remain and reform a profession that has not always made space for women. 2,604 women across 23 state bar councils have spoken clearly, consistently, and with remarkable precision about what needs to change. The Supreme Court Bar Association is committed to ensuring that these voices move from this report to institutional policy, from data to dignity. In fact, when you access the report, you'll find at the end, which I'm sure my learned colleague, Mr. Panigrai, is going to talk about the reforms, the directions for that we have already indicated. Thank you so very much for your patience. I would like to thank the team of Madam Monica Gosai, who helped, and Madam Pragya Baghel, who helped us collecting the data, and Mr. Mohan Katarki, who was kind enough to bring the survey report from Delhi to Bengaluru, and Saileshwar Yadav in helping me in the analysis of data. Thank you very much.
May I now request our President, Mr. Vikas Singh, to start with the question-answer session.
Honorable the Chief Justice of India, Justice Suryakant, Justice Bibu Bhakru, the Honorable Attorney General for India, Justice Anu Sevaraman, my Aishwarya Bhati, my colleague in the Supreme Court, other team members of the Supreme Court Bar Association, Honorable former Chief Justice of India, Justice B.R. Gawai, Justice Varale, Justice Mishra, Justice Tandon, Justice Ashutosh Kumar, Shibu Shankar, other guests present here. First of all, I'd like to thank the Honorable Chief Justice. He was not here on the inaugural session today. I did make a brief mention, but this national conference is happening because of the date given by you long back. You agreed that in Bangalore you will have some time, and you were supposed to be only half day away from us, but unfortunately because something very important coming up tomorrow, you are unable to be with us tomorrow. But we are glad that because of you we could start this conference, our first national conference in Bengaluru today. As far as the, I've changed this format because we're running into time, so I thought let me do it like I'll set the context of this debate and then I'll request the other speakers to go forward. In the legal profession, why women don't do well? If women can do well in every other profession, whether it be bureaucracy, whether it be science, whether it be medicine, whether it be corporates, whether it be finance, whether it be marketing, what is it that holds women back from making a mark in the legal profession? So really that really is the context of our debate today. Is there something wrong in the system that we are having for women? Is there something wrong that the practices that we follow as far as litigation is concerned? Is there any corrective action to be taken to ensure that this is corrected? Is actually the debate today. This is what I feel was the purpose, because to exclude women from the judiciary or from litigation is actually regressive. We are going backwards. It should be our responsibility, and especially since I'm the bar leader of the Supreme Court bar, I consider myself to be in a position to do something, and I thought that is why this kind of a session will be very important, to do some soul searching and try and find out some solutions. Now we have all read the survey, and the survey will be uploaded, so you all can also have a look at the survey at leisure later. But the crux of the survey is that somehow litigation and politics, women have not fared well. Of course, in politics, there is a amendment to the Constitution. We will be having a reservation, which is, of course, not yet kicked in, but hopefully it will kick in, and that reservation will definitely improve things as far as politics is concerned. But as far as the reservation in judiciary is concerned, that's still a far cry. And again, I commend the Honorable Chief Justice of India that he has, in spite of the bar associations not being happy, and I must admit this to you, sir, that the bar associations are not happy that you have imposed, or the bar councils have not been happy that you have imposed 30% quota in the bar elections. But I think it's a salutary step, and we should all thank the Chief Justice of India for this and also applaud him for this. You also made a statement very recently in our other function that we did recently on women in the Supreme Court, where you said that we should also have 30% reservation of women even as judges. Now, that's again, I'm sure that it will be your endeavor to do something very significant in achieving that. I only feel that I can, as a leader of the bar, give some thoughts which will help you achieve that. When you look at elevation, I'm straight away, otherwise there are a lot of issues which I would like to deal with about women, how women entry should come and how the bar should play a very active role, because I think the bar plays a very active role in ensuring that they get proper placements, that they are not in any manner harassed or exploited. These are issues, of course, which are very, very large issues, and I think all the bar associations of the country should take this as a very important part of their responsibility. Even when the Bar Council expects these young students to go for internship, it does nothing to actually get them placements, with the result that these young students, and as the survey points out, more than 80% of first generation lawyers have actually no way of finding out or getting placed appropriately, resulting in all kinds of harassments happening and not getting the right mentorship which they deserve at the very start. So those are much bigger issues, but probably with the Chief Justice of India here, I thought I'll use this platform for that limited purpose of how to help him achieve the target of ensuring 30% women are judges. Now, sir, as you will be noticing the present system, the collegium system, you are looking at the people who argue before you. They are the face before you. And you feel that this lawyer did a good argument, and you call him, that why not consider him for elevation? But what you don't see, that that argument firstly is more for being made a senior advocate in due course of time rather than becoming a senior, because as judges, by the Advocates Act, you make seniors also. So you decide in the profession who will go as a senior and who will come as a judge. Both decisions are to be taken by you. So the ones arguing before you are more capable or more likely to be good senior counsels in the long run, because that also is the need of the profession. But the lawyer assisting the senior many a times is completely faceless. Most of the hard work may have been done by that lawyer who has done the drafting of the brief, who has done all the research, who has briefed the senior, and the senior, probably because he agrees with what is being briefed by him or her, ultimately goes and does the presentation. Now that segment of the bar is still today completely unnoticed as far as elevation is concerned. I think that segment of the bar will be, sir, good enough to give you a full 30% which you want to achieve. And I can assure you that the women in this profession, there are a large number of lady advocates in the law firms, litigation law firms, who regularly brief senior advocates or draft matters or appear in matters. There are a large number of lady advocates who practice in Supreme Court, who do not come to argue, but do the entire homework as far as the preparation of the brief is concerned. There are a large number of advocates who ultimately do the whole strategy, planning, research, the entire homework which goes in the final presentation, which you actually only see. You see only the final presentation, which is by that mouthpiece who's in front of you, who may be a senior or may not be a senior. If you, sir, start identifying that pool of women lawyers, I am sure, sir, you will not have a problem of achieving the 30% target that you have promised for yourself and promised us in the recent past. The problems of women not making it in this profession, in my view, has no justification, apart from, of course, these attrition issues. I was just talking to Aishwarya Bhatia in a very interesting conversation we just struck while sitting on the dais. She said, when you were struggling as a lawyer, what kind of a role did your wife play in your progress? Did she not make sacrifices? Did she not take the children to the hospital? Did she not attend the parent-teacher meeting and you could not go? I said, yes, it is absolutely true. If she had not been there, I would not have done what I have done. How many husbands are ready to do this job, or the family members of a woman is ready to do this job, to take over her responsibilities to ensure that she thrives in this profession? Now that's the mindset which needs to change. That is something which is a social issue, I will say, a cultural issue. You feel that a woman is supposed to look after the children, she has to do the cooking, and she's also supposed to go to work. And obviously, since all of it is her job, you don't expect anybody to help her in any of those. Now that's also, I think, a very important point, and I think the Honorable Chief Justice of India, in a recent matter, I think which was listed this week only, has taken the concept of paternity leave. That why not the fathers should also be taking leave and taking care of the children if the woman is working, and why should this concept also not be encouraged? So I think these are very, very important debates, and I think I would only beseech the Honorable Chief Justice of India, and also because we are a channel and we have a couple of Chief Justices also here, and I'm sure we will be able to reach out to the other Chief Justices also, that if they start this identification process of looking at the faceless people in the system so far, the faceless people in the system, I'm sure achieving this target will not be a problem. And I end only with one small note, that where in the lower judiciary, the selection is purely by merit, which is by a competitive examination and by a interview, women are more than 40%. So it is not as if that they can't compete if they are given a proper, appropriate opportunity. So obviously in the collegium system, there is something lacking as far as looking up at the right merit is concerned. And it is that merit criteria which is lacking in the collegium system can be easily corrected if the collegium system is ready to move out and look at people who are so far unidentified in the system. Thank you.
I will now request my colleague, Mr. Ashok Panigrahi, Senior Advocate and Senior Executive Member, SCBA, to take forward from here.
Good afternoon, everybody. Now, what would be a better time to speak on this, because the Navratra is on, so we are speaking on women and law. In fact, I would start the discussion. I wouldn't say much. I'll just start the discussion from the Chief Justice. The Chief Justice was shared with the report as of now. So what would be your views or the key takeaways which you think that we could bring in?
See, first of all, I must congratulate the team of the women lawyers whom the credit goes for preparation of this very authenticated document. That no, SCBA provided a platform, but credit goes to the women lawyers who really, of course, along with the team of and full cooperation of the office bearers of the SCBA. It was really a very remarkable and a very scientific survey, I would say, that has been conducted. And the documentation based upon the voices of the women in legal profession, I think that's a very an excellent eye-opener, and it also provides a roadmap that how we identify the challenges and their solutions. If you come to page 15 of the report, you will find the priority theme. And I'm very happy to see that how minutely a very good, excellent crystallization has been done of the different challenges and different issues which the women lawyers face in profession. The brief details you will find on page 14, but before coming to page 14, I will refer to page 15. If you will see, the first item is equal access and equal opportunity. The best part of the report is that it merely does not flag the problem or the issue or the challenge. It also tries to respond to it, that what can be the effective response to that. And the answer given is, and the gender-based discrimination in work allocation, briefing, and empanelment. So speaking on the very first item, I personally believe that when we talk of equality within our constitutional framework, this equality is not merely on papers. So the equality has to be translated into the lived experiences. And for that, we have to take the initiatives at different levels. What has happened is that nowadays, 2-3 things are very encouraging. One is that when you go to the national law universities, the national law schools, even our conventional universities where the law departments are there, it's very encouraging to see that more than 50% students are our girl students. That itself shows a very strong foundation and symbol and visibility of the women in legal profession. That shows that how in the women groups, that how the society is now encouraging that our girls, our daughters should also now come to the legal profession or the legal world, maybe that eventually they go to corporate or they go to judicial services or they eventually join the profession. But you will also find that there is, from last at least 10 years, that there is a very encouraging, very positive and very optimistic approach when you will see the entrance into legal profession. So if you go by the static of enrollment every year, you will find that a lot of women are getting enrolled as members of the bar. Let's ignore the conditions of requirement of practice of 7 years to become an officer in the higher judicial services or a particular length of practice for the purpose of becoming a judicial officer. I am not on that point. Even before these conditions, there is a very growing trend last couple of years that the women are joining the bar. The problem starts after that. So you have a lot of equality at the entry level, whether it is the law schools or the profession. I think question is that are we able to maintain that equality at the subsequent stages of progression in life, progression in professional life? How many ultimately women are surviving in the profession? Not as many those who really joined, and a very small percentage of those eventually ultimately leads the true professional life in the law. So maybe that couple of them, a good amount of them will settle down at different stages. There are several factors for that. Maybe this one session may not be sufficient to discuss all those challenges. But my main concern is that let us identify the issues, the challenges, the impediments, the roadblocks, which are eventually at a later stage in the profession are denying the equality part to the women. And once we are able to identify those challenges, then we need to resolve and find out a way out that. Say some of the way outs can be that why the women are not continuing in profession. Because the profession has very odd hours in working, because how many litigants are not entrusting their briefs, or the seniors are not providing them the adequate junior fee. These are our multiple factors, and we need to resolve. One or two or three quick solutions which I always find is that in the government empanelment of advocates, let us ensure, let's not go by 30%, let's be at least 50% women lawyers should be empaneled as government counsels. That can be one beginning. The second beginning can be that in the legal aid panel council also, at least 50% should be the women counsels on the legal aid panel. This is how you get a platform, an opportunity to show your worth in profession. This will also give you some element of stability, and ultimately if you prove your worth as a government counsel or as a legal aid counsel, I am quite sure that in due course of time, the private client will also catch up, and the talent never hides, whether you appear either of the side, and they will be really and ultimately be able to establish their private practice also. If you sustain in profession, if you continue in profession, the second, third stage comes the judicial services. Now we have very encouraging facts and figure as far as the entrance level judicial services are concerned. Today we have almost 50% women judicial officers on pan-India basis. There are some of the states, I personally know some of the states are there where are 60% officers are now, those who are being recruited are women judicial officers. But on average basis, 45 to 50% judicial officers throughout the country are now the women judicial officers. They will eventually become the district judges. When you are district judges, then you have a share for the elevation to High Court. So the face of the High Court is also, you will find some of the High Courts like Punjab and Haryana High Court, there are 18 women judges, and thanks to only because of that initial stage, they joined the judicial services, they were able to become district judges, and many of the district judges have eventually, based upon their hard work, seniority, competence, merit, integrity, and they have been able to now make to the High Court judges. I think this is how there is a long drawn process, a part of which, a big part of that battle which we have already successfully won, and only a small part leaves to ensure the gender equality, where I think all the stakeholders will work together, and these, the issues that have been identified in this survey, like formal reservation and representation, I have already flagged this issue that in legal aid council, in government empanelment, we can ensure that. Mentorship and structured guidance. I think senior members and the male members of the bar need to work on it. This can be a very effective way out. Financial support in early years. We can create a corpus. I think we can persuade the Government of India, state governments to create a corpus which should be only meant to help the women lawyers, particularly during the period when they are required to go on maternity leave. There should be a dedicated professional assistance as honorarium that should be made available to them, for which the states can initially come forward to create that corpus, and slowly we can find out another mechanism to keep on adding that. Maybe that there are other ways and means that we can create that part. Now this maternity protection and returnship, this is extremely important. This kind of protection must be provided in the profession, or of course in judicial services, or in the private sector, this facility is available. So there is no reason that why it should not be there in profession. Safe work environment is another very important factor. I think this is extremely important because the legal profession, the working hours are quite odd. Normally, during the court time, you are in the court, and in the evening you have to work in the office. So it's a profession which demands late hour working also. So this safe work environment is also a very important factor. Child care infrastructure. I see no reason that in every judicial court complex, in every high court, there must be a child care center, there must be a crèche, there must be a child room, and this kind of facilities we must provide. I can assure you that I will take up the issues with the 3-4 Honorable Chief Justices are very much here. I will take up with all the high courts to make sure that this kind of facility is made available at all the places. Now this item 9 is again very, very important, very sensitive, but unfortunately those stakeholders I don't find here, the Bar Council reforms. I would have really appreciated if they were also here. There are a lot of reforms required there at their end, the term limits, transparent elections, but as you will find, and it should not be any individual credit, but the Supreme Court has, as an institution, come forward in ensuring, at least if not fully effective, at least some substantial representation in the bar associations and in the Bar Council. You are well aware of the recent time the orders passed. I am quite sure, though my feedback in last 2-3 days was that there are some attempts even to frustrate the order the court has passed on judicial side, but that we will take care of that. But the point is that there is now an initiation, there is a beginning, and that beginning must result into more than what we have expected through the judicial orders. And I am quite sure that all of you, with your proactive role, will make sure that this institutional representation is ensured at all levels, right from the Taluka Court up to the Supreme Court in the bar associations, and of course at every level in the bar councils also. Judicial exams I have already shared with you. The representation by our young daughters, the women candidates is is absolutely encouraging. It's very delightful to see that most of the meritorious position, in fact, because of their hard working and their dedication, their commitment, that they are gaining this position. And overall, infrastructural issues are also, if effectively addressed by all the stakeholders, particularly the state governments and the central government, for this purpose. If someone will recollect that in recent times, in fact, when I went to Uttar Pradesh for the foundation stone of a couple of integrated judicial court complexes, and after that, at wherever place I have gone, I have always said that not a single judicial court complex is acceptable to us unless it provides dedicated, separate infrastructural facilities to the women members of the bar. And that is what I have publicly announced. And I can assure you that that commitment as an institution will continue there, and we will make sure that these facilities are provided. So this report itself, to my mind, is a guide, is a guidebook. It's something it really should hold as a smaller mini constitution for us for the women reforms, and we should follow all the analysis done it, and it can really work wonder in ensuring that we are able to, if not completely eliminate right now, in due process of time, this gender discrimination is completely eliminated, and we are able to achieve what the Constitution envisages, the principle of equality. Thank you very much. Thank you.
Thank you. In fact, the Chief Justice has dealt with the whole issue. In fact, there were 10 pointers in this. He's dealt with all the pointers. So in fact, it would also serve as a closing remark for me, because now all the pointers have been dealt. If I could now just ask Madam Aishwarya Bhatti that we'll just have one single question, so because we are running short of time. Yes, if I could just ask her that what steps would you suggest for young female advocates, especially first-generation lawyers who do not have mentors in litigation, given the fact that this presents that around 83% women are all first-generation lawyers. So what are these which you would suggest?
Well, I think my suggestion would be that you have chosen a profession which has been a male bastion for far too long. So get ready to roll up your sleeves and jump right in, because even the male lawyers don't have it easy. Hard work, honesty, and humility. I always believe these three capital H's is what is required for any lawyer to make a way for himself. I think we should consider ourselves like farmers who are going into a field which has not been tilled for a long time. It's going to take a lot of hard work. It's going to take a lot of dedication. And I also feel that courage in the legal profession is not the roar that you hear on the podiums in the courtrooms or in the corridors. A large part of the courage in the legal profession in litigation is the meek assurance to yourself at the end of the day that I'm going to try again tomorrow. So you don't give up. You just go on and on, you don't give up. And from a personal experience, I can say that when I was a young lawyer, many clients used to speak in their local language in front of me and say, "Ye to ladki hai, ye kya kar legi?" But when I became an ASG and I told my clients that I had to give up the briefs as a government counsel, I will not be able to do their matters, the reaction from 99% of my clients were, "Can you suggest a good woman lawyer? We believe women lawyers are very dedicated and sincere." So it's really up to us. And one additional thing that as women we need is, we need to have comrades in arms. We need a band of brothers, so to speak, in blood, from our family, from our mothers, from our brothers, from our sons, from our husbands. Like I was sharing with sir, that law is a jealous mistress. Now, it is easy for men to keep jealous mistresses. It's not easy for women to have jealous mistresses and be accepted at home. So have a strong network of your friends, family in robes. Look for friends who are older to you, younger to you, and don't look for only gendered friends. Many of my colleagues here are like elder brothers, younger brothers, father figures. So you will get help from all quarters if you be on the journey that you have decided for yourself, and don't give up no matter what.
Thank you, Madam. May I now just ask Justice Bhakru, what is it that you feel would be a singular pointer which would go towards inclusivity of women in the legal profession? Since we are running out of time, so sir, I've made it short.
I'll make it short. The systemic problem that we have, really, we must recognize in this profession is that it's an unstructured profession. So when we talk about the part that the women will play and how much can we allocate to them, we presume that there is a structure in which we can allocate. So the first and foremost, to begin with this, is to have a more structured profession. And I'd like to make it short. We have parallel professions like that in chartered accountants where you find far more structured practitioners than we have in law. As the profession matures, I'm sure this will happen. It's already happening. Second structural thing, I think, is the very nature of the times will thrust on us. The fertility rate in the southern states has dropped below 2.1, which is regular to maintain the population ratio. So in Telangana, in Telangana, for instance, it is now 1.6 or 1.7. The translation to that is that in the Viksit Bharat dream that we have of 2047, 29% of the population will be senior citizens in that state. It will compel the younger population, that is the rest of them, to put their entire might to support this. And therefore, automatically, women will have a larger role. It can't function otherwise. Third thing, which I said, which is, I think, singularly more important and more down to ground that we can do, is to have that structure in place, crushes in place, variable hours in place, and any other support that we can give structurally in the court for women. I think that goes a long way. They anyway multitask, so we have to really recognize the fact that they're not one role that they're playing, they're playing several roles. To mitigate the load they have, this is the minimal that we can do. I think that will go a long way in inclusivity of women.
Thank you, sir. Thank you for your inputs. In fact, actually, it's what we are all talking about here is we are talking of change. So now that we have started talking of change, change will happen. That's what we all, in a system of hope that we have, change will certainly happen. And if change happens, then the structure would also come into place. And then, as you were saying, we would do embedding of things in that structure, which would make things maybe in days to come a little better to roll.
Yeah, it's a natural progression. It has to be. There's no other way out. And like I said, there is a good example of what's happened in the accountancy profession.
Yes.
You had individual ad hoc, two-member firms, mom and pop shows. They've all almost vanished. Now you have large structured firms. I'm sure law as a profession will follow suit. Once that happens, then it's simpler to put in structure a place to say that women have a larger role or a significant role or a proportionate role. But today when it's such an unstructured profession to begin with, then to contemplate to say that we'll have some allocation. You can do so in structured areas like panel lawyers or like the Chief Justice said as far as associations are concerned, councils are concerned. But the bulk of law is outside that. So how do you get them in? You have, for example, if you look at the report, women saying that we don't get briefs.
Yes.
Well, as far as male law is also concerned, they don't get briefs. The client chooses once in a while to give them one brief, and their specialization goes in that way. We've all have struggled that way. So it has to be a societal change there. That you can't impose, come what may. But you can only impose a structure that is available so they can devote more time, and hopefully this will progress. You're right, changes don't happen overnight. It'll take time. It'll probably be a metamorphosis more than change that we can contemplate. But the fact that we are talking about it today, the fact that it's, my SCBA has got so many people assembled here for this, this is inevitable. It has to happen.
Thank you, sir. Now, could I just ask Madam Shivaraman, Justice Shivaraman, to give a bit of thoughtful insights, because as a lady judge, she's come up here. So what is it that you think that would be regarding maternity protection and returnship, because returnship is something, because motherhood can't be a penalty. So what is it that you think that women should, or what is the returnship thing? Because if people do not return back to the profession after motherhood, that is in fact then you're losing a lady lawyer, you're losing somebody who's who would have been an asset to the system. So what is it that you think on that count?
Let me start by just thanking the organizers for having me here as a part of this panel. So when we are talking about the problems faced by women lawyers, especially about maternity and returnship, I feel that what is required, like Justice Bhakru just said, this is a very unstructured place where it is very difficult to enforce any of these decisions. When you say maternity benefits and returnship, well, how do we enforce this in these small offices where there are maybe 4 or 5 people? So in a small legal practice, the question of replacement is something that the practice cannot afford not to do. So if somebody is going out for an extended time, there has to be a replacement, because otherwise the practice cannot continue. So coming back, there has to be some kind of a structured situation where there is something to come back to. So if you're working in a one-man or a two-man office, what do you have to come back to? So therefore, the structure is something which is extremely important, so that there will be a space for the woman to come back to and to continue with her profession. I'd also like to put a small question with regard to the survey. The women who are dropping out, have we found, are they actually going away completely from the profession, or is it only the legal actual litigation that they're going away from? Are they returning, and are they able to...
Madam, they're returning back. When they return, they are not at the same position while they would have left the profession. That's the point.
So they're returning to litigation itself?
Either they're going for higher studies,
Okay.
so they take a break,
Okay.
or they are at home because of motherhood.
Okay. Okay.
Or
Thank
some
you.
other
Thank you.
personal difficulties. But
Thank
they
you.
want to come back.
Yes.
They want to come back.
Yes. So the coming back aspect, again, there has to be a structure for the woman to come back to.
And the difficulty is being high-tech in the meanwhile, because the e-filing, etc., is proving to be a stumbling block for such lady lawyers.
Absolutely, absolutely. So, as a woman lawyer who started practice in the last century, let me tell you that maternity break was something that was strange to us, because my maternity break was 40 days. So that was the ecosystem that we worked in. We did not have that option of going out, because if you went out, then you didn't know what would happen when you came in. So that we did not take that option. But then how did we manage? We managed because everybody stepped up. The family steps up, the environment around you steps up, your friends, your society steps up. But do we let go? That again is a problem. It's also a question of attitude. Well, if there is somebody to look after the child, do you let go? I find it difficult. I did find it difficult because I wanted to do it all myself. This is with regard to this finding about being underpaid as well. Yes. Why are we underpaid? Are we less competent? No, we are not less competent, but we want a lot more from our professions than money. Yes. We want satisfaction. Yes. We want all that, I think, is the reality of this profession. Thank you.
Thank you, madam. Thank you for this brief and nice insight. Now, if I could just ask the Attorney General, who's on the dais, as to give his concluding remarks, in fact, before we give the closing. And sir has a, sorry for interrupting, sir has a poem which also sir can.
Before I read that, I want to enliven the audience. We spent a lot of very high, dense, intellectual, arguments and debates. So I want to imagine a couple of things today. I want to imagine that I am sitting in the Lok Sabha, I am the Speaker of the Lok Sabha, and all the women participants here, including the honorable judges, constitute the treasury bench, and I'm going to ask you to vote in favor of the survey. You will raise your hands. So that's going to be the greatest moment for this survey. When women vote in favor of all the opportunities that ought to be made available to men, women, that will be a great moment in the country's life. The second imagination is, I imagine myself that Aishwarya Bhatti is the Attorney General, that I am only the additional Solicitor General.
Yes.
And they will certainly go and stand by your side and say, can I be of any assistance to you? That's the kind of imagination we need to have. We're just talking about the Chief Justice. Let us reimagine many things. From a reluctant ecosystem to a tolerant ecosystem to a more conducive ecosystem to an embracing ecosystem. We need to go from reluctant to ultimately to an embracing ecosystem. So all these, the survey is a great and a wonderful moment in the SCBA's history, and I'm sure that we'll be able to take it forward. Finally, one more, lighter moment. I suppose I write a letter to the Government of India saying that this survey is an important milestone in understanding women's position in the legal profession. I want to take quick action on that. I will also say that the Attorney General in India has never filed any petition as a litigant. I do not mind filing a petition in the Supreme Court while asking Chief Justice will take a suo motu action on this survey. I don't mind filing a petition in the Supreme Court and saying I'm arguing on behalf of the survey. I don't mind doing that. So I thought this is a wonderful opportunity for each and every one of us to relive our own thought process, to check, to scan, or how do we think on many of the important issues. I mean, it started in the morning with mediation. We looked at how the courts face enormous number of problems and handicaps and challenges. So unless we start imagining how to rethink, how to do a rethinking, fundamental rethinking, I don't think we'll have answers for all this. Article 15(3) says special provisions for women and children. All the 10 facets at page 19 are nothing but equal opportunity and equal access. Every one of them are facets of equal opportunity. Let us vote in favor of page 19. Right? Finally, I thought this morning, as I was thinking about the theme for the evening session, I penned a few words. Let me read it out. If it meets with your claps, if possible. Just for I titled this, The Weary Traveler. It's as if a woman is talking to all of us. How do I share the stress I bear on many friends with smiles on my face? To be a woman is being more than a man. All attachments that I carry are stories that I marry. No task of human care is alien to my mental wear. In hospitals, I am your homely care. In schools, I am your mind-filled care. In cleaning roads, I am your social care. In TV chats, I am a daring chair. In crushes, I am a motherly care. In armed forces, I am an equal dare. As a pilot in sky, I take due care. With my gentle teams and smiles they wear. Any task I hold is no great deal. At home, I am an all-tool wear. From morn till night, all duties done. In courts, to plead or judge in all I do, a weary traveler should I be, and wait for justice to land in whim? All I need is the weeds of minds to be cut and trimmed, that I walk with shoulders burdenless and beg not for what is due. And the caravan of my life is lit more bright, its wheels too carry many smiles. Thank you.
Thank you, sir.
Now I'd like to just end with a small conversation which I had with Sri Ram Panchu yesterday.
Please, sir.
So he was informing a very interesting thing which had happened in the Madras Club. So after probably 100 years, Madras Club elected a committee member. So everybody questioned that how did this happen? I mean, how did you achieve this, getting a woman into the committee? So he said what happened really, what behind it was that all the influential members of the club, some of their wives ganged up and they said, if this woman is not getting elected, you are not coming back home. And that made that election come through. So we have to look at such solutions now, actually, to ensure that women really get the true place that they deserve in the system. Thank you.
We are thankful to the whole dais, on the dais, off the dais, and for being part of this session. So now, the closing remarks, I won't take much time. The Chief Justice has given a wonderful closing remark. In fact, at the beginning itself, he set the tone. The whole survey shows raw data which can be transformed into action. But then it would beg a small little question, that is the bar ready? Certainly the bar is ready. There are people all here. There have been toppers, there have been lady toppers, as both in exams, judiciary, and everywhere. So in fact, what we are all doing is we are navigating through a 19th century system. Hope we would, the systemic changes which Justice Bhakru said, and Madam Shivraman, and even Madam Bharti said, that in fact, if you have thought of coming into the profession, jump into it. So certainly, this would be a good clarion call for all of them. So with these words, I wind up, and I would just call upon for the felicitation which is to happen for Honorable the Chief Justice. Sorry, I'm extremely sorry. The Chief Justice of India would have the closing remark.
Probably, normally when Ashok argues cases, he is always right. But today he is not right that I have closed my final comments. I reserve my final comments. You know, the very fact, the success story lies in the fact that on a public platform, in public domain, we are now seriously deliberating on these issues. I think that itself is a sign of success.
Yes, sir. Agreed.
I must congratulate Mr. Vikas Singh and the entire Supreme Court Bar Association, the Executive Committee, for taking this initiative. Particularly when male office bearers coming forward and raking up this issue concerning the women members of the bar, our daughters, our law students, I think is a very welcome step. It's a very salutary step, very progressive and very pragmatic approach, for which again they deserve to be congratulated. This deliberation should continue once the stakeholders will discuss the issues which have been identified. I am absolutely confident we will find out the further solutions also. With all these best wishes, thank you very much.
Thank you very much, sir. Thank you. Could we just call upon...
May I request now Mr. Vikrant Yadav, Treasurer, to come forward and felicitate our Honorable Chief Justice of India, Justice Surya Kantji. May I now request Rohit Vats, Member Executive, to come forward and felicitate Mr. Justice Vibhu Pakru, Chief Justice, High Court of Karnataka. Madam Samta Mishra Pushkarna, Member Executive, is requested to come forward and felicitate Mrs. Justice Anu Siva Raman, Judge, High Court of Karnataka. Mukesh Kumar, Member Executive, is requested to come forward and felicitate Mr. R. Venkatramani, Senior Advocate, Attorney General for India. May I request Gaurav, Member Executive, to come forward and felicitate Mr. R. Venkatramani, Senior Advocate, Attorney General for India. I would now request our Madam Secretary Pragya Baghel Madam to come forward and felicitate Ms. Aishwarya Bhati, Senior Advocate, Additional Solicitor General of India. request Smriti Madam now, Member Executive, to come forward and felicitate our President, Mr. Vikas Singh Ji. I'll request for a group photograph now. The entire EC members are requested to come forward.
Now, can I request all the delegates to come outside for a group photograph with the Honorable Chief Justice of India, because he's leaving, and all the speakers also, all the speakers and all the delegates. Can I request everyone, please, to join us for a group photograph? This is our first national conference, so this photograph is something which we will all be treasuring in the years to come.
Check, check, check. Hello, hello, hello. Check, check. Check, check. Check. Check, check. Hey, 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 hey. Check, check. Check, check. Check, check. Hello. Check, check. Hello, hello. Check, check. Hello, hello. 8. Check, check. 6. Check, check, check. Hello, 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 hello. Check, check. Check, hey. Check, 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 check. Hello. Check, check, hey, hey, hey. 1, 3, check. Check. Check, check, hey, hey. Hey, 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 check.
Yes. Okay. All of you. Okay. All of you, please smile. Yes. Done. Okay, now with cheers. Yes. Gentlemen, little back. All of you look at this lens here. Here, smile. Smile. Yes. Yes, now cheers. Thumbs up, thumbs up. Thumbs up. Thumbs up. Yeah, thank you. Thank you. Thank you. Wait. Kimbal ले लो पहला. हाँ जब तो लिया. Yes sir, please look here. Wait. Smile please. Yes. Yeah. Thank you. Okay. All of you please smile. Yes. Done. Okay, now with cheers. Yes. Gentlemen, little back. All of you look at this lens here. Here, smile. Smile. Yes. Yes, now cheers. Thumbs up, thumbs up. Thumbs up. Thumbs up. Yeah, thank you. Okay, now with cheers. Yes. Gentlemen, little back. All of you look at this lens here. Here, smile. Smile.
As we are all aware, this is the fourth and last session of the day. The topic is panel discussion on first-generation lawyers and access to justice, addressing institutional barriers in the Indian courts. Broadly and at a glance, we may figure out few challenges with the topic, and which are lack of mentorship and guidance, limited professional network, financial instability, courtroom confidence and exposure, difficulty in getting good chambers, social and cultural barriers, knowledge gap in practical skills, client trust issues, work-life imbalance, and stress. Thereafter, we go on to introduction of our panelists. Although our panelists require no introduction, but since this is a formal ritual, we have to follow it. You all know them, and their reputation precedes them. Honorable Mr. Justice Arvind Kumar, Judge, Supreme Court of India, who assumed office on 13th February 2023. He is a former Chief Justice of Gujarat High Court and former Judge of Karnataka High Court. Honorable Mr. Justice Prashant Kumar Mishra, Honorable Mr. Justice Prashant Kumar Mishra, Judge, Supreme Court of India. Before being elevated to Supreme Court, his Lordship was the Chief Justice of Andhra Pradesh and Judge of Chhattisgarh High Court.
Honorable Mr. Justice Harish Tandon. Honorable Mr. Justice Tandon is the 35th Chief Justice of Odisha High Court. Before taking oath as a Chief Justice, his Lordship was the Judge of Calcutta High Court. Honorable Mr. Justice B.R. Gavai, former Chief Justice of India, being elevated to Supreme Court, was the Judge of Bombay High Court and also served as Chancellor of many NLUs. I would like to inform members of Supreme Court Bar Association that for the first time, thought of having committee to address the concern of first-generation lawyers, and we collected some data. More than 650 advocates said that they are the first generation and require some institutional support. Accordingly, SCBA organized 2 advocacy training programs for young first-generation lawyers. One was conducted by Ms. Priya Hingorani, senior advocate, and fortunately she is present here, and her team. And the other one was done by Bombay Bar Association. This SCBA is working towards providing necessary hand-holding for young and first-generation lawyers. Now I invite Mr. Vikas Singh, President, Supreme Court Bar Association, to kindly moderate the panel discussion. Thank you.
Welcome everyone. First of all, I'd like to thank Honorable Justice Gavai, Justice Arvind Kumar, Justice P.K. Mishra, and Justice Harish Tandon for participating in this session today. Now, in some ways, the earlier session also is linked to this session, because what we discussed in the session for women, we saw that there are 83% of women coming in this profession who are first-generation lawyers. But we could not have merged these two subjects because these subjects are very different, and there are a lot of men who also come as first-generation lawyers, and I am myself a first-generation lawyer. So we have on the panel mostly first-generation lawyer, except Justice Tandon, who is a third-generation lawyer. But I must inform all of you, and that's very, very important, that Justice Tandon, even though he's a third-generation lawyer, he was given the privilege as if he was a newcomer in the bar. And that is what I think is very, very important. I also, when both my boys wanted to join the profession, I never let them work with me. And I think that is the reason why both of them have independently established themselves. And that is the importance of being a first-generation lawyer. And there are, of course, huge struggles of a first-generation lawyer, because there is nobody in the family to guide them as far as the initial steps are concerned, and accordingly they have to depend on proper mentorship. And if they don't get proper mentorship, then they face many problems. So I'd like to start with Justice Gavai. Justice Gavai, how did you firstly decide to become a lawyer, and secondly, what were your initial steps that you took to establish yourself in the legal profession?
As I already said on many occasions, that it was not my choice to be a lawyer, but it was my father's choice that I should be a lawyer. As a matter of fact, he wanted to be a lawyer, but he jumped into politics and social movement during his student days, and when he had to appear for law examination, he was in prison, and therefore I think he wanted his wish to be fulfilled through me. And I think I must thank him for that decision. Insofar as challenges are concerned, I see that many young generation lawyers, it's difficult for them to find a chamber. And particularly if they are coming from rural areas, if they don't have any standing, if they are not known to the established lawyers, it's difficult for them to initially find a chamber. And unless you find a chamber, because the chambers, they provide a platform for learning, because nowadays the legal education has undergone a drastic change. But when we passed out from our law schools, it took around 6 months to understand that you have learned nothing in the law schools, and the learning starts after you start with the profession. So insofar as I am concerned, I did not face that challenge, because my father was established political leader, and when I started practice, he was in Mumbai as a Speaker of the Assembly. And I found a good chamber. I'm grateful to my senior who gave me many opportunities in the earlier days. And but I've seen many lawyers who used to come from the rural background, because I started initially in Mumbai. It was difficult for them to get good chambers. But all those who got good chambers, who were nurtured by their seniors, I'm happy to say that many of them became the High Court judges, many of them have been designated as a senior lawyer. So according to me, the first challenge for a first generation lawyer would be to get a good office. And unless you get a good office, you don't get a good mentorship. The second aspect I would also like to address on is that after 5 years of practice at Mumbai, I shifted to Nagpur. And Mr. Manohar was the then Advocate General. And he insisted that I should join the Government Pleader's Office as an AGP. And since he was my father's good friend, I had no choice. But within 1 year, I got such a wide experience in the Government Pleader's Office. Because as a young lawyer, you may not come across many such litigations which we get an opportunity to handle in the Government Pleader's Office. So I continued there only for 1 year, and after that I resigned. But I could argue many important matters before the stalwarts, against the stalwarts at that time, including viruses of various legislations, viruses of the regulations for medical admissions, engineering admissions. During those days, the litigation was at the peak. And I therefore feel that if the first generation lawyers get an opportunity, even in the Government Pleader's Office, or as was said by the Honorable Chief Justice with regard to women lawyers, as a legal aid councils, that will be a good boost for them. They will get a good platform for learning so that they can progress further. I'm really grateful to the Supreme Court Bar Association and Mr. Vikas Singh for organizing this conference and taking up this issue. When I was in Bombay High Court with the Bar Council of Maharashtra and Goa, we have attempted to do in this regard. We used to have continuous legal education program for young lawyers, and periodical trainings used to be held. Sometimes the trainings ranging over for a week or so also. So with the initiative of the Supreme Court Bar Association, I think we can plan something on the same lines on a pan-India basis. Thank you very much, Vikasji.
So it's a very interesting moment in the history of the Supreme Court that we have two successive Chief Justices who are first-generation lawyers. In fact, Justice Suryakant also is a first-generation lawyer. And actually, when I first discussed this, when Justice Gawai was still the Chief Justice of India, that I want to do something for first-generation lawyers, he was also sitting with me. He said, no, Vikasji, I'll also be in that program. And he would have been there and if he had not to go suddenly for this other program, which was requested by Justice Nagaratna, and he was ultimately, he had to... And both of them are from agricultural background. But one point which Justice Gawai made is that he got a very good mentor's office, very good senior's office. Now, getting a good senior's office is actually almost half the work being done. If you get a good senior's office, then really speaking, there is no looking back. But how many first-generation lawyers are able to get a good senior's office or a good mentor to start with? I would like to ask Justice Arvind Kumar that how would a young first-generation lawyer who's unable to find a good senior's office, how does he go about in this profession? Because that's the bigger challenge we are facing today in the system.
A very good evening to one and all. Respected Honorable former Chief Justice, Justice Gawai, my esteemed brother, Justice Mishraji, Justice Tandon, Mr. Vikas Singh, and Mr. Vikrant Yadav, learned senior advocate, learned attorney general, all stalwarts are here. I would like to just preface it with two instances. Number one, the moment I go to any bar association or any bar function, the first question they ask is, learned members of the bar, sir, how do you feel being a judge and after being an advocate for 20 years? And how do you feel when you come to the bar association? I tell them, I give you a small example. A young girl who gets married and goes to her husband's house, after 2 or 3 months, if she comes back to her parental home, what the amount of feeling of that oneness, that feeling I get it. Number one. Number two, how I became a lawyer. Friends, I am not flattering myself, I am not blowing my trumpet, I am telling you the honest, candid confession in this august gathering in the presence of our, I consider him as my, not only my senior, as my good God-given friend, Justice Gawai Saab. One day I refused to go to school. I think I was somewhere in 4th standard. My mother told my father that he is refusing to go to school. My father came with a scale. Will you go or not? I said, no, I will not go. He said, why? My socks is not ironed. This is the reason I gave. Why I tell you? Then he said, all right, I will iron your socks, and he gave it. He said, no, I am not going because today driver is not there, I am not going, car is not there. He said, nothing doing, you go by walking. Hardly it was about 200 meters or 300 meters. Why I am telling you is, after having brought up in such an environment, I was born in Bangalore, brought up in Bangalore, studied in convent, good educational institutions. Everything was, God was very kind to me. And my father was hell-bent upon that I should become a lawyer. I said, I will become anything, but not a lawyer. So every day, the fight used to start in the morning breakfast table and end at the dining table in the night. So every day my mother used to complain, why father and son should fight? Both of you don't sit together. This was her grievance. But invariably we used to have dinner and breakfast together. So one day I told my father, I will not become, from tomorrow onwards, if you force me, I will not come and have dinner with you. He said, all right. I told him, all right, give me one good reason why I should become a lawyer. He said, wait. He was halfway through. He went, washed his hands, brought his old diary, which was a rubber band. And he opened it and he said, look here. The entire freedom movement of this country was done by the lawyer fraternity. Look here, the first parliament had nearly about 70 members of the parliament members were lawyers. Karnataka first assembly, the assembly members were 60%, more than 60% of them lawyers. If anything good can be done to the society, to the country, it is only the lawyers can do it, and I want you to become a lawyer. And this is how I became a lawyer. And he was my father, he was very clever. So I had told him, he said, you become lawyer for one day, then you don't practice. So first day when he put up the board, Arvind Kumar, advocate, my father and mother both came. My mother put kumkum to that board, and we stood in front of the camera. My photographer flicked it, and he said, from tomorrow, do whatever you want. But he was my father. He was very clever. So he said, all right, do one thing. Just go to the profession. Practice for 1 week or 1 month or 2 months. If you don't find interesting, do whatever you want. Then whom should we choose? So none of from my father's side, my mother's side, no judges, no lawyers, none. So ultimately my father said he had a good friend, family friend. His name was Justice Rama Joyce. So he said, come, he's the only person with judiciary whom I know. I will take you to him. At that time, he was a High Court judge. So he took me to his house and he introduced and he said, look here, I want you to become, I made him a lawyer, so I want him to join a good office. Why don't you suggest? He said his nephew is there, Justice Mr. Subramania Joyce. But he said he's practicing on the High Court, so don't practice on the High Court. First and foremost for a lawyer is Section 26, Order 7, Rule 1 or 317 of CRPC. Go to the trial court. Work for 5 years. Then you will become a good lawyer. Then they took me to my senior, Mr. S. Nanjun Swami, who is no more. I should remember him with reverence. Whatever I am today, it is because of him. The most interesting point will come now. When I asked, sir, when should I come? He said, another 1 week the court will reopen. It will be on 25th May 1987. So he said, you join from that day. Then I asked my father how much he is going to pay me. Then my father just smiled and said, keep quiet, don't talk. So then he asked my seniors, what is that? He is asking some doubt. No, just forget. No, you are telling about emoluments. I know, sir, you will take care. Immediately my senior said, no, now that you have come to learn from me, you should pay me. Of course, it was on a lighter point. And this is how I entered the profession. And after entering the profession, no question of turning back. And he said, look here, Arvind, first and foremost, first day he took me to the association. There is a cooperative society. There was a. It is still there. He bought me one dairy. He bought me one book. He bought me one gown and one band. He said, today is your first day in the profession. This is my gift. Keep it up. May God bless you. And God has been very kind to me. And this is how my journey started. Later on, I will add little more after my co-panelists speak. Thank you.
So that's also a very inspiring life story. Only the small difference that I have with you, sir, that I straight away started in Supreme Court. And I may not be a good example. I don't think that everybody should teach these youngsters to start straight away.
That is why you have become the Bar Association president.
But starting in Supreme Court had its own challenges, and that is what I remember. I thought I'll share. So getting every day Supreme Court, you get new subjects to argue and new subjects to deal with. And even judges of Supreme Court have this problem. They also many a times have not dealt with a particular subject and they end up dealing with that subject in Supreme Court. So practicing in Supreme Court is like doing a master's on a new subject overnight daily. You get a new subject, you can't, even if you're not well conversant with this, you still have to, because it's the last court and you can't take any chance, so you have to do that kind of preparation. I remember when the first time I had to do a cross-examination, because I'd never done cross-examination in my life, so I read a book on cross-examination. I just tried to find out that what is the art of cross-examination before I actually start doing a cross-examination. So that's, of course, a different cup of tea. But one answer which I'm still groping with is, I'll then put it to Justice Mishra. How if you don't get a good mentor, what are the steps to be taken? Because there are so many young children coming into the profession, so many of them. All of them don't end up getting a good, if you don't get a good mentor, what other steps you can do? Because if you get a good, I also got a very good mentor, Mr. L.R. Singh. I worked with him and he gave me some very fundamental basic values in the profession, and which helps me even today. But this is difficult in today's times. In today's times, the children, the new first generation children which are coming into the profession are so many. The volume is so large. If 83% of women are first generation, you can imagine boys would be definitely more than that. So how do they, what is their struggle, if you can help the audience, because that is something which is...
Honorable Gavai Sahab, the former Chief Justice of India, esteemed brother Justice Arvind, brother Justice Harish Tandon, Vikas Singh ji, and Vikrant ji, First come first. Your question. You see, my take is that if you do not have a good mentor at the beginning, that is the best thing which happens to a young first generation lawyer. If you do not have a good mentor, then you strive hard. You work hard. And you see, then you start comparing your mentor with other successful lawyers who are good individuals. And then you strive to do well. And believe me, I have seen first generation lawyers whose seniors and mentors are not, punctual or sincere in their office, and that is the best time to encash and grab the opportunity and show your skill and talent. You see, whenever a young lawyer gets a brief and his senior is not interested on that particular day, it is not that senior would not be interested in the file, otherwise he would not have been a successful senior. On that particular day, something may happen and the senior is not interested in doing that file on that day. And that is the day for the junior to perform. And I tell you, I myself started, now deviating from that question, I wanted to become a doctor. I failed by 4 marks in the medical entrance test. And I landed in my profession. We have 3 brothers. The eldest one is a doctor. The second one was an engineer. So my father wanted, like brother Avrin, my father wanted me to become a doctor, but as the destiny would have been, I landed in this profession. And at that time, I joined the law college, which used to be happening in the evening classes for 1 hour or 1.5 hours. From 7 to 8:30 or 6:30 to 8 was the time. And my father was a good civil lawyer. He told me, day one, I have told this story in Supreme Court Bar Association felicitation function also. On day one, I was given some few khasra, khatoni and that revenue papers. Some new client had come. My father told me to go and trace the title, history and genealogy of this person in the revenue record, how this paper has come to him. And I was, that client paid me 10 rupees. That was on 4th or 5th of September, 1987. So that is how the journey begins. And I practiced for 2 years in that small district court. And one fine morning, I started with an iron trunk in the Utkal Express from that Raigad to Katni and then Katni to Bilaspur, Katni to Jabalpur, and stayed in a hotel for 4 days. I was going to High Court from a hotel. In one hotel I was staying for 4 or 5 days. I didn't have any house, any room to stay. I stayed in a hotel for 4 or 5 days and searched for some house on rent. And 4 days I went to the High Court. And my mentor was Justice P.P. Navlekar. He was my senior. And believe me, though I was son of a lawyer, I may not be fitting in this scheme of the conference deliberations about first generation lawyers. But in the High Court, I was almost a first generation lawyer. And he will never spare me. Justice Navlekar would never spare me if I committed any wrong at any point of time. One day, why I say that there may be not one turning point in your life, there may be 2-3 events in succession or in regular intervals which shape your life. One day, Justice Mr. Navlekar, as he then was, he entrusted me 2-3 briefs in the court of Justice B.M. Lal. Brother Kosi would know it. B.M. Lal's court. His court would start at around, say, 11, and by 11:30 it is over. So then he asked me to seek adjournment in 2-3 matters. And all 3 matters were dismissed for want of prosecution. Your senior is not here, you are not arguing, the matter is dismissed. And that day, Justice Navlekar thrashed me like anything, and he told me that if you are not able to open your mouth, if you are not able to speak in the court properly, then go back to your native place. Don't so. So these are the events which provoke you, compel you, force you, or coerce you to do something in your life which will change the history for yourself. So for our first generation lawyers, I'm telling you that life is always difficult. Whether it is a second generation lawyer, a lawyer born with golden spoon, or a first generation lawyer, life is always difficult at the beginning. And those who are born with golden spoons, those who are fed with files, briefs, and clients at the beginning, will always be at the receiving end, because they don't understand the importance of struggle in life. And one who doesn't understand the struggle in life will be a loser in life. You don't understand the importance of hard work, the importance of toiling, the importance of burning midnight oil. And these events must happen in everybody's life. Otherwise, you will not excel. You will never dream of excelling. If the dream for which a young lawyer eyes fall and aims at is at his lap from the very beginning, where are the dreams? There are no dreams for him. And unless there are dreams, you will not strive to attain those goals in your life. So I always think that though there are difficulties, access to justice, access to client, access to file, access to mentor, and then access to an audience in the court, and access to relief in the court. Those are all access which are meant for young lawyers to achieve. I'm telling you, though I was, again I will go back to my old days. Humility, consistency, endurance, why all these are very important things in life for young lawyers, first generation lawyers is, in 1987-88, when I went to High Court, there were lawyers and the regular clients of my father who used to send me money order of rupees 100 or 150 to file cases in the Supreme Court. And as a young lawyer, you have to bear with those amounts, because that 100 or 150 or 300 rupees, they are not money. With that but small amount comes the opportunity to argue the matter in court. Your appearance in court in your initial days are more important than money. For first 2, 3, 5 years, money is not the thing, but your face in the court, the familiarity which, recognition which you will get in the court when you appear regularly pays you in the long run. And seniors always used to say that don't run after money, money will run after you when you become a successful lawyer, like Mr. Vikas Singh. So, thank you, Supreme Court Bar Association, for giving me this opportunity to speak it out. And I'd say in my court, juniors must be finding that I give maximum audience to a young lawyer than a senior lawyer. Thank you so much.
So this is something which I've always been telling as president of the bar and even otherwise to youngsters, that even if you go in court for a passover, be so thorough with the file that if the judge asks you a question, you should be ready to argue. And I've seen that these are, as Justice Mishra very rightly pointed out, these are these opportunities which will make you get noticed and which will actually take you in this journey upward in this profession. And I've always seen, and just as Justice Mishra said, and I've seen Justice Gawai also in court, Justice Arvind Kumar, when a young lawyer, or Justice Tandon, when a young lawyer is arguing something, especially when his senior is not there, invariably they don't pass any adverse orders. They try to accommodate the young lawyer, try to give him that opportunity. If he's not able to answer a particular question to the satisfaction, they normally give a date instead of passing an adverse order. So that's the greatest opportunity that you get in litigation, when you are holding a brief, even if it is not meant to argue, to be ready to argue when the time comes for arbitration. Now I'll just turn to Justice Tandon. Now he's a third generation lawyer. And when I was doing this survey on who are these first generation lawyers in Supreme Court, lot of lawyers who had parents in the legal profession also said that I am also in a sense first generation lawyer. I said, how? He said, my father is in some civil court in some state, and I have moved to Supreme Court without any backing. There is no mentor here, no godfather here. So if I am struggling in Supreme Court where there is nobody to guide me, then for all practical purposes, I am a first generation lawyer. Now, I would like to get the comment of Justice Tandon of two things. Firstly, that of course, because he himself has literally worked as a first generation lawyer, because he was asked to do everything on his own. But what would you also advise young lawyers of today when they're coming to the profession, that what should be the first baby steps they should take as far as establishing themselves?
Thank you for giving this opportunity. I think the distinguished senior judges, they have already shared their experience of life, of professional life, obviously, and what they have initially passed through. I think everybody who is here in this podium, I think everybody will share that they have at least encountered the same thing in their life at least once or twice. So these are such a things which everybody has passed through and have embraced. But there are another things which I can say apart from the same. As Mr. Vikas Singh has said, that being a third generation lawyer and being a first generation in a court, how you feel a difference. The feeling initially was very humiliating. Humiliating in the sense that when I passed the law examination and wanted to start the practice, I just thought of that I have got a mentor, I have got a big umbrella over my head. I did not have to think about any other things. I have all the resources, I have all the infrastructures, I have all the journals, the books which are required to excel in these professions. But my father was more wiser than he treated me like a fool. That what you have thought of, that you will start your career under me, that is not your, I would say, cup of tea. On the very first day when I went in his chamber, obviously it was there. So he just noticed me, did not utter a single word. He did not interacted with me. He was doing his work, even not noticing that I am there. That happened for 2-3 days. So I was just thinking that what to do. He is not really paying any attention on me, and I have joined, and he knows that I have joined the profession. So as it happens that some juniors, they come and then say, if I am engaged as a junior in the matter, I think my father will be acting as a senior, so he will pay more attention to a case. So if he engages him, so that will be the best. So his case will be taken care of in a more better manner. That was the day, as I'd say, is a turning point of the life. So I went in a most professional manner and said that, sir, I have got a client. I wanted a time for a consultation or a briefing. Give me a time, like a juniors. So he gave me that you come on Wednesday at 4, I'd say around 7 o'clock in the evening, the father. Then I said, okay. Then I went there, sat. Then he says, yes, what is the matter? I just narrated the fact. Then he asked me what to do. A lawyer who has just joined 7 days before, everybody will share that what was the understanding of law, and that too also happened to me. So I say, I think this can be done. Then he just looked at the client and says, if such a junior is handling your case, you are sure to lose and nobody can save you, who does not know even the very basic principles of law. That was the humiliation. Immediately I came out of the chamber. First thing, no objection on the Wakalatnama signed by me. And then I went to another friend of my father and say that I want to start the profession. Then he says, okay, I will take you to another senior. That I was taken there, and he never disclosed the identity that who I am. He simply engaged. He's a young boy. He's coming. He want to learn. Wanted to join your chamber. Please take him. And that is how I joined the senior, who was a great mentor. So what I feel is I was a bit lucky in that regard that I could get the good mentor by an assistance, by a support of any other persons who is known to me. For a first generation lawyer, which I have seen is that the first thing is the chamber gatekeeping is the important, that's the obstacle and the hurdle which every young first generation lawyer faces. Access to a particular chamber is not a very easy task. And taking any young boy, simply looking at him by a senior is also not possible. How to get it? This is where some system has to be evolved, which I believe. There should be an involvement of the Bar Council of India. There should be a program. There should be some kind of a structured program. They should come out of it, where at least all the seniors, they should be, I think, wholeheartedly participating therein and choosing some good young talents so that they can get an access, and the barriers which is already there may not be there. The second thing is there should be, as the Honorable Chief Justice and Justice Gawai, the former Chief Justice of India, also corroborated, that they should also be included into the government panel or as a legal aid lawyers panel. But what I feel is that giving independent charge from the day one will not really help them to excel in the professions. They should also be attached with the senior who is also doing a pro bono job, so that at least both of them, if they appear in a particular matter, they will also get a lot of learning experiences by working with at least a seasoned lawyer who has already spent 10 or 15 years of time in this. So that is what I also feel for a first generation lawyers, the first hurdle is. The second hurdle is the recognition. I must say that every lawyer faces this recognition from the bench. Whenever any lawyer who has a practice of say 5 years, 10 years, I think sometimes he is addressed by his surname by the bench. But sometimes the junior, because the bench, the judge may not know him, is not been addressed in that sense. So that is also some kind of a resentment that comes in everybody's heart or a mind of a first generation lawyer. I think that comes by passage of time. It is not that the judge knows him. It is what the judge has sees his performance and he has shown some kind of the contribution to the legal professions, and that's the recognition which is reciprocated by the bench to that. So for that, you never lose your heart. Remain there. Ms. Aishwarya Bhati, the learned ASG, was saying about a 3H. I could remember two. There's the first is a hard work and the second is a humility. I think I have three other notions. Honesty. That's the three honesty. So I can have three different facets. A lawyer must be passionate about his profession. Unless he has a passion, he can never gain any height or any success in the profession. The second one is the dedication. He must be dedicated to his the work. He must do all efforts which he can to particular case. And unless he shows his dedication to them, same, I think that will not. And the third one is the inquisitiveness. The two words I always carry with me, that where and why, the two W's. Each senior says it happens like this. Then the first question is, where do I find this? First you go and find it, and then you ponder upon why it is so, why not like this. So that's the greatest advantage of the first generation lawyer, that their mind is still very fresh, and they have very, very innovative ideas which is really circling around their mind, and sometimes that shapes the new law and the new theory and the new principles that would come. So that is why I also feel that that's the greatest advantage of the new generation lawyers as well. The second story, I must say that what is the disadvantage? The disadvantage I feel is similar, but in a different form or a variety. As a first generation lawyer, nobody recognizes you. Nobody tell you anything. You are just roaming around the corridors of the court, roaming around from the one chamber to another, one court to another to see it. But the second, the major hurdle with the second or third generation lawyers they faces is a humiliation again, or trolling by some of the persons, which I faced when I was hardly having 1 month of practice. I was just walking on the corridor. There was one gentleman who just stabbed me and say, brother, are you a grandson of such and such or a son of such and such? I said, yes. Oh, I have seen your grandfather. I have seen your father. You are not like him. So I say, sir, if you pardon my impertinence, if I say something to you, they say, yes, yes. Then I say, you have seen my grandfather when he has already 50 years of practice. You have seen my father when he has already 25 years of practice. Sir, I am in practice only 1 month. Do I not require 25 months to be compared about? That comparison cannot be done like this. So this is also sometimes the trolling, the humiliation that really face the lawyers. And the second thing which always grappled in the mind is that do I become or justify what my grandfather or a father has achieved in their professional career. This is what is also carried throughout to become. I always think it was a first generation, as Vikas Singh ji said. Definitely I considered myself as a first generation lawyer, and I was treated by my senior like the first generation lawyer and never. And the second thing which is very important is that you will get only one or two opportunities in your life, which I can share that there was one matter which was given. I had two seniors above me, so I was a bit complacent that when there are two seniors, they will be arguing, I will be sitting and getting some money in the form of a fees and going home. But as is usually done, I just went through the files. And then I just read it, but not so carefully so that I have to argue. And that was a special bench where both the seniors, they were engaged in another course. And the bench was sitting only for that matter. Then the bench said, you start. And that was a day I get an opportunity to start. And then I started telling the facts. And I still remember that I have to spend time and how to keep the court busy. So there was a case regarding the interpretation of a lease deed. The intention has to be found out. Then I started with one line that in order to interpret any document, an intention is to be gathered from there. It is better to read the document as a whole and then to find out the intention. And I started this deed of lease executed on such and such date and goes on, just to keep the bench pending. So that was the way I started. And that's an opportunity which I got. And rest is the destiny. I can't say anything about it. So my congratulations to all first generation lawyer. Do not lose heart. Be there in the profession with commitment, dedication, remain passionate. I think the success will follow you. You need not have to follow the success. That's it.
So two very, very important things coming out of Justice Tandon's life story. One is that there is no shortcut in this profession. You have to work the hard way. And second is, of course, the strength of character that his father showed in rebuking his son when he got a brief and he said that, no, if you continue with this lawyer, you're bound to lose. So that actually, if I may say, was the turning point in his life, because if he had not been rebuked that way, he would have taken similar briefs of future and would have never grown in the profession independently. So I think we must salute his father also today. For I don't think very many fathers can take such a bold stand with regard to their son when the son is appearing and coming with their first brief to brief their father. Now we are fortunate here today to have the learned Attorney General for India. He also would like to speak on this subject. I'm not very sure whether he's a first generation lawyer or he is. Okay, great. So So I didn't know that, but we are so grateful that he is here today and he also wants to speak. It will be great for this discussion today if you can. You can come here, yes.
Many mentors have entered my life, and there are of different ways. Not necessarily a senior who joins and who grooms you. In the second year of my college, in Government Law College, Pondicherry, we had part-time teachers. One of them was a public prosecutor in Pondicherry. So when I was completing my second year, he called me one day and said, after you complete your graduation, come and join my chamber. But that was a great invitation. A student being asked by a public prosecutor to come and join a chamber. I never knew him, nor he knew my family. My father was a textile engineer, none of my, neither my maternal side or paternal side were ever lawyers, anything near to law, closer to law. I joined this chamber, and one day he was not available for a cross-examination of an investigation officer. So a senior sub-judge who was doing criminal cases, I was asked to go and cross-examine the investigation officer. In trial courts, you will find when the police officers come, they have to remove their hat out of deference to the court. The gentleman did not do that. The judge got very wild. He got annoyed. And he asked me, what are you going to do today? He said, so-and-so is not available. Probably I would like to do the cross-examination. I tried my best, getting ready within half an hour of my senior not being there. As we were trying to proceed with the cross-examination, the senior subject said, stop. And he said, where did you study? Who gave you a law degree? I don't know what kind of law degrees people like you get. I was so stunned by that. I was really stunned by that. Something like a humiliation. A humiliation. It went so deep into my mind. I went back to my senior chamber, who came a little later, and I said, this is what happened in the court. My senior regarded me as one of the brightest in his chamber. So he went and told the principal district judge, this is what happened to one of my treasured junior. I think people in the bar who are first generation lawyers, if they receive this kind of a humiliation, how will they receive progress? The principal district judge called me and said, don't worry, young boy, I'll talk to the senior subject and try to tell him what probably went wrong with you in the court. The story ended there. So when I came back to practice in Supreme Court in 1979, I came here not because I wanted to come to Supreme Court. The least, Supreme Court is a faraway place from somebody who was born in Pondicherry, studied in Pondicherry, knew nothing about Supreme Court, not even about the High Court. Professor Madhav Menon, my teacher, who became principal in Government Law College, Pondicherry, took interest in me when my father passed away. And when I was wondering whether to shift from Pondicherry to Madras, looking for many opportunities, one senior lawyer told me, yes, you can come and join my chamber, but I will not pay you anything. And another senior lawyer said, you can join my chamber, but I'll pay you 150 rupees a month. If you want, you can come and join. This is the year 1978. I said, 150 rupees is a big money. I said, I'll come and join the chamber. Well, all this is happening. Professor Madhav Menon came all the way from Delhi to Madras and to Pondicherry and said, you are not having any such thoughts. You are going to practice in Supreme Court. I made all the arrangements for you to go and practice in Supreme Court. Which principal, which teacher will take such an interest in a student? I pay my greatest respect to Professor Menon even today, and wherever I go, in law schools and no law school, public platforms, I say, what a wonderful teacher can do to a humble student. That's how I came to Supreme Court. I joined Mr. P.P. Rao's chamber. 3 years later, after I came to Supreme Court, I had to go back to Pondicherry on some occasion. I visited the Government Law College. The same senior sub-judge had now a retirement to become the principal of the law college. I sent my visiting card to go and see him. He came out of his chamber to receive me and said, I'm so glad that you got to Supreme Court to practice. Somebody from Pondicherry, the one who scolded me saying, who gave you a law degree, received me with all the respect I received. It's the kind of, you're talking about humiliation, no? How things turn in your life. So I landed with a small suitcase and in Supreme Court. Look at the greatness of a teacher. He gives you encouragement. Professor Menon has a Labrador scooter. He was teaching in Delhi University those days. He comes all the way with the scooter, picks me up and takes me to Mr. P.P. Rao, introduces me to Mr. P.P. Rao and said, he's so-and-so, so-and-so. I mean, wonderful. So therefore, you're talking of mentors. Mentors can come in different forms. Wait, just keep your door open 24 hours a day. Mentors will come and walk in and tell you where I'm going to lead you. Just be alive to mentors walking in. That's the only lesson I'll give to first generation. So that after it's a different story, it's a very, very long story. I don't think I would like to share it today. Maybe one day I write my little memoirs of my life in Supreme Court, how it transformed my entire life and things like that. I will remember many of you, most particularly the mentorship which a teacher can give you. The mentorship which a teacher can give you, he is the first mentor. If you remember the first mentor, I think many mentors will follow. They'll stand in queue and follow you. Await mentors one after another. I tell you, don't because you are a first generation lawyer, don't think you will have nobody to help you. in some form or the other, in some way or the other, in some way or the other, you will find mentors waiting to receive you. Every one of you would have the same experience. Thank you so much.
So I'll just take one closing comment from each of the. My just last closing comment is that what I would like to say, and I say this whenever I go to these law colleges also, that consider the pain of your client as your own pain. That is the first lesson of your coming as a lawyer. As everybody in the panel said, that you have to actually have that empathy of understanding the pain of your client and then giving it a legal shape for which you require the legal knowledge. And lastly, initially in litigation, there is no money, as everybody knows, or very little money to sustain. But if you make a mark, you will be noticed and you will be definitely in this profession without any godfather also, you can definitely rise. So that's something which I think is very, very important for every youngster to know today. Just one closing comment.
Thank you very much. With the 3 H stated by Aishwarya ji and 2 Ws stated by Harish Tandon ji, I would like to just add 5 I's which are essential for a successful lawyer. Industry, integrity, intellect, initiative, and a good interpersonal skill, because at times as a lawyer you must know what is in the mind of a judge. So even if a judge is wrong, you have to say that your lordships are correct, but so how to deal with the judge? So now, after 24th of November, I am free to speak many things which I could not have spoken earlier. But I can tell you that with hard work, dedication, nothing is impossible. I have come from a humble background, starting by schooling in a municipal school in a semi-skilled area. I know that it's we are too late, but I will just give you one example, which will be an encouragement for many, many first-generation lawyers coming from a humble background. Mr. Bausaheb Bobde was the Advocate General, and they have a very big, the M.R. Bobde, a legend in Nagpur, about whom Justice Hidayatullah has written in my own Boswell that he was one of the greatest lawyers. So they had a big property, and they always had to engage a mason to keep the property in good state. So one young boy who was assisting a mason was noticed by Mr. Bausaheb Bobde, and he found a spark in him. So he said that you, while working, complete your education. So he made him pass matriculation. After that, he made him pass 12th. And after passing 12th, he was working as his driver, come clerk in the office. And then after passing law, after completing a couple of years as a lawyer, he appeared for the examination of a district director, district judge. He cleared that examination, and with the God's grace, about 5 to 6 years back, he was elevated as the judge of the Bombay High Court, and now he is working as a judge of the Bombay High Court. So if you work hard, if you are sincere, if you are dedicated, your dreams can come true. Dream high, and those dreams will come true. Thank you very much.
Mr. Vikas Singh ji, now I am coming after you. In the sense, you have done so much, shown so much of concern for the bar. So I would really appreciate if you say that for first 3 years, for a young member of the bar, you are not going to charge the subscription fee. That would be the best one. Having said so, you may pose me a question, said then now who is going to make up the deficit? The Attorney General is here, so at least the government, I was told you are not getting any grant from the government. Normally the bar associations, the grant is given by the respective state governments. Many states, that is what I know. And I think the Attorney General would be gracious to persuade the government to give some nominal grant of 50 or 100 crores to the Supreme Court Bar Association. Third and the last aspect is, sir, I want what you know as institutional responsibility, that is through the seniors. Every senior, my humble request and appeal to every senior is, please identify 2 persons in a year, not more than 2 persons. Take them under your wraps, take them under your tutelage, who come from rural background, poor background, financially poor, who are first generation lawyers. Try to take them under your tutelage and nurture them. Tomorrow they may become even a Supreme Court judge also. They will remember you for life. So this initiative should be taken by the Bar Association through the learned senior advocates. This is my humble request.
Thank you, sir.
Yeah, I don't regret from my coming here today for this conference. But I just want to share, since you mentioned about picking up 2 people, a couple of years ago when the Bar Council of Tamil Nadu called me for a felicitation function, in the felicitation function I told the Bar Council that I would like to identify 5 female graduates who are graduating that day, who come from the most backward sections of the community. I have picked up 5 people. Each one of them are the most backward persons. Somebody's father was a coolie, somebody's mother was a home worker, so on and so forth. I have given them 2 lakhs for their commencing their practice. I wish that if you're able to adopt people like that, each and every one of us here, that will be a great contribution to our country.
While the panel discussion was going on, Honorable Mr. Justice Arvind Kumar was asking me about the rules, regulation, amount of subscription we charge from junior advocates, and I was wondering why he's asking. He has a long way to go to retire and come back in our bar, but this was the point. I didn't realize it. We are thankful, Malad. So we can conclude, if I put my own opinion, we can conclude by saying that the first generation lawyers succeed through persistence, continuous learning, networking, and resilience. Gradually, with time, they often become highly independent, dynamic, and adaptable professionals. But at the same time, the second generation lawyer may have a great leap forward initially, but in longer run in our profession, keeps testing everyone. So everyone has to prove their mettle after a point of time. So we conclude with this, and now we proceed with the felicitation of our guest. Just one thing I wanted to point out, Mr. Tushar Mehta, Learned Solicitor General, was supposed to be on this panel, but unfortunately he had some personal issue in the family, so he stayed back. He didn't able to attend it. He has sent a regret for that. And he is also a first generation lawyer. In fact, he opted for this particular panel. So now we can proceed with the felicitation. I request Mr. Ashish Kumar Sinha, Member Executive, to kindly felicitate Honorable Mr. Justice Arvind Kumar. Mr. Upendra Mishra is here. I request Mr. Manish Mohan to kindly come forward and felicitate Honorable Mr. Justice Prashant Kumar Mishra. कर रहा हूँ मैं. I request Mr. Rohit Vats to kindly felicitate Honorable Mr. Justice B.R. Gavai. I now request Ms. Rachna Gandhi to felicitate Honorable Mr. Justice Prasanna Varale. I request Honorable Mr. Justice Prasanna Varale to kindly come on the dais. Oh, yes, yes.
Thank you very much, Vikas Singh ji, and I thank Honorable Justice B.R. Gavai sir, who is a guide, philosopher, and for me is an elder brother. Brother Justice Arvind Kumar ji, Brother Justice Prashant Kumar ji, all the esteemed members of the bar, the dignitaries, the learned Attorney General ji. Thank you. And Pragya ji ने भी पहले कहा था कि सर आप अगर 4 पंक्तियाँ सुना दे तो एक तो आपका जो पहला सेशन था और ये सेशन दुष्यंत कुमार जी की है. बहुत हो गई पीर, अब हिमालय से कोई गंगा निकलनी चाहिए. हंगामा खड़ा करना मेरा मकसद नहीं है, मेरी कोशिश है कि सूरत बदलनी चाहिए ना हो. मेरे सीने में नसी तेरे सीने में सही हो, कहीं भी आग मगर जलनी चाहिए, आग मगर जलनी चाहिए. थैंक यू.
I now request Mr. Mukesh Kumar Singh, Member Executive, to kindly felicitate Honorable Mr. Justice Harish Tandon, Chief Justice of Odisha High Court. I request Honorable Mr. Justice P. Sam Goshi to kindly come on the stage, please. Judge, High Court of Telangana. I also request Honorable Mr. Justice Sibu Shankar Mishra, Judge, High Court of Odisha, to kindly come on the dais. I request Ms. Samta Mishra, Member Executive Supreme Court Bar Association, to kindly felicitate Honorable Mr. Justice P. Sam Goshi, Judge, High Court of Telangana. I now request Ms. Smriti Kumari to kindly facilitate Honorable Mr. Justice Sibu Shankar Mishra, Judge, High Court of Odisha.
विक्रांत भाई,
with this, I request our committee of executive committee to kindly come on the stage, and we can have a group photograph with the honorable judges.
Last photo of the day.
I request all honorable judges to kindly take the chair, and we'll stand behind them. Yeah. Yes.
Our coordinator for the event and our treasurer, Vikrant Yadav sir, is also a first generation lawyer.
Thank you.
ठीक है सर।
मिनेश टोपी पहना रहा है हमारे प्रेसिडेंट। I request all participants to kindly join us for dinner at 8 p.m. and it is sponsored by Senior Advocate, hosted by Mr. Sajan Pavaya, Senior Advocate.
JW Marriott, venue is JW Marriott, second lawn. I am extremely thankful to all of you for joining us. Sir.
If any participants find blue iPad, please deposit with me. I have lost my iPad blue color. If any participants find blue color iPad, please deposit with me.
अरे अजीत ये गवई साहब का है ये जस्टिस प्रशांत मिश्रा का ठीक है ये जस्टिस हरीश टंडन चारों नाम नोट कर लेना पर्ची डाल देना गवई साहब का
आ गया